Kotak sir. Kotak sir.
Kodi up to 10th. 8. The other side. Okay. 20. 19. Oh. ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ? ಅಲ್ಲ ಏನು ಇಬ್ರು ರೆಡಿ ಇದ್ದೀರಾ ಅಥವಾ ಡೇಟ್ ಬೇಕಾ? ಡೇಟ್ ಬೇಕು. ಯಾವಾಗ ಬೇಕು? ಯಾವಾಗ ಬೇಕು ಹೇಳಿ. ಆಯ್ತು ತೋಳಿ. One council system, apparent council present list this matter on 23rd. 24 ready. Settlement ಆಗ್ತಾ ಇದೆಯಾ? ಆಯ್ತು R1 element of settlement. Let's list this. 34 to 42.
Milad 30. 32 and Milad 50, and there is another 2 days I have some.
R1 council 6 time and undertake. So you have to intimate other side. Council.
I'll do that. I'll do that, man. In fact, I'm running around the hospital, Milad. I'll try to. 50 also, Milad.
23rd. Amela serial number?
50, Milad. 50.
Yes, learned council for respondent submit that this appeal may be called on.
Obligation.
19 connected matters MFA 1599 up to 2016, 1599 up to 16 6 time and also undertakes to inform other side. List this matter on 23rd. Just tell. Baki idella 230 matters. Keshava Prasant. Finishing up PF correct address accepted issue notice to R1. First time, is absent. And 1 week time granted to furnish the PF correct address. If not furnished, list this matter on 10th. If furnished, issue notice against R1. Really concept. Council has filed memo for dispensation of notice against R1 and hence dispensed at the risk of the appellant. Memo for dispensation of notice to R2 dispensed against R2 at the risk of the appellant. Serial number 3.
I am for the respondent, my lord. First respondent.
Do you know that in the opening, that
Yes.
is a physical hearing and video conference?
I am for the first respondent, my lord. Maybe called next week, my lord. After dispensation, it can be disposed of.
List this matter on 23rd.
Much best.
Right? 23rd. Uday Kumar RL. Acceptance of paper application. Acceptance of ಬಂದಿದೆಯಾ madam? ಕರ್ಸಿ ಕಾಲ್ ಔಟ್ ಮಾಡಿ. R1 is called out absent and hence absent. Another another for proposed amendment to the memorandum of appeal. An amendment ಅದು? ಕಾಪಿ ಶುರು ಮಾಡಿದ್ರಿ ಅದರ್ ಸೈಡ್ ಶ್ರೀಕಂಠ ರಾವ್ಗೆ ಮಾಡಿದಿರಿ ಅಲ್ಲ ಇವತ್ತು ಪೋಸ್ಟ್ ಆಗಿರೋದು ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಮಾತ್ರ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ಅಲ್ಲ ಬಂದಾಗ ನೋಡೋಣ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಆ ರೀಸನ್ ಅವ್ರು ಬಂದಿರಲ್ಲ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
No, I pay for second respond, my lord.
Very, very good.
I pay for second respond.
ಅಯ್ಯ ಟು ಹ್ಯಾವ್ ಯು ಗಾಟ್ ಎನಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್
I had to ಅದು ನನಗೆ ಕಾಪಿ ಬಂದು ನೋಡಿ ಹೇಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ರೆ ಮಾಡ್ತೀನಿ.
ಆಟೋ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಏನ್ರಿ ಇದು ಬಿಸಿ ಸರಿ ಇಲ್ಲಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲಾರ ವಾಯ್ಸ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ ನೋಡಿ ಕಟ್ಸಿ ಅವ್ರಿಗೆ ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 23rd.
ಆಯ್ತು.
Yes, A2 for condonation of 845 days in filing the recalling application.
We appear for second respondent. Right?
AMT order ಆಗಿದೆ.
There is no justification of delaying 2.5 years. Dismissed for default.
Dismiss for default ಅಲ್ಲ ಮತ್ತೆ preemptory order.
Ten 1/2020.
ಅದು ವೆರಿಫೈ ಮಾಡಿದ್ರ ಮೇಡಮ್ ನೋಟಿಫಿಕೇಶನ್ ವೆರಿಫೈ ಮಾಡಿದ್ರ ಏನಿಲ್ಲ ಮೇಡಮ್ ಬರಲ್ಲ ಅಂತ ಒಂದು ಸರ್ಕ್ಯುಲೇಷನ್ ಇದೆ ನೋಡಿ ಸರ್ಕ್ಯುಲರ್ ಕಳ್ಸಿದ್ರು ಇದೆ ಒಂದು ದೇರ್ ಇಸ್ ಅನ್ ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ನೋಡಿ ಮೇಡಮ್ ನಾವು ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ನೋಡಿ ಅಥವಾ ಜುಡಿಷಿಯಲ್ ಸೈಡ್ ಮಾಡಿದಾರೆ ಏನೋ ಮಾಡಿದ್ದಾರೆ ಸಮಥಿಂಗ್ ಇಸ್ ದೇರ್ ತಗೊಂಡು have you got any objections or are you going to file objections?
I'll file objections, my lord.
R2 council seeks time to file objections to IA1 of 22. List it. ಆಯ್ತ್ರಿ ಅದೇ ಈಗ ಅವ್ರೇನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತೀನಿ ಅಂತಾರೆ ಹಾಕ್ಲಿ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಏನ್ ಮಾಡಿದ್ರೆ don't make such comments on the other side advocate. That is his right.
If you want, my lord, I'll not file objection. I'll make my submission, my lord.
ನೀವ್ ಹೇಳಿದಿರಿ ಬಟ್ ಅವ್ರು ಹೇಳ್ಬೇಕು ಅಂತಿಲ್ಲ ಡೋಂಟ್ ಮೇಕ್ ಸಚ್ ಕಾಮೆಂಟ್ಸ್ ಅನ್ ಮತ್ತೆ ನೀವ್ ಹೇಳಿದ ಅದೇ ತಾನೇ ಈಗ ಡೋಂಟ್ ಡೂ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ not correct on your part. You are also a senior, not junior. If any young advocate comes and makes a submission, court mistake ಅಲ್ಲ ನೀವು ಬರ್ದಿಲ್ದಕ್ಕೆ ಹೌದು ಪ್ರಿಯಂಪ್ಟರಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ನೀವ್ ಇರ್ಲಿಲ್ಲ ಅವತ್ತು ಕೋರ್ಟ್ ಇದ್ದೀರಾ ಅದೇ ಪ್ರಿಯಂಪ್ಟರಿ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಲ್ವಾ ಯು ಆರ್ ನಾಟ್ ಪ್ರೆಸೆಂಟ್ ಆನ್ ದಟ್ ಡೇ ಆಯ್ತು Right. Right. Right, next, finally.
My lord, I may be permitted to retire from the case, my lord. If that is the attitude of the other side, I may be permitted to retire and let them take notice to the other side.
ಗೊತ್ತಿಲ್ಲ ನೀವು ಏನ್ ಮಾಡ್ತೀರೋ ರಿಟೈರ್ ಆಗೋಂಗಿದ್ರೆ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ಹಾಕಿ ಐ ವಿಲ್ ಪಾಸ್.
ಆಗ್ತೀನಿ ಸ್ವಾಮಿ, ಆಗ್ತೀನಿ.
ದಟ್ಸ್ ಆಲ್. ಹಾ. ಹೇಳ್ರಿ ಏನಾಗ್ಬೇಕು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇಂಜುರಿ ಕೇಸ್. ಹಾ ಏನಂತ? ಟೈಮ್ ಬೇಕಾ ನಿಮ್ಗೆ? ಆಯ್ತು. Auto council 6 1 week time and then this matter on 10th. NOC not obtained ಅಂತ ಇದೆಯಲ್ರಿ? ಹಾ ಹಾ ಈ ರಿವ್ಯೂ ಅಲೋ ಆಗಿದೆಯಾ? ಹಾ ವಕಾಲತ್ ಹಾಕಿದೀರಾ? ಯಾವಾಗ ಮತ್ತೆ ಫ್ರೆಶ್ ವಕಾಲತ್ ಹಾಕಿದಿರಿ ಆಫ್ಟರ್ ದಿ ರೆಸ್ಟೋರೇಷನ್? ಆಯ್ತು. ರಿವ್ಯೂ ಅಲ್ಲಿ ನೀವು ಅಪಿಯರ್ ಆದ್ರಿ. ಆಯ್ತು ಆಯ್ತು ತಗೊಳ್ಳಿ. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಈಗೇನ್ ಮ್ಯಾಟರ್? ಇದಾರಲ್ಲ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವ್ರು ಆರ್ಜೆ. R2. ಇವತ್ತು ಫೈಲ್ ತಂದಿಲ್ವಾ? ಆಯ್ತು. Auto council 6 time list this matter on 10th. Next sitting at 10th. ಅದಕ್ಕೋಸ್ಕರ 10th ಕೊಟ್ಟಿದೆ. ಸತೀಶ್ ಕುಮಾರ್ ಮುರುಗೇಂದ್ರ ಫಾರ್ R1. ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರು ಇದ್ರಲ್ಲಿ ಇದ್ರೇನು? ಸತೀಶ್ ಕುಮಾರ್ ಇದಾರಲ್ರ? ಹೇಳಿ. ಸಬ್ಮಿಟ್ ಮಾಡಿ. ರೆಡಿ ಇದೀರಲ್ಲ? ಫೈನಲ್ ಹಿಯರಿಂಗಿಗೆ ಇರೋದು, ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ಕೆ ಇರೋದು. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಾ? ಬೇರೆಯವ್ರು ಇದಾರ? ಚಂದ್ರಶೇಖರ್ ಆರ್ ಲಾಯರ್ಸ್ ನೆಟ್, ರಾಜಣ್ಣ ವಿ. ನೀವ ರಾಜಣ್ಣ ಇದ್ರಲ್ಲ ಯಾರು? ಚಂದ್ರಶೇಖರ್ ಆರ್ ಲಾಯರ್, ಅವ್ರದ್ದು ಅಪೀಲ್ ಏನು? ಅವ್ರ ಓನರ್ಗ ಅವರು? ದಟ್ ಈಸ್ ಓನರ್ ಅಪೀಲ್. ನಿಮ್ದು? ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಂತ. ವ್ಯಾಲಿಡ್ ಇನ್ಶೂರೆನ್ಸ್ ಇದೆ. ಏನ್ ವೆಹಿಕಲ್ ಏನು ನೋ ಪರ್ಮಿಟ್ ಅಂತನಾ? ಬಸ್ಸ?
May I make one submission, my lord? The connected appeals, my lord, which has been shown in the cause date, they are all dismissed, my lord, for on 27/9/19, 10/3/17 and 1/12/14. They are not.
ಅದು ಓನ್ಲಿ ಕೆಪ್ ಬಿಲೋ ಆಗಿದೆ ಅಷ್ಟೇನೆ. ಅದು 8.3 ಅದರಲ್ಲಿ
all are disposed of, my lord.
ಇದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲ ಹರಿಣಿ ಶಿವಾನಂದ ಫಾರ್ R2 ಇದಾರೆ ಫಸ್ಟ್ ಒನ್ ನಲ್ಲಿ. ಅವ್ರ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗೆ 8.1 ಅಲ್ಲೂ ಕೂಡ ಹರಿಣಿ ಶಿವಾನಂದ್ ಫಾರ್ R1 ಇದಾರೆ.
All those things are disposed of, my lord.
ಹೌದು. ಇಲ್ಲ 8.1 8.2 ಆರ್ ನಾಟ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್. ಓನ್ಲಿ 8.3 ಇಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅನ್ಸುತ್ತೆ. ಇಲ್ಲೋ ಮೇಡಮ್?
7015, 7016 are disposed of, and 10,914, 15 are disposed of.
Only 914, 10915 of 13 are kept disposed of. That's why kept below ಅಂತ ಮಾಡಿದ್ದಾರೆ.
7015
ಹೌದು, 4 ಇದೆ. 1 2 3 4 ಇವ 4 ಡಿಸ್ಪೋಸ್ ಆಫ್ ಆಗಿದೆಯಲ್ಲ.
ಹೌದು, 4
ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದ್ರೆ ಇದೆ ಅಷ್ಟೇನೆ. ಬೇರೆ ಇನ್ನು 3 ಇದೆ ನೋಡಿ ಕನೆಕ್ಟೆಡ್.
That is not posted, my lord.
ಅಷ್ಟೇ ಆಗಿದ್ದಾರೆ. 8.1 8.2 8.3 ಇದೆ ನೋಡಿ ಅಲ್ಲಿ.
I am not there in that.
Not there. Harini Shivanand is there.
I stand corrected.
8.3 ನಲ್ಲಿ ಏನಾಗಿದ್ದಾರೆ ಮೇಡಮ್? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಫಾರ್ ಹೆರಿಂಗ್ ಸರ್ವ್ಡ್ ಕಾಪಿ ಆನ್ ಅದರ್ ಸೈಡ್. YS ಮುರುಗೇಂದ್ರ ಇದಾರೇನ್ರಿ? R2 ಅದ PF ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಮುರುಗಿ ಅಂದ್ರೆ ಏನೋ ತಗೊಳ್ತೀನಿ ಅಂದ್ರಲ್ಲ ಅವರು ಇದ್ರಲ್ಲಿ ನಾನ್ ಫೈಲಿಂಗ್ ಅಪ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ಕಾಪಿ ಆನ್ ಅದರ್ ಸೈಡ್ ಅಂತಿದೆ. ಫರ್ನಿಶಿಂಗ್ ಕಾಪಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು R2 ಫಾರ್ ಥರ್ಡ್ ಟೈಮ್. ಲಿಸ್ಟ್ ಮಾಡಿ ಇಟ್ಟಿರಿ ನೋಡ್ ಬರ್ಲಿ ಮುರುಗೇಂದ್ರ ಬರ್ಲಿ ವಿಲ್ ಕಂಪ್ಲೀಟ್ ಇಟ್. ಅವ್ರು ಇದ್ರು ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡಿದೀವಿ ಏನೋ ಒಂದು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಲಾಸ್ಟ್ ಟೈಮ್. ಇರ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ, ಇಲ್ಲ ಅಂದ್ರೆ ಇವತ್ತು ಟೇಕಿಂಗ್ ಸ್ಟೆಪ್ಸ್ ಏನಿದೆ ಅದನ್ನ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ. ಲೆಟ್ ಹಿಮ್ ಟೇಕ್. ಏನಾಗಿದೆ ಆರ್ಡರ್ ಮಾಡಿದೀವಲ್ಲ. Learned counsel for the appellant in MFA 70717 submit that other claimants appeals in MFA number are already connected to these appeals. ಆಯ್ತು. Hence the registry is directed to list MFA. So ಆ ರೀತಿ ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್. ಇವ್ರಿಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕಲ್ಲ ಇವರು. ಇದ್ರಲ್ಲಿ ಯಾರು ಇದಾರ ತಗೊಳ್ತೀರಾ? 8.3 ನಲ್ಲಿ 7017 ಅಲ್ಲಿ ನೀವ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ಯಾರ ಪರವಾಗಿ? ಯುನೈಟೆಡ್ ಇನ್ಶೂರೆನ್ಸ್ R2ಗೆ. R2ಗೆ ಆಲ್ರೆಡಿ ಒಂದರಲ್ಲಿ ಓಂ ಮಹೇಶ್ ಅವರು ಇದ್ದಾರೆ, ಇನ್ನ ಎರಡರಲ್ಲಿ ಹರಿಣಿ ಶಿವಾನಂದ್ ಅವರು ಇದ್ದಾರೆ. ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ, ನಾನು ಇದ್ದೀನಿ. ಅದ್ರ ಇನ್ನೆರಡರಲ್ಲಿ ನಾನು ಇದ್ದೀನಿ.
ನೀವಿದ್ರಿ ಯಾರು ನೋಟಿಸ್ ತಗೋತೀರಿ ಹೇಳಿ? MFA 7017 ಆಫ್ 2018 ಅಲ್ಲಿ
ನಾನೇ ತಗೋತೀನಿ.
ಶ್ರೀ ಹರಿಣಿ ಶಿವಾನಂದ್, ಶ್ರೀಮತಿ ಹರಿಣಿ ಶಿವಾನಂದ್ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಫಾರ್ R2 in MFA 7017 of 2018. The counsel appearing for the appellant is directed to furnish the copy of the appeal memo forthwith and list all these matters on date for madam 24th.
ಆಯ್ತು.
ಅಲ್ಲಿ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು. ನೋಟಿಸ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆದಾಗ ಆಯ್ತು. ರಾಜಣ್ಣ ಎ ವೆಂಕಟೇಶ್ ಫಾರ್ R2 ಹೇಳಿ. ಆಯ್ತು ಹೇಳಿ. ರೆಡಿ. Why it was dismissed? Delayed complaint. Date of accident ಯಾವಾಗ? Complaint on 12/9. 13/9 ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ತೀರ್ಕೊಂಡಿದ್ದಾನೆ. ರೀಸನ್ಸ್ ಏನು? ಡಿಲೇಗೆ ಇಂಜೂರ್ಡ್ ಜೊತೆ ಹೋಗಿದ್ದೆ, ಅದರಿಂದ ನಂಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಅಂತ. ಹಿಸ್ಟ್ರಿ ಏನ್ ಕೊಟ್ರಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? When the injured was taken to the hospital, what is the history given by you? RTA ಆಯ್ತು, ಏನಂತ? RTA ಮೇಡಮ್ ಏನು ಅಂದೆ? ಬರೀ RTA ಅಂದ್ರೆ ಆಗಲ್ಲ, ರೋಡ್ ಟ್ರಾಫಿಕ್ ಆಕ್ಸಿಡೆಂಟ್ ಅದು. ಹಿಟ್ ಬೈ 2 wheeler ಅಂತ ಹಿಸ್ಟ್ರಿ ಕೊಟ್ಟಿದ್ದೀರಿ. ಹಿಟ್ ಬೈ 2 wheeler ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ? ನಿಮ್ ಕೇಸ್ ಏನು ಈಗ? ಹಿಟ್ ಬೈ 2 wheeler ಏನಾ ಅಥವಾ ಬೇರೆನಾ? ಅದೇನೆ. ಆಯ್ತು. ಇಂಜೂರ್ಡ್ ಹೇಗೆ ಕರ್ಕೊಂಡು ಹೋದವ್ರು ಯಾರು? ಜೊತೆ ಯಾರಿದ್ದವರು? ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವರು ಅವನು ಹೀಸ್ ಆಲ್ಸೋ ಇಂಜೂರ್ಡ್. ಕಂಪ್ಲೇನೆಂಟ್ ಏನು ಇಂಜೂರ್ಡ್ ಅಲ್ಲ. ವೆದರ್ ಹಿ ವಾಸ್ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಇಂಜೂರ್ಡ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ದಿ ಆಕ್ಸಿಡೆಂಟ್? ಹೇಗೆ? ಮೋಟರ್ ಸೈಕಲ್ ಅಲ್ಲ, ನಡ್ಕೊಂಡು ಹೋಗುವಾಗ. ಅವನೇ ಹೋಗಿ RTA ಅಂತ ಹಿಸ್ಟ್ರಿ ಕೊಟ್ರದ? ಯಾರ ಜೊತೆ ಹೋದ? ಅವನೇ ಕಂಪ್ಲೇನೆಂಟ್. ಕಂಪ್ಲೇನೆಂಟ್ ಹಿಮ್ಸೆಲ್ಫ್ took the injured to the hospital. given the history. 2 wheeler hit by 2 wheeler ಅಂತ. ಆಯ್ತು. ಆಮೇಲೆ ನಿಮ್ಮನ್ಸ? Case report supra-aptly. Head injury. The findings, sir. Based on all these materials, the counsel for respondent to vehemently argued that petition is not maintainable in support of the contention so and so. So argument so and so. Reasons say no. The facts on the place on record clearly different story. In spite of the confidence of the criminal to accept as true and thereby they miserably failed to prove the occurrence of the accident involving a motorcycle bearing registration number so and so. Para 12. To prove their case, first petitioner examined himself as PW1 herself, who is in retained. Her evidence reiterated the so motorcycle bearing number so. Apart from her oral evidence, the petitioners have also put in exhibit P1 copy of the affair. Motor accident that on 8 and himself on Venkatesh. This is had been to Benanakala and work, and after having finished work at about 8 when they were returning to their village, and when they reached near bridge in front of house of Narehalli, a motor came from dashed against Venkatesh. As a result of which Venkatesh suffered injuries to his head, hand and legs. Thereafter he was shifted to the hospital. As per the advice of the doctors, nobody to look after him, and he lodged complaint belatedly based on statement by the complainant in the complaint and the history recorded with action accident registered mark history marked as Kim's Hospital, Bangalore, as per exhibit R7. Content that there is a variance between the pleading and proof in as such. After the alleged accident, the injured was accompanied by one Jagdish and not the complainant. Yara Jagdish antala madam ಇವನಲ್ಲ ಕರ್ಕೊಂಡು ಹೋಗಿರೋದು ಕಂಪ್ಲೇನೆಂಟ್ ಹೆಸರೇನು ಅವನು ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ ಯಾರ ಬೇರೆಯವನು injured accompanied by one Jagdish and not the complainant, whereas the deceased Venkatesh was hit by an auto rickshaw. Right, madam, alle munde nodi, the deceased Venkatesh was hit by an auto rickshaw while riding a two-wheeler. By an auto rickshaw while riding a two-wheeler. Two-wheeler hoಗ್ತಿದ್ದಂತ. It has to be stated that it is not the case of petitioner that Venkatesh was riding motorcycle, nor he was hit by an auto rickshaw. Further, if we peruse exhibit R7 clinical history at page number 20, shows that on 39/2010 at about 10:40 the injured Venkatesh succumbed to injuries, and it is only upon the death of the injured police intimation was issued. Further, in the cross-examination, PW1 has categorically admitted that as she has not seen the accident, she has personally doesn't know what was so. It was informed about the accident by Ninge Goda, the complainant hearing on the date of accident itself, and that police station is about 12 kilometers. She further admits that because of fear after hearing the news regarding the accident to her husband, she could not give complaint or pass so. The explanation for delay in lodging the complaint cannot at all accept for the reason that hospital, though he stated so. Further, even if it is accepted for the sake of argument that he had accompanied the injured to the hospital and informed about the accident to the wife of the injured. Say of PW1, what made him not to pass on the information to the police or some other persons who could pass on the information to the police? More interestingly, the complainant who has been examined as PW2 in the class examination stated that after the accident, he took the injured to the hospital with the assistance of another 20 persons who came there in response to his telephone call, and he contacted Doraiswamy from his mobile, wherein he has preserved number of mobile numbers, and that he has not stated so in the complaint before the police. Surprisingly, the name of Doraiswamy finds place in the accident register as having accompanied by the injured. Above all, if really complainant had accompanied the injured to the hospital, surely the hospital authorities would have recorded his name in the Venkatesh had sustained injuries in an accident involving the motorcycle in question with the complainant and Jagdish R. Doraiswamy. There is one of the 20 members gathered of the accident would have informed about it. Police, since they failed to do so, it gives an impression that Venkatesh might have sustained injuries in some other incident during the course of our arguments. ಈ ಆಟೋ ರಿಕ್ಷಾ ಅಂತ ಹೇಳಿ ಎಲ್ಲಿದೆ ಎಂಟ್ರಿ? ಎಕ್ಸಿಬಿಟ್ R7, ಎಕ್ಸಿಬಿಟ್ P7 ಅಲ್ಲ. ಕೊಡಿ ಮೇಡಮ್. Exhibit R1 first. Alleged history of RTA. ಇದ್ರಲ್ಲೇನ ಎಕ್ಸಿಬಿಟ್ R1 ಅಲ್ಲಿ ಹಿಟ್ ಬೈ 2-wheeler ಅಂತಿದೆಯಲ್ರಿ? R4 ಅಲ್ಲಿ ಏನಂತಿದೆ? ಮೆಂಟಲ್ ಹೆಲ್ತ್. pedestrian hit by 2-wheeler ಅಂತಿದೆಯಲ್ಲ? ಅದೇ RTA hit by 8/9/2010. pedestrian hit by 2-wheeler ಅಂತಲೇ ಇದೆ, ಎಕ್ಸಿಬಿಟ್ R1 ಅಲ್ಲೂ ಇದೆ, ನಿಮ್ಮಾನ್ಸ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲೂ ಇದೆ. ಒಂದ್ 20 ಜನ ಹೋಗಿದ್ವಿ ಅಂತಾರಲ್ಲ ಅಲ್ಲ, ಬಟ್ ಹಿಸ್ಟ್ರಿನಲ್ಲಿ ಇದೆಯಲ್ಲ, ಹಿಟ್ ಬೈ 2-wheeler ವಾಸ್ ಪೆಡೆಸ್ಟ್ರಿಯನ್ ಅಂತ. ಎಕ್ಸಿಬಿಟ್ R3 ನೀವ್ ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Even exhibit R4 ಇದೆ ನೋಡ್ರಿ. He was hit by 2-wheeler vehicle, got injured. ಫಸ್ಟ್ ಆಸ್ಪತ್ರೆ ಕರ್ಕೊಂಡು ಹೋದಾಗ್ಲೂ ಓದಿದೆ. ಮತ್ತೆ ಇವ್ರಿಗೆ ಎಲ್ಲಿ ಬಂತು ಈ ಜಡ್ಜ್ಗೆ ಆಗಂತ ಬರೀಲಿಕ್ಕೆ ಆಟೋ ರಿಕ್ಷಾ ಅಂತ? In all the records, two-wheeler vehicle had injury, loss of consciousness, history of vomiting. Even Adichunchiri hospital allu ade details ಇದೆ. ಹೋಗ್ಲಿ, ನೀವು ಯಾರನ್ನಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರೆ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರು? ಯಾರವರು? ಅಲ್ಲ, ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಎಲ್ಲಿ ಸಿಕ್ತು ಹಿಟ್ ಬೈ ಆಟೋ ರಿಕ್ಷಾ ಅನ್ನೋದು? ಎಕ್ಸಿಬಿಟ್ R7 P7 ಏನ್ ಹೇಳ್ತಾರೆ? P5 P7 post mortem report. ಎಕ್ಸಿಬಿಟ್ P7 ಅನ್ನೋ ಹಿಸ್ಟ್ರಿ ಆ ರೀತಿ ಇಲ್ಲ. PM ರಿಪೋರ್ಟ್. R5 medical records gifted from Nimans. ಯಾವುದು ನಿಮ್ಮಾನ್ಸ್ ಅಲ್ಲ, ಹಿಮ್ಸಲ್ ತಾನೆ ಕರ್ಕೊಂಡು ಹೋಗಿರೋದು. ಅರ್ಲಿಯರ್ ಹಿಸ್ಟ್ರಿ ಏನು? hit by auto while riding a 2-wheeler ಅಂತ. ಫಸ್ಟ್ ಇಂಜೂರ್ಡ್ ನ ಫಸ್ಟ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದು ಎಲ್ಲಿಗ್ರಿ? ಆದಿಚುಂಚನಗಿರಿ, ಆಮೇಲೆ ನಿಮ್ಮಾನ್ಸು. ಆದಿಚುಂಚನಗಿರಿ ನಿಮ್ಮಾನ್ಸು ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅದೇ ಇದೆಯಲ್ಲ, 2-wheeler ಅಂತೆಲ್ಲ ಇದೆ. Later taken to Nimans, the petitioner is referred to KIMS for further management. KIMS ಅಲ್ಲಿ ಬರ್ದಿರೋದು ಇದು. No discussion about the earlier history ಏನು ಇಲ್ವೇ ಇಲ್ಲ. ಅದೇ ರೀ ಪ್ಯಾರಾ 1230 ಓದಿದ್ದೀಗ. ಅದು ಥರ್ಡ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಬರ್ದಿರೋದು ಆ ರೀತಿ, ಹೌದಾ? ಆಯ್ತು. ನೀವ್ ಯಾರನ್ನ ಎಕ್ಸಾಮ್ ನೋಡಿ? ಮೆಡಿಕಲ್ ಟೆಕ್ನಿಷಿಯನ್. ಎಲ್ಲಿ ಇವನು ಕಿಮ್ಸ್ ಹಾಸ್ಪಿಟ್ಲಾ? ಎಕ್ಸಾಮಿನೇಷನ್ ಇನ್ ಚೀಫ್ ಬೈ ವೇ ಆಫ್ ಒಬ್ರಬಿಟ್. Sagaya Raj. ಯಾರ ಎವಿಡೆನ್ಸ್ ಓದ್ತಾ ಇದೀರಿ ನೀವು? RW2, he is an witness of the ನಿಮಾನ್ಸ್ ಅಲ್ವಾ? ನಿಮಾನ್ಸ್ ಅಲ್ಲಿ ಹಿಸ್ಟ್ರಿ ಕೊಟ್ಟಿರೋದೆಲ್ಲ 2 ವೀಲರ್ ಅಂತಾನೆ ತಾನೆ. ಆಯ್ತ್ರಿ, ನನ್ ಪ್ರಶ್ನೆ ಇಷ್ಟನೆ. ಹೌ ದಿ ಟ್ರಿಬ್ಯುನಲ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ದಿ ಥರ್ಡ್ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್? ಯಾವ್ದ್ರಲ್ಲಿ ಹೊಡೆದಾಕ್ ಬರ್ದಿದ್ರು? ದೇ ಹೇಳ್ತಾ ಇರೋದು that is third hospital records. ಹೌದಾ? Why the tribunal has not believed the first hospital and second hospital history given by the injured? ಅವ್ರು ಬಿಟ್ರೆ ನೀವ್ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ? ಯಾರು ಇಲ್ವಾ? RW2 ಇವ್ರ PW2 told madam. Heard the apparent counsel and also the counsel appearing with the respondent. Remind Badwa. What was he? Agriculturist, ಯಾವ year accident? 2010. ಏನ್ರಿ ಇಲ್ಲೇ ಮಾಡ್ಬೋದಲ್ಲ, ಮತ್ತೇನದು ಎಲ್ಲ ಇದೇ ಇರ್ತದೆ. ಮತ್ತೆ ಯಾಕೆ ರಿಮೈಂಡ್? 5,500 ತಗೊಂಡ್ ಮಾಡೋಣ, ಅದೇ ಮಾಡೋಣ. 5,500 ತಗೊಂಡು. Heard the appellant counsel and also the counsel appearing for the respondent. The present appeal is filed by the claimant challenging the judgment and award of dismissal of claim petition passed in MEC number 7992 of 2010. The factual matters of the case of the claimant before the tribunal that injured met with an accident on 8/9/2010. When he was proceeding as pedestrian, the motorcyclist came and hit him. As a result, he was immediately taken to Adjudication Hospital and thereafter he was shifted to Nimans and then KIMS Hospital. The claimant, in order to substantiate her claim, examined herself as PW1 and also examined PW2 as an eyewitness to the accident. PW3 are PW3 is the medical record technician of KIMS Hospital. ಅಲ್ಲ ರೀ, ನೀವು ನಿಮ್ಗೆ ರೆಕಾರ್ಡ್ಸ್ ಎಗೇನೆಸ್ಟ್ ಇರೋದನ್ನ ಕರ್ಕೊಂಡ್ಬಂದು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಲ್ಲ, ಯಾಕೆ? PW3 who comes and deposes that it was an accident of the auto rickshaw ಅಂತ. ನೋಡಿ ಏನಾಯ್ತು ಮೇಡಮ್? PW3 medical record technician. On the other hand, the insurance company examined the RW1 medical record technician KIMS Hospital. Avanu Kimsu, Yunu Kims, Lingappa Ranganath. So, and also examined another witness, RW2, administrative officer of insurance company. The tribunal, after considering both oral and documentary evidence, dismissed the complaint in coming to the conclusion that there is an entry in the KIMS hospital that vehicle involved in the accident is an auto rickshaw hit the motorcyclist when the injured was riding the motorcycle. And hence the present appeal is filed. The main contention of the counsel appearing for the claimant that the tribunal committed an error in not relying upon the document of earlier hospital, that is Adi Hospital and Nimans Hospital, and instead of relied upon the document of KIMS Hospital, where death was taken place, and failed to take note of the evidence of PW2, who is an eyewitness who accompanied the injured to hospital. And also he has given the history, two-wheeler hit the pedestrian. And document exhibit R1 and R2 relied upon by the insurance company itself discloses pedestrian was hit by the two-wheeler, and the same has not been discussed. And hence it requires interference. On the other hand, counsel appearing for the insurance company would submit that tribunal rightly taken note of the material available on record, particularly the exhibit R7, which is the case sheet of the KIMS Hospital, wherein history is mentioned, involvement of auto rickshaw hit the rider who is the deceased. Having heard the counsel appearing for the respective counsel and also the grounds urging the appeal as well as the contentions, the court has to take note of the oral and documentary evidence. The PW1 is the wife of the deceased, wife alwa, wife of the deceased, and she is not an eyewitness. However, relied upon the evidence of PW2, who claims that he accompanied the injured, and both of them walking on the left side of the road, and a motorcycle came and dashed against him. As a result, he sustained injury, and immediately he lost his conscience, and he is an eyewitness to the incident. He was subjected to cross-examination. In the cross-examination, he admits that he has given the statement before. Not given statement before any doctor, but he claims that Doraiswamy was there with him when they had been to the Adi hospital. But he claims that he furnished the information to the doctor as to how an accident was occurred. On the other hand, and also examined PW3 and got marked document exhibit P13 and 14. And also he was cross-examined on medical records exhibit R7, clinical histories pertaining to their hospital. And also admits that it was mentioned that hit by auto. The other witness is RW1, who is also the medical record technician of KIMS Hospital. And he was not subjected to cross-examination. On the other hand, insurance company examined another witness, RW2, who is an administrative officer of insurance company. And in the cross-examination also, he admits that in exhibit R4, it is shown that a patient by name Venkatesh, who met with an road traffic accident hit by two-wheeler, was brought to the hospital on 8/9/2010 at about 10:30 p.m. And also he admits that name of Doraiswamy is mentioned in exhibit R4. And he also admits that in exhibit R4, the records pertaining to the admission and treatment in Nimans, also it has been referred as he was an outpatient And in exhibit R6 also, it was mentioned patient was shifted to demands with history of 8/9/2010 hit by a two-wheeler. And when these when the answers are elicited from the mouth of RW2 regarding history is given, hit by two-wheeler against the pedestrian. And also exhibit R4 and R6 are admitted by the RW2. The tribunal committed an error in only relying upon exhibit R7 and fails to take note of exhibit R4 and R6, which came into existence immediately after the accident, wherein specifically mentioned that he was a pedestrian and hit by a two-wheeler. And instead of the third hospital records were relied upon by the trial court and no discussion with regard to the exhibit R4 and R6. And also he admits that there is no date but signature there on exhibit R7. And how, in spite of it, relied upon the document exhibit R7. And fails to take note of the immediate records of exhibit R1 to 4 and exhibit R6. And even in postmortem report exhibit P7 also it is mentioned that traffic accident. And all other documents.
Next one. Date ಏನು ಕೊಟ್ಟೆ 24th ಏನು ಕೊಟ್ಟೆ.
By two-wheeler, and no doubt there is a delay.
ಆಮೇಲೆ
The explanation was given that the injured was taken to hospital and hence there was a delay. And complainant himself was an eyewitness to the incident. When such being the case, the tribunal ought not to have doubted the case of the claimant, and hence committed an error. And hence it requires to be set aside the judgment and award of the tribunal regarding dismissal of the claim petition. Now coming to the quantum of compensation is concerned, the claimant claimed is in claimed that he was an agriculturist. Claimant have claimed that deceased was an agriculturist. And having taken note of any documentary proof for the notional income would be rupees 5,500 for an accident of the year 2010. And he is aged about 45 years in terms of the PM report. 25%. And in the absence of and hence the 25% has to be added as a future prospectus. The claimants are wife and children, 4 in number. 1/4 has to be claimants are wife and children and also the mother. 1/4 has to be deducted. Having deducted the 1/4, taking income of rupees 5,500 and adding 25%, it comes to rupees, madam, 5,000. 5,556 table ಹಾಕೋಬಿಡಿ ಮೇಡಮ್, ಕೊಡ್ತಾರೆ. In all claimant entitled for compensation of rupees so and so on the head of loss of dependency. The claimants are also entitled for an amount of rupees 1,60,000 on the head of love and affection and also 33,000 on the head of funeral expenses and loss of estate. In all, claimant is entitled for an amount of rupees 208. So the appeal is allowed, impugned judgment of set aside, and consequently claim petition is allowed, granting compensation of rupees 10,59,208 with 6% interest. 6% interest. N. Krishnaswamy. ನೀವ್ಯಾರಿಗೆ R1 counsel seeks time. Appellant counsel is absent. List this matter on 24. 11. V.B. Siddaramaiah, A. Ravishankar for R1, R2 Mailarappa sir. R1 counsel seeks time. List this matter on. Madam, another date kodi. 24th. Next one, V.B. Siddaramaiah, O. Mahesh. Renukappa Saruda. Owner appeal. Yen ground ena? ಓ ಮಹೇಶ್ ಫಾರ್ R3. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡವ್ರು ನೋಡಿ. ಕೌನ್ಸಲ್ ಓ ಮಹೇಶ್. ಓ ಮಹೇಶ್ ಕೇಳ್ಸಲ್ವಾ? ಮ್ಯೂಟ್ ಆಗಿದೆ ಕೇಳಿದ್ದು. ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡೋದು? ನಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಕ್ಕಲ್ವಲ್ಲ. ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕು ಅವ್ರು. ಇನ್ನು ಈಗ ಫೈಲ್ ಬಿಚ್ತವ್ರೆ. ಓ ಮಹೇಶ್ ಅವ್ರ. ಹಾ, ನಾವೊಂದ್ ಫೋನ್ ಇಟ್ಕೋಬೇಕೇನ ಕೋರ್ಟ್ನವ್ರು? ಓ ಮಹೇಶ್ ಅವ್ರ ಅಂತ ಫೋನ್ ಮಾಡಿ. ಹಾ ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡ್ಬಿಡಿ ಆಮೇಲೆ ನೋಡ್. ಹಾ ತೋಳ್ DL ಇಲ್ವಾ? ಅಲ್ಲ, ಕ್ಲೈಮೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ಬರೋದೇ ಇಲ್ವಲ್ಲ ಅವ್ರ ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್. ಏನ್ ಏನ್ ಗ್ರೌಂಡ್ ಏನು? ಸರಿ ರೀ, ಏನ್ ಗ್ರೌಂಡ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಗ್ರಾಚ್ಯುಟಸ್ ಪ್ಯಾಸೆಂಜರ್ ಅಂತನಾ ಅವ್ರ ಕಂಟೆನ್ಷನ್? ಓ ಮಹೇಶ್ ಅವ್ರ, ನಿಮ್ದೇ ಮ್ಯಾಟ್ರು. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ನೀವು.
ಆಯ್ತು.
ಹಾ, ಇಲ್ಲ ಒಂದ್ ಬೋರ್ಡ್ ಇಟ್ಕೋತೀವಿ, ಇಲ್ಲ ನಿಮ್ಗೊಂದು ಫೋನ್ ಮಾಡಿಸ್ತೀವಿ ದಿನ.
ಇಲ್ಲ, I was in the other court, my lord.
ಕೋರ್ಟ್ ಆದ್ರೆ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಅಲ್ವಾ?
I'll be watching, my lord. I'll be watching and.
ಆಯ್ತು ಆಯ್ತು, ರೆಡಿ ಇದ್ದೀರಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 12.
Serial number 12 ಅಲ್ಲಿ act policy, my lord. It's an act policy. No liability on the insurance company.
ಏನ್ರಿ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಅಂತಾರಲ್ರಿ ಇವರು?
Exhibit R, act policy.
DL ಇಲ್ಲ ಅಂತಲ್ಲ ಏನಂದ್ರೆ ಈಗ ಅಲ್ವಾ? ಇದ್ರಲ್ಲಿ ಏನ್ ಮತ್ತೆ ಗ್ರೌಂಡ್ ಏನು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು ಗ್ರಾಚ್ಯುಟಸ್ ಪ್ಯಾಸೆಂಜರ್ ಅಂತ, ಗ್ರಾಚ್ಯುಟಸ್ ಪ್ಯಾಸೆಂಜರ್ ಅಂತಾನೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನೀವು ನೋಡ್ರಿ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಅಂತೀರಿ.
Yes, exhibit R1 may kindly be looked into.
Premium is collected for workman. 25 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಡ್ರೈವರ್ಗೆ ಇರುತ್ತೆ. ಡ್ರೈವರ್ಗೆ ಸಪರೇಟ್ ಇದೆಯಾ? ಓನರ್ ಕಮ್ ಡ್ರೈವರ್, ಅದು ಪಿ ಎ ಕವರೇಜ್ ಅದು.
B register extract and policy exhibit R1 kindly be looked.
ಕೊಡಿ ನೋಡಿ. ಆಕ್ಟ್ ಓನ್ಲಿ ಪಾಲಿಸಿ ಅಂತ ಇದೆಯಾ?
ಇದೆ, ಮೇಲ್ಗಡೆನೇ ಇದೆ. Even officer of the insurance company is also examined.
ಲಯಬಿಲಿಟಿ ಓನ್ಲಿ ಪಾಲಿಸಿ ಅಂದ್ರೆ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಓನ್ಲಿ. ಬರುದಿಲ್ಲ, ನೀವೇ ಕೊಡ್ಬೇಕು. ಏನ ಪ್ರೀಮಿಯಂ ಕಲೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರಲ್ರಿ?
ಎಲ್ಲಿ ತೋರಿಸ್ಲಿ ಸ್ವಾಮಿ? ಅಲ್ಲಿ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಎಕ್ಸಿಬಿಟ್ R1 ಅಲ್ಲಿ.
ಎಕ್ಸಿಬಿಟ್ R1.
Exhibit R1 kindly be looked into.
Type of policy is important.
And B extract is also not.
B extract ಏನು?
Nobody is driver, nobody is permitted to carry.
B extract ಪ್ರಕಾರ ಡ್ರೈವರ್ ಒಬ್ಬನೇ.
Yes.
Vehicle involved in the accident ಏನು?
Tractor trailer.
Tractor trailer. ಇವನ್ ಸತ್ತವನ್ ಎಲ್ಲಿದ್ದ?
They claim Manoj that he was a coolie.
ಕೂಲಿ.
Lady Manoj.
Lady. Sitting in the tractor trailer or trailer?
ಅಲ್ಲ, ಎಲ್ಲಿ ಕೂತ್ರು ಆಕ್ಟ್ ಪಾಲಿಸಿ ಒಳಗೆ ಬರೋದಿಲ್ಲಲ್ಲ.
ಪ್ರೀಮಿಯಂ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರ?
ಪ್ರೀಮಿಯಂ ಕಲೆಕ್ಟ್ ಮಾಡಿಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ R1 kindly be looked into.
ಅಲ್ರಿ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? ಆಯ್ತು, ಪ್ರೀಮಿಯಂ ಫಾರ್ ಟ್ರೈಲರ್ಗೂ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಓನರ್ ಕಮ್ ಡ್ರೈವರ್, ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಆಗಿದ್ರೆ ಅದೊಂದು 100 ರೂಪಾಯಿ ಇದೆ. WC2 ಎಂಪ್ಲಾಯಿ 1 ಅಂತ ಇದೆ, 25 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ವರ್ಕ್ಮನ್ ಒಂದ್ ಇದೆಯಲ್ರಿ, ಎಂಪ್ಲಾಯಿ 1 ಅಂತ.
No, that is not being carried, my lord, while, I mean, loading or unloading, if, my lord, that's a repeat, not being carried, because B extract, my lord, shows only one person. And policy says, my lord, act policy.
ಶೆಡ್ಯೂಲ್ ಆಫ್ ಪ್ರೀಮಿಯಂ ಅಲ್ಲಿ ಇದೆಯಾ WC2 ಎಂಪ್ಲಾಯಿ 1 ಅಂತ ಇದೆಯಾ? ಇದೆಯಲ್ಲ ನೋಡಿ, ಅಲ್ಲೇ ಇದೆಯಲ್ಲ, ಕೊನೆಗಡೆ 25 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಲ್ಲ.
My respectful submission, my lord, is that not being carried, my lord. While loading and unloading, if something happens, my lord, that's thing, but it's a tractor trailer, only driver, my lord, is permitted to this thing, my lord, there is no carrying capacity.
Why you have collected the premium?
Premium, while loading or unloading, if something happens, my lord, in the carriageway.
ಎಂಪ್ಲಾಯಿ ಅಂತ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಲ್ಲ, ಅದು ಯಾರಿಗೆ ಅಂತ ಕೇಳ್ತೀನಿ ನನ್ನ ಪ್ರಶ್ನೆ.
ಅದೇ ಮೇಡಮ್, while loading and unloading, if something happens, my lord, then the insurance company would be liable, not being carried.
Trailer is used meant for what?
But trailer is meant for, my lord, forestry, or if it is a registered as a transport vehicle, it will be a transport vehicle. The policy, liability policy, my lord, you have to kindly see at the top. Your lordship gets it, liability only policy.
But you have premium WC1 to WT.
That, my lord, that's what, my lord, I am explaining. Only while loading, unloading, if something happens, my lord, not being carried.
That is your argument.
Yes. And the evidence of, my lord, the insurance company, my lord, officer may kindly be looked into, my lord. Radha Pai, my lord, has been examined. I'll read, my lord, the evidence of the officer company. Para 3, my lord, tractor trailer bearing registration number so belonging to one location Pagoda is insured with us under the miscellaneous special type of policy vehicle act only. It is meant only for agriculture purpose of the insured owner. It cannot be used for hire or carrying passengers. It is not a transport vehicle, and hence it does not have a permit as required for a goods vehicle or a transport vehicle to carry passengers or goods of others. The only good that can be carried is the TT unit is of the insured. The vehicle is registered as a non-transport vehicle, and therefore it cannot carry any person to load or unload the goods. We have not covered any employees or the owner except the driver. The driver of the police and other employees of the owner is not required to be covered compulsorily.
Not compulsorily, but you have collected premium.
Under the policy, the coverage is only for, and that is for the driver so and so, so and so.
It's not mandatory ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
Mandatory ಇಲ್ಲ, but WC liability, my lord, is only at the time of, my lord, loading and unloading, not being carried. Because permitted carrying capacity is only one for driver.
ಏನ್ರಿ ನಿಮ್ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಏನಿದೆ, ಏನ್ ಮಾಡಿದ್ರಿ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್? ಅಪಘಾತ ದಿನದಂದು ಪಾಲಿಸಿ ಚಾಲ್ತಿ ಇರ್ತಿತ್ತು ಎನ್ನುವುದು ಸರಿ. ವಾಹನದ ಚಾಲಕನಿಗೂ ಚಾಲನಾ ಪರವಾನಗಿ ಇತ್ತೆನ್ನುವುದು ಸರಿ. ವ್ಯವಸಾಯಕ್ಕಾಗಿ ವಾಹನವನ್ನು ಉಪಯೋಗಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಅಪಘಾತವಾದರೂ ತಾವು ಪರಿಹಾರ ನೀಡಬೇಕು ಎಂದು ಸೂಚಿಸಿದ್ದಾರೆ, ಸರಿ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಯಾರಿಗೆ ಪರಿಹಾರವನ್ನು ನೀಡಬೇಕು ಎನ್ನುವ ವಿಚಾರವನ್ನು ಪಾಲಿಸಿಯಲ್ಲಿ ಕಾಣಿಸಲಾಗಿದೆ ಎನ್ನುತ್ತಾರೆ. ಅಪಘಾತವಾದ ದಿನಾಂಕದಂದು ವ್ಯವಸಾಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಾಗಿ ಸದರಿ ವಾಹನದಲ್ಲಿ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದವರು ಅಪಘಾತದಲ್ಲಿ ಮೃತಪಟ್ಟಿದ್ದಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಅವರು ಪ್ರಯಾಣಿಕರಾಗಿದ್ದ ಕಾರಣ ನಾವು ಪರಿಹಾರವನ್ನು ನೀಡಲು ಹೊಣೆಗಾರಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ಮೃತ ವ್ಯಕ್ತಿ ಆ ದಿನ ಸದರಿ ವಾಹನದಲ್ಲಿ ಪ್ರಯಾಣಿಕನಾಗಿ ಪ್ರಯಾಣಿಸುತ್ತಿಲ್ಲ ಎಂದರೆ ಅದು ಸರಿಯಲ್ಲ. ನಾನು ಪರಿಹಾರ ನೀಡಬೇಕಾಗುತ್ತದೆ ಎನ್ನುವ ಒಂದೇ ಕಾರಣಕ್ಕಾಗಿ ಸುಳ್ಳು ಸಾಕ್ಷಿ ನೀಡುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. And also the counsel appearing for the respondent. While challenging the judgment and award MEC 963 of 2011 dated 19th day of October 2012 on the file of District and Sessions Court, Shimoga. Questioning. The liability is fastened on the insured instead of insurer. The main contention of the counsel appearing for the insured that tribunal committed an error in fastening the liability on the insured. Even though it was in force, the claim is also admitted by RW1. And this is Durgamma was traveling as a loader in the said vehicle. And hence, conclusion that deceased Durgamma was traveling in the tractor as a passenger. She was working as a coolie, traveling in the tractor in the course of her agricultural employment to load the mud to the garden of the appellant. And RW1 administrative officer during the course of cross-examination admit that in terms of policy, the respondent number 1 is liable to pay the compensation. In the event of death of any employee in the course of agricultural employment. In terms of exhibit P4 also, the complaint is lodged by the father of the deceased Durgamma. Clearly reveals that she was traveling in the tractor for the purpose of loading mud. And in spite of the same, the tribunal committed an error, coming to the conclusion that she was a passenger. And hence it requires interference. The counsel appearing for the appellant also brought to notice of this court the copy of the exhibit R1 policy will contain that a separate premium is collected in respect of WC employee. And hence ought not to have dismissed, ought not to have exonerated the liability of the insurance company, and hence it requires interference. For contra, the counsel appearing for the respondent insurance company would submit that policy marked which is exhibit R1 is only liability only policy. And hence the company is not liable to pay any compensation. The counsel also would submit that even though the premium is collected for WC employee, and the same is only at the time of loading and unloading and not carrying in the trailer. Hence insurance company is not liable. The of material available on record. Particularly document exhibit P1 complaint. It is mentioned that the driver of the tractor trailer drove the tractor and trailer in a rash and negligent manner. Complaint exhibit P4 disclosed. The deceased was occurred, she fell down from the tractor, trailer. And immediately she was shifted to Megan Hospital. In the cross-examination of he says that she was proceeding to attend the work of Lokeshappa, but not knows what was the work. And he doesn't remember attending loading work of his mother. And also she was traveling in the tractor. And on the other hand, the respondent examined one witness as RW1. And in his evidence, he says that it cannot be used for hire or carrying any passengers. And vehicle is registered as a non-transport vehicle and therefore it cannot carry any person to load or unload the goods. And they have not covered any employees of the owner except the driver. The risk of police and other employees of the owner is not required to be covered compulsorily under the Act. And taken the premium only for third parties and own damages. The witness was also subjected to cross-examination. In the cross-examination, admits that policy was in force. And driver was also having the, and admits that driver was also having the driving license. And witness admits that when the vehicle was used for agriculture purpose, and if vehicle was met with an accident, they are liable to pay compensation. However, witness volunteers that in the policy itself, it is mentioned to whom the compensation has to be given. It is suggested that the deceased was traveling in connection with agricultural work. And witness volunteers that traveling as passenger, hence insurance company is not liable to pay compensation. Having considered the material available on record, in the FIR, it is mentioned with regard to the accident was occurred on the negligence of the driver of the tractor. And also in exhibit P4, it is mentioned that she was proceeding in the tractor trailer as coolie. And also in the admission of RW1, he admits that if the person was carried in a vehicle and the same is for agriculture purpose, insurance company is liable to pay compensation. And only contention that proceeding as passenger, and in order to prove the fact that proceeding as passenger, nothing is placed on record except the voluntary statement, except the statement of RW1. And all records discloses that she was proceeding as coolie in the tractor trailer. And only contention of the insurance company that if the deceased traveled as passenger, then company is not liable to pay compensation. And I have already pointed out that there is no any cogent evidence before the court that deceased was traveling as passenger. And on perusal of exhibit R1 also, though it is mentioned as liability only policy, the premium is collected 25 rupees per WC employee 1. When suspecting the material available on record, the contention of the insurance company cannot be accepted. And the fact that 25 rupees premium is collected to WC to employee 1 is not in dispute. Only contention of the insurance company that carried a person in the tractor trailer, and hence company is not liable. And one council also would vehemently contend that only at the time of any accident was occurred while loading and unloading, the insurance company is liable, and the said contention cannot be accepted when the premium is collected in respect of WC employee one. Under the circumstances, there is a force in the contention of the petition of counsel that the tribunal committed an error in not considering the material available on record and erroneously fastened the liability on the insured instead of insurance company when the policy was in force as on the date of the accident and premium was collected towards WC employee. And hence it requires to be repaired. In view of the discussions made up, I pass the following order. Appeal is allowed, improved judgment and the award of the tribunal is modified. Setting aside the exonerating the liability of the insurance company and directed the insurance company to pay the compensation with interest. Amount in deposit made by the appellant is ordered to be refunded on proper identification. ಹಿಂದಿನ ಡಿಲೇ ಇದೆಯೇನ್ರಿ 321 days ಎಲ್ಲಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡಿ. The insurance company is not liable to pay the interest for the delayed period of ಎಷ್ಟು ದಿವಸ ಇದೆ ನೋಡ್ಕೊಳ್ಳಿ 321 ಅಂತ ಹೇಳ್ತಾರೆ. ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಚೆಕ್ ಅಂತ ಹಾಕೊಳ್ಳಿ.
ಇಲ್ಲ ಟೋಟಲ್ ಆರ್ಡರ್ ಆಗಿದೆ 2921 ಅಲ್ಲಿ
383 days ಅಂತ ಹಾಕೊಳ್ಳಿ. ಎಸ್ ಕೌನ್ಸಿಲ್ ಏನ್ರಿ? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರ. ಎಲ್ಲಿದೆ ರೀಸನಿಂಗ್? ಯಾವ ಸ್ಥಳದಲ್ಲಿ ಕೆಲಸ ಮಾಡುವಾಗ ವಿದ್ಯುತ್ ಶಾಕ್ ನಿಂದ ಅಪಘಾತವಾಗಿರುತ್ತದೆ ಎಂಬುದರ ಬಗ್ಗೆ ಸೂಕ್ತ ದಾಖಲೆ ಅಥವಾ ಸಾಕ್ಷ್ಯಾಧಾರಗಳ ಮೂಲಕ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಮರ್ಥಿಸಿಕೊಳ್ಳಲು ವಿಫಲರಾಗಿದ್ದು ಅಂತ ಇದೆ. ನಾಟ್ ಪ್ರೂವ್ಡ್ ಅಂತ, ನಾಟ್ ಫಾರ್ ದಟ್ ರೀಸನ್. Owner has denied the relationship. ಹೌದಾ? ಕೊಡಿ ಏನದು? CC ಆರ್ಡರ್ ಏನ್ರಿ? ಆರ್ಡರ್ ಬಿಟ್ಬಿಡಿ, ಬೇರೆ ಹೇಳಿ ನೀವು. ಬೇರೆ ವಿಟ್ನೆಸಸ್ ಆಯ್ತು. ಠಾಣೆಗೆ ದೂರು ನೀಡದ ನಂತರ 7 ತಿಂಗಳ ತಡವಾಗಿ ದೂರು ಸಲ್ಲಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಹೌದಾ? 7 months. 1 month ಆಯ್ತು. ಆಮೇಲೆ ಏನ್ ಮಾಡಿದೆ? 7 ತಿಂಗಳವರೆಗೆ ಏನ್ರಿ ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ ಅನ್ನೋ ಒಂದೇ ರೀಸನ್ಗೆ ನೋ ರಿಲೇಶನ್ಶಿಪ್ ಅಂತ. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ರಿ, ನೀವೇನ್ ಹೇಳಿದ್ರಿ? ದಾಖಲೆ ಏನಿದೆ? ವಿಟ್ನೆಸ್ಗಳು ಸಾಕ್ಷಿ ಹೇಳಿರೋದು ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ. ಆಯ್ತು, ಹಾ, ಸುಮಾರು 1.5 ವರ್ಷ. RW1 ಎಲ್ಲಿ ಏನ್ ಪ್ಯಾರಾಗ್ರಾಫ್? ಅದು ಆಲ್ ಆರ್ ಫಾಲ್ಸ್ ಅಂತ ಹೇಳೋರ್ರಿ ಕೊನೆಯಲ್ಲಿ. ಚೀಫ್ ಅಲ್ಲೇ ಹೇಳ್ತಾ ಇರೋದು. ಓದಿ, ಫಸ್ಟ್ ಇಂದ ಓದಿ. The government that applicant was working under the respondent as coolie and on 12:30 PM while the applicant combining the cable to the secondary line in the electric pole. The applicant sustained fracture of backbone and so on. So I was surprised not and immediately the applicant was treated in Pushpa Hospital, NR so on so. Thereafter the total disablement so on not able to even work are all false and incorrect antide. The chief admission No, not appointed any worker. I reliably learned that accident was taken place in the premises of the respond number 2 while giving electric connection to the water irrigation pump, which was used for the purpose of agriculture work for respond number 2. Hence, the respond number 2 himself appointed the applicant to do the above said work. Respond number 2 yaru? Landowner. Respond number 1 is? ಏನಂತ ಬಿದ್ದಿರೋದ್ರ ಬಗ್ಗೆ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಎಲೆಕ್ಟ್ರಿಕ್ ಇದರಿಂದಲೇ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ವಾಟ್ ಈಸ್ ದಿ ಮೆಟೀರಿಯಲ್ ಹೀಗೆ ಸುಮಾರು 2 ತಿಂಗಳ ಹಿಂದೆ ಆರೋಪಿ ಅಸೀಂ ಎಂಬುವರ ಗುತ್ತಿಗೆಯಲ್ಲಿ ಅವನು ಗುತ್ತಿಗೆ ಇವನಿಗೆ ಕೊಟ್ಟಿದ್ನ ಸದಾಶಿವ ಎಂಬುವರ ತೋಟದ ವಿದ್ಯುತ್ ಕಂಪದಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 and he was a contractor R1 ಹೌದಾ ಕಂಪ್ಲೇಂಟ್ ಅವತ್ತೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್ 6 ತಿಂಗಳ ಮೇಲೆ ಆಯ್ತು ಯಾರು ಕಳ್ಸಿರೋದು ಇಮೇಲ್ ಆಸ್ಪತ್ರೆಯಿಂದಲ್ಲ ಆಸ್ಪತ್ರೆಗೆ ಇಂಟಿಮೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು ಆಕ್ಸಿಡೆಂಟಲ್ ಇದು ಅಂತ ಏನಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಂತ ಏನ್ರಿ RW1 also admits in the evidence that in the place of Page number? ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು? ಪೇಜ್ ನಂಬರ್ 9. CC ಆರ್ಡರ್ ಮತ್ತೆ ಕಮಿಷನರ್ ಆರ್ಡರ್. ಆ ದಿನ ಕೆಲಸಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದರೆಂದು ಅಣ್ಣ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದ ಅಂತ, ತಮ್ಮಲ್ಲ. ತಮ್ಮನ್ನು ಕೆಲಸಕ್ಕೆ 1ನೇ ಪ್ರತಿವಾದ ತಮ್ಮನ್ನು ಕೆಲಸಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗಿಲ್ಲವೆಂದು ಮತ್ತು ಅವರು ಎಂದಿಗೂ ಎಲೆಕ್ಟ್ರಿಕ್ ಗುತ್ತಿಗೆಯನ್ನ ಕೆಲಸ ಮಾಡಿರೋರೆಂದು ಖುದ್ದು ಅರ್ಜಿದಾರರ ಪರ ಸಾಕ್ಷಿದಾರರು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಅಣ್ಣ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದ ಅಂತ, ತಮ್ಮಲ್ಲ. The fact that he fell down and sustained injury is not in dispute. And also case has been registered against you only. In case of injury, doctor examine ಮಾಡಿದಾರ, ಏನ್ ಹೇಳಿದಾರೆ? ಡಿಸಬಿಲಿಟಿ ಏನ್ ಇಂಜುರಿ ಏನು? ನೀವ್ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ? ಡಾಕ್ಟರ್ ಬಿಡ್ರಿ, ವರ್ಕಿಂಗ್ ರಿಗಾರ್ಡಿಂಗ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್, ಪ್ರೂವಿಂಗ್ ಆಫ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್. ಅವ್ರು ಬಂದಿರೋ ಎಂಪ್ಲಾಯ್ಮೆಂಟೇ ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ವಾ? ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಿರಿ? ಮಾಡೇ ಇಲ್ಲ, ಎಕ್ಸೆಪ್ಟ್ ದಿ ಇಂಜೂರ್ಡ್. ಮತ್ತೆ ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಿರಿ, ಬಟ್ ದಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಇದಲ್ವಾ considered by the criminal court. You would have examined some other person who are the co-employees before the tribunal. Set aside ಮಾಡಿ ರಿಮೈಂಡ್ ಮಾಡೋಣ ನೋಡಿ ಅಷ್ಟೇ. ನಾಟ್ ಟು ಪ್ರೂವ್. ಏನ್ ಬೇರೆ ದಾಖಲೆ ಏನು ಇಲ್ಲ ಎಕ್ಸೆಪ್ಟ್ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW1. Susan 6 ಏನ್ ಮಾಡೋಣ? ನೀವೇನು ಕೆಲಸನೇ ಮಾಡಿಲ್ವಲ್ಲ ಅಲ್ಲಿ, ಏನ್ ಮಾಡಿದಿರಿ? ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಅಷ್ಟೇ. ಯಾವುದೇ ಪೂರಕ ದಾಖಲೆಗಳು ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಅಂತಲೇ ಮಾಡೋದು. ಅವನು ಕಂಪ್ಲೀಟ್ ಆಗಿ ಡಿನೇ ಮಾಡಿದಾನಲ್ಲ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಓನ್ಲಿ ವಾಸ್ ವರ್ಕಿಂಗ್ ವಿತ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅಂತ ಹೇಳಿದರು. ಫಸ್ಟ್ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ರಿಗಾರ್ಡಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್. ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ, ಅಲ್ಲಿ ಮಾಡಿ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟು. ಹರ್ಡ್ ದಿ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೌನ್ಸಿಲ್ ಅಪೇರಿಂಗ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್. This appeal is filed challenging the judgment and award passed by the tribunal by the Workman Compensation Commissioner in Kapaka NF 16/2007 dated 13/3/2013, dismissing the claim petition. The factual matters of the case of the claimant before the Workman Compensation Commissioner that he was installing a cable to the secondary line. And the said work was under the supervision of first respondent. In the land belongs to the second respondent. And he had sustained in the said employment and immediately he was shifted to Puspa Hospital, Ennathura. And thereafter he was shifted to Manipal Hospital, wherein he was an inpatient from 12/11/2006 to 19/11/2006 and again 14/3/2007 to 18/3/2007. The tribunal, after considering the material, the tribunal, the Workman Compensation, the Workman Compensation Commission, after considering both oral and document evidence, dismissed the claim petition on the ground that the claimant failed to prove the relationship between the respondent number 1 and between him. And though documents are registered, and though case is registered against respondent number 1 and in the criminal case, he was acquitted. And counsel would vehemently contend that the material disclosed that he fell down and sustained the injury and immediately was shifted to the hospital. And in the chief evidence itself, the RW1 admitted that the incident was taken place in the land of respondent number 2. And in spite of it, dismissed the same. For count of the counsel appearing the respondent would submit that in the admission itself, it is very clear that they are not working under respondent number 1 and not established the employer and employee relationship between the parties. And the tribunal also in detail considered that the claimant has not substantiated that he was an employee of respondent number 1. And hence company is not, and hence the rightly dismissed the petition. Having heard the respective counsel and also on basis of material available on record, and though claim is made against respondent number 1 and 2, and only respondent number 1 contested the matter, respondent number 2 not contested the matter. ಯಾರು ನೀವಲ್ಲಿ ಹಾಕೋಬಹುದು, ಬಟ್ ಇಲ್ಲಿ ನಾನು ಕೇಳ್ತಾ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಕಂಟೆಸ್ಟ್ ಮಾಡಿರೋದು, ಹೌದಾ? And also on perusal of material, though R2 not contested the matter and R1 in his evidence categorically stated that he has learned that when the work was going on in the land of the respondent number 2, while giving electric connection to the water irrigation pump, which was used for the purpose of agriculture work of respondent number 2, an accident was taken place. And hence not disputed the accident is concerned. And it is contended that respondent number 2 himself appointed the applicant to do the aforesaid work. And he is nowhere connection to the work of electric repair or concerning any electrical work. As he was working, doing any electrical contract or work as contended by the claimant. But in the cross-examination, he categorically admit that a case was registered against him in FIR 65 of 2007. But his main contention that in the said case he was acquitted. The tribunal also, while answering the point number 1, erroneously committed an error that criminal case registered against the respondent number 1 was dismissed. And merely because of criminal dismissal of criminal case cannot be a ground to dismiss the claim petition when the injured has sustained the injury during the course of employment. And the claimant also not examined any other witnesses before the Workman Compensation Commissioner except the oral evidence in order to prove the factum of the relationship between the employer and employee, between himself and the respondent number 1 and 2. Hence, it is appropriate to remand the matter by giving an opportunity to the appellant oblique claimant to substantiate his contention, since tribunal only comes to the conclusion on the ground that no substantial material is placed before the commissioner to arrive for a conclusion of relationship between the claimant and also the respondent number 1 and 2. Hence, a date has to be fixed. Appearance of the parties before the Workman Compensation Commissioner oblique the concerned court. And the matter requires to be remanded for fresh consideration. In view of the discussions made up, I pass the following order. Appeal is allowed, improved judgment and award of the Workman Compensation Commission is set aside. The matter is remitted back to the concerned court to consider the matter afresh by giving an opportunity to the respective parties to adduce evidence. The parties are directed to appear before the concerned court on 6th of December 2022, and parties and the respective parties appear before the concerned court without expecting any notice. The concerned court is also directed to dispose of the matter within 6 months, and the registry is directed to send the records forthwith to enable the concerned court to take up the matter on 6th of December 2022. ಏನು injuries ಏನು clavicle bone ಅದು ಬಿಟ್ರೆ ಒಂದೇ ಇಂಜುರಿನ ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಕಡೆ ಎಲ್ಲ ಇದೆಯಾ ಇಲ್ಲ 70 ವರ್ಷನ ಡಾಕ್ಟರ್ನೇನ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋರ OPD ಡಿಸಬಿಲಿಟಿ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ OPD ಕಾರ್ಡ್ IME ರಿಪೋರ್ಟ್ ಇನ್ಪೇಷಂಟ್ ಇಲ್ವಲ್ರಿ ಬರ್ದಿದ್ದಾರೆ ಆಯ್ತು ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡೋಣ ಅಷ್ಟೇ ಆಯ್ತು ಇನ್ಪೇಷಂಟ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲೋ ಯಾರ ಮೇಲೆ ಮಾಡವ್ರೆ ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಮತ್ತೆ ಆಯ್ತು ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆಯ್ತು ಎಲ್ರಿ ಆಸ್ಪತ್ರೆ ರೆಕಾರ್ಡ್ ಸೇರಿದೆ ರೀ ಏನಿಲ್ವಾ ಏನೂ ಇಲ್ಲ 10,000 ಇನ್ನೊಂದು 10,000 ಕೊಡೋಣ ಅಷ್ಟೇ 20,000 ನೋಡಿ at the appellant counsel and also the counsel appearing for the respondent. The claimant has suffered the fracture of clavicle, and tribunal, after considering both oral and documentary evidence, awarded an amount of ₹10,000 as global compensation, and hence the present appeal is filed. The counsel appearing for the appellant would vehemently contend that tribunal, in spite of the doctor has been examined, not assessed the compensation and not awarded just and reasonable compensation. The counsel appearing for the respondent would submit that no material is placed before the court for having taken any treatment except the OPD card. And also, though disability certificate is marked and the doctor categorically admitted in the cross examination that he has not treated the injured and also not given any follow-up treatment. Having considered the respective submission and also on perusal of material, wound certificate exhibit P5 discloses that he had suffered the fracture of clavicle. And no inpatient records are produced and how long he took the treatment. Also, no material is placed except OPD cart exhibit P7 and exhibit P8 X-ray film report and medical bills 10 and 11 and exhibit P15 and 16 X-ray films. And having considered the same, it is a fit case to award an additional compensation of ₹10,000 considering the nature of fracture. We have the discussions made up by Pastipalangoda. Appeal is allowed and the judgment and award of the tribunal is modified, enhancing and granting another additional additional compensation of ₹10,000 with interest. Om Mahesh for R1. ಮತ್ತೆ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ರು. ಮತ್ತೆ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ರು. ಅವ್ರದೇನು ಅಪೀಲ್ ಏನು? ಅಪೀಲ್ ಮೆಮೊ ಕೊಟ್ಟಿಲ್ವಾ? ನಿಮ್ಗೇನ್ ಗ್ರೌಂಡ್ಸ್ ಗೊತ್ತಿಲ್ವಾ? ಅದೇ ಕೇಳಿದ್ ಏನು ಅಂತ ಗ್ರೌಂಡ್ಸ್ ಅಂತ ಗೊತ್ತಿದೆ, ನೋಡಿದೀರಾ ಅಂತ. ಆಯ್ತು, ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡೋದ್ ಬಿಡಿ. ನೀವು ನೋಡ್ಕೊಳ್ಳಿ, ಅಷ್ಟೊಳಗೆ ಗ್ರೌಂಡ್ಸ್ ನೋಡ್ಕೊಳ್ಳಿ. Appellant counsel present and counsel appearing for respondent not responding and he is sitting in VC and muting the court. Yen ground. ನೋಡಿ ಅವ್ರು ಈಸ್ ಇನ್ ಫೋನ್. ಈಗ ನೋಡ್ತಾ ಇದ್ದಾರೆ. ನಿಮ್ದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 16.
Not 14, I was told that it is urgent.
ನಿಮ್ದೊಂದು ಅಪೀಲ್, ಅವ್ರದೊಂದು ಅಪೀಲ್ ಇದೆ ನೋಡಿ. Sixteen, 14 ಅರ್ಜನ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
ಅಲ್ಲ 14 ಅರ್ಜನ್ ಆಗಿದೆ ಅಂತ ಇವಾಗ ಮೆಸೇಜ್ ಬಂತು.
15 ಅಲ್ಲ 16.
15.
16.
16.
16 ಮೇಲೋಡ. ಎಸ್ ಮೇಲೋಡ.
ಇಲ್ಲ, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ ಆಗಿದೆ.
ಕಂಪನಿ ಮೇಲೆ
ಮಾಡಿದ್ದಾರೆ. They have filed appeal challenging.
Why you have filed appeal?
Now enhancement.
ಏನ್ WC? Case of injury na?
Case of injury. Malad was a driver. Doctor 85% ಹೇಳೋರೆ.
ಎಷ್ಟು?
Amputation of right hand.
Amputation of
right hand.
Right ankle.
Right hand. 85% ಡಾಕ್ಟರ್ ಹೇಳೋರೆ. ಟ್ರಿಬ್ಯುನಲ್ 40% ತಗೊಂಡವ್ರೆ. ಸಿನ್ಸ್ ಈಸ್ ಎ ಡ್ರೈವರ್ ಬೈ ಪ್ರೊಫೆಷನ್ 85 ತಾಗಬೇಕು ಅಂತ 100 ತಾಗಬೇಕು ಅಂತ ನಮ್ ಕಂಟೆನ್ಷನ್.
ಆಯ್ತು.
ಆಮೇಲೆ 4,000 per month ಇನ್ಕಮ್ ಅಂತ ಹೇಳಿದ್ರೆ 2010 ಆಕ್ಸಿಡೆಂಟ್.
2010 subsequent to the amendment.
Subsequent to the amendment.
Subsequent to the amendment.
ಹೌದು, ಜೂನ್ ನಾಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ. ಇದು ಅಕ್ಟೋಬರ್ ನಲ್ಲಿ. ಅದು 10,000 ತಾಂತಿದ್ದ ಅಂತ ನಾವ್ ಹೇಳಿದೀವಿ. And he was having a driving license to interstate to DL ಇತ್ತು, ಅವಂತು ಹೆವಿ ವೆಹಿಕಲ್ interstate DL ಇತ್ತು. So in view of the amputation of right hand, my that since is a driver by profession having interstate driving license 8,000 ತಗೋಬೇಕು ಅಂತ ನಮ್ಮ ಕಂಟೆನ್ಷನ್.
ಎಷ್ಟು?
8,000 ಮ್ಯಾಕ್ಸಿಮಮ್. 205.95 ಇದು ಫ್ರಾಕ್ಷನ್ ಕರೆಕ್ಟ್ ಇದೆ. 31 ವರ್ಷ
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಟೂ ಸೈಟೇಷನ್ಸ್ ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್. ಒಂದು ಜಯಾ ಬಿಸ್ವಾಲ್ ಅಂಡ್ ಅದರ್ಸ್ ವರ್ಸಸ್ ಇಕ್ವಟೋಜೆ ಜನರಲ್ ಇನ್ಸೂರೆನ್ಸ್. ಕಾಪಿ ಕೊಟ್ಟು ಇದು WC ಆಕ್ಟ್ ಅಲ್ಲಿ ಸೆಲ್ಫ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಡಿಫೆನ್ಸ್ ಬರಲ್ಲ ಅಂತ.
ಅವ್ರದೇನ್ ಸೆಲ್ಫ್ ನೆಗ್ಲಿಜೆನ್ಸ್
ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್. ಅದು
All document in support of monthly wage. ಇದಾಯ್ತು. Truck driver course of employment, compensation of employees, compensation held cannot be reduced. Contributory negligence.
ಉಳಿದವೇನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಅಷ್ಟೇ. ಉಳಿದವೇನು ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇಲ್ಲ. ಇದು ಆಸ್ ಪರ್ ಶೆಡ್ಯೂಲ್ 90% ಬರುತ್ತೆ. ಆಂಪ್ಯುಟೇಷನ್ ಆಫ್ ರೈಟ್ ಟು ಅಪ್ಪರ್ ಲಿಂಬ್
90%.
WC ಆಕ್ಟ್ ಪ್ರಕಾರ ಡಾಕ್ಟರ್ 85% ಹೇಳವ್ರೆ, ಟ್ರಿಬ್ಯುನಲ್ 80% ತಗೊಂಡವ್ರೆ. ನಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸಿನ್ಸ್ ಈಸ್ ಎ ಡ್ರೈವರ್ ಬೈ ಪ್ರೊಫೆಷನ್ 100% ತಗೋಬೇಕು.
ಆಯ್ತು, ಅವ್ರ ಅಪೀಲ್ ಕಾಪಿ ಕೊಡಿ ಮೇಡಮ್.
But I have read, my lord, that the commissioner had no jurisdiction or power or authority, my lord. After the amendment of EC Act coming into force, my lord, from 18/1/2010. Petition, my lord, was presented on 23/2/2011 and disposed on 18/8/2013.
18/8/2013.
19/8/2013. But the Employees Compensation Amended Act came into force, my lord, with effect from 18/1/2010.
18/1/2010.
Section 20 of the, my lord, said Act. Therefore, my lord, the commissioner had no power, jurisdiction, my lord, to adjudicate.
Then he has adjudicated. That is the crux of the matter.
Therefore, the matter, my lord, has to go to the civil court, my lord, now for adjudication.
Henry, what is it?
He has not raised such objection before the commission.
Right, whatever it may be, there is the point of jurisdiction. You can set aside the order and send it to the concerned court now. In view of the amendment, that's all. ಹೌದಲ್ಲ, ಅಲ್ಲೇ ಹೋಗಿ. ಈಗ ಮತ್ತೊಂದ್ಸರಿ ನಿಮ್ಗೆ ಇನ್ನೊಂದು ಅವಕಾಶ ಸಿಗುತ್ತಲ್ಲ, ಶೆಡ್ಯೂಲ್ ಇಂಜುರಿ 90% ಅದೆಲ್ಲ ಅಲ್ಲಿ ಪ್ಲೀಡ್ ಮಾಡ್ಬೋದು ನೀವು.
ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಮಾಡಿರ್ತೀವಿ,
ಅದೇ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಮೇಲೆ
ಏನಾದ್ರು ಇದೆಯಾ?
23/1/2014 ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಇದೆ. 2014 ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿತ್ತು.
14 ಬಂದಿದೆ, ಬಟ್ ನಿಮ್ ಕೇಸ್ ಡಿಸೈಡ್ ಆಗೋದು 18/8/2013
ಹೌದು, 13
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿರೋದು 23.
ಇಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿರಲಿಲ್ಲ ಇನ್ನೂ, ಅದು
2010 ಅಲ್ಲಿ ಆಗಿರೋದು ಅಂತ. 18/1/2010
ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ. 14 ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದ್ದು, ಅಷ್ಟರಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು.
ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದ್ದು ಯಾವಾಗ? 23/1/2014.
ಹೌದು, ಅದಕ್ಕೆ ಮುಂಚೆನೇ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು.
ಈ ನೋಟಿಫಿಕೇಶನ್ ಗಿಂತ ಮುಂಚೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಲ್ಲ.
That is, my lord, regarding, my lord, who has got the jurisdiction to consider. But the act came into force, my lord, section 20 on 18/1/2010. By that time, my lord, commissioner had no power. Only thing is, my lord, who has to.
Consequent upon the act, the government has not issued any notification with regard to the establishment of courts.
But that doesn't mean, my lord, that the commissioner continues to be, my lord, this thing. When the act has come into force,
then till the date of 2014, where the claimants have to go?
Till, my lord, that date, my lord, when the matter is, my lord, then the court has to, the designated court has their jurisdiction, my lord.
That's all your argument.
Section 20, so 20 may kindly be looked into, my lord.
Subsequent to the order passed by the.
That is the notification, my lord, who has got the jurisdiction after removing the, my lord, commissioner of their power to, my lord, decide the WC claim. You must kindly, my lord, read the notification, my lord. The senior civil judges of, my lord, respective district have been made to deal with the thing and conform with the power and jurisdiction.
Plus designated the judicial officers to deal with the matter.
My lord, my respectful submission, my lord, section 20 of the, my lord,
Section only referring the notification.
The notification, my lord, will not overrule the, my lord, the provisions of the law. So let me kindly see, my lord. Ground number 2, my lord, I have taken a specific contention.
That's all your argument regarding jurisdiction, no jurisdiction.
That is jurisdiction, my lord. Then, my lord, you must kindly see. Ground number 5, my lord. That is the register to be maintained by the, my lord, the employer under the Minimum Wages Act. Then, my lord, ground number 6. The injured claimant admitted in his cross-examination that he could examine his alleged employer and failed to do so. And as such, there were no positive as well as conclusive evidence to prove relationship of employee and employer between the injured claimant and the insured. The commissioner further ought to have seen that it is customary for the transport manganese to several ports by hiring the good transport vehicle by mine owners whose employees are their own drivers and so on and so. He was not under the employment of the insured. That is one thing, my lord. Then ground number 7, my lord. The commissioner ordered that of Dr. Venkataramana Rao examined as PW3 that amputation of a right arm with a stump left of injured was due to the negligence of the injured himself in not taking timely and proper treatment and allowed gangrene to develop, resulting in amputation, which would have been avoided by proper and timely treatment. That is the evidence of Dr. PW3. And as such, the disability of loss of funding capacity to be assessed and computed at the rate of 80% was not justified. PW3 evidence may kindly be not looked into even otherwise. Therefore, my lord, considering this, my lord, let the matter go and let them prove, my lord, their thing before the competent, my lord, the court. Notification is only in respect of, my lord, which courts have got jurisdiction to, my lord. And there is one ruling of Justice Ram Mohan Reddy also, my lord, that once the commissioner is stripped of his position, power and jurisdiction, no order could be passed. Just attention to, my lord, evidence of the Dr. PW3.
Case of amputation of right arm.
But that is because of his own negligence in not taking the treatment. That's what, my lord, the doctor said.
What is your ground number 7 in your appeal?
Ground number 7, my lord, in my appeal. For his own negligence, my lord, even presuming that, my lord, that thing that the employer or the insured cannot be made liable for to an extent of 80%, which could have been cured, did not, my lord, because he allowed it to develop gangrene and ultimately it resulted in amputation. It is his own negligence. And substantial question of law may also be kindly be looked into, my lord. The acceptance of, my lord, the examination in chief by way of, my lord, the affidavit is unknown to the, my lord, the provisions of the WC Act or EC Act. substantial question from Malad, I'll read. Whether the commissioner had power or authority to hold inquiry proceedings under the provisions of the Employees Compensation Act 1923, amended by Act 45 of 2009, and particularly in view of the amended section 20 of the said Act. Whether the proceedings held conducted by the commissioner is in derogation of the provisions of the Act and vitiates for the reason the commissioner was not competent person as stipulated under section 20 of the Act, which came into force with effect from 18/1/2010 to discharge his duties as such.
You referred judgment of Justice Ramon Reddy.
Yes.
You details of that judgment.
Malad,
You can,
by 2:30, Malad, I'll give.
I will make it reserve. You furnish in the meanwhile. Heard, reserved.
Shall I file it in the registry, Malad?
You furnish to our court officer, huh? WP. WP. WP, what it says, Justice Ramon Reddy has delivered judgment in.
Decide these cases must be
But very establishment of civil judge and giving powers to the civil judge only in 2014.
2000.
After the.
They only.
ಅದು ಯಾವಾಗ ಅದು ಆಗಿರೋದು ಅಲ್ಲ ಅದು ಯಾವಾಗ ಆಗಿರೋದು ಮುಂದೆ ಇಲ್ಲೇನಾಗಿದೆ ಮ್ಯಾಟರ್ ವಾಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಆನ್ 18/8/2013 ಇಟ್ ಸೆಲ್ಫ್ ಅಲ್ಲ ಎನಾಕ್ಟ್ಮೆಂಟ್ ಬಂತು ಸರಿ ಬಟ್ ಯಾರು ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಕೊಡ್ದಲ್ಲೇ ಯಾವ್ದು ಕೋರ್ಟಿಗೆ ಪವರ್ಸ್ ಕೊಡ್ದಲ್ಲೇ ಹೌ ದಿ ಮ್ಯಾಟರ್ ಕ್ಯಾನ್ ಬಿ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ದಿ ಸಮ್ ಅದರ್ ಕೋರ್ಟ್ಸ್ ಮಾಡಿಲ್ಲಲ್ಲ ಈಗ 2014 ಅಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ after the notification if any orders is passed then without jurisdiction
All the proceedings before the commission not to pass any order strange
and adidre kodi ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ if such order has been passed ಆಯ್ತು ನೀವೇ ಕೊಡಿ ನೀವಾರು ಕೊಡಿ ಅವರಾರು ಕೊಡಿ ಅಟ್ ಲೀಸ್ಟ್ ದಿ ಅಕಾಡೆಮಿಕ್ ಪರ್ಪಸ್ ಅಲ್ವಾ ಯಾರು ಕೊಟ್ಟರು ಆಯ್ತು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ರಿಗಾರ್ಡ್ ಟು ದಿ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಥರ್ಡ್ ಅಂಡ್ ರಿಸರ್ವ್
ನೋಟಿಫಿಕೇಶನ್ ಜೆರಾಕ್ಸ್ ಮಾಡಿ
ನೋಟಿಫಿಕೇಶನ್ ಕೊಡಿ ನೀವು ಕಾಪಿ ಕೊಡಿ ನೀವು ಬೇಕಾದ್ರೆ
ಕೊಡ್ತೀನಿ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡು
ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಒಂದು ಜೆರಾಕ್ಸ್ ಇದು ಮಾಡ್ಕೊಂಡು ಕೊಡ್ಲಿ
ಅವ್ರಿಗೂ ಕೊಡ್ತೀನಿ
ಅಲ್ಲ they are also not disputing issuance of notification of the year 2014 it is their knowledge only reserved. His own negligence, what he is arguing only with regard to the amputation, gangrene agide, not negligence. Negligence with regard to not proper treatment and such his argument. Yes, sir.
In this case, I appear for a.
Malad, adnolu. ಆ ಬೇರೆ ಎಲ್ಲ ಇದು ಮಿಸ್ ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿದ್ರೆ ನಾನು ಐ ಬಿ ಏಬಲ್ ಟು ಕಮ್ ಇನ್.
15-20 ಏನು ಕೆಲಸನೇ ಮಾಡ್ತಾರೆ.
Unfortunately, it is true, Malad. My wife was admitted, my son was admitted, my daughter was. Malad, almost everybody has recovered now. Probably another 2 days, Malad. Next week, any date may kindly be, I'll appear and. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಮೆನ್ಷನ್ ಮಾಡಿ ತಗೊಂಡು ಇದಂಗ ಮಿಸ್ ಆಯ್ತು ಹಾಗಾಗಿ ಅಪಿಯರ್ ಇದೆ. ಹಾಕಿ ಸ್ವಾಮಿ ನಾನು ಇದಕ್ಕೆ
24th ಆಯ್ತು. ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಪಿ ನಟರಾಜ್ ಫಾರ್ R1. ಏನ್ರಿ
involvement of the vehicle. ಬೇರೆ ಇನ್ಯಾವುದೋ ಒಂದು ಅಪೀಲ್ ಹಾಕಿದ್ರು ಅದೇನೋ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು. ಡೀಕಾಲಿಂಗ್ ಆಗ್ತಿದೆ.
ಆಲ್ರೆಡಿ ಇದೆ ಇದೇನು
Altered ಆಯ್ತು. ಇನ್ನೊಂದು connected matter. It was remanded.
Tata Sumo 19/2002 PM complaint scooter
Remand ಆಗಿದೆ.
ಯಾವ್ದು ರಿಮ್ಯಾಂಡ್ ಆಗಿದೆ?
Connected matter which was dismissed for non-prosecution was restored. And 2-3 days back, another court has remanded the matter for fresh consideration.
ಆಯ್ತು. ಈಗ ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
This also, the learned friend is agreeable, could be remanded so that parties would get fair opportunity.
ಆಗ್ಬೋದಾ? ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್ ಇದು.
ಅದ್ರಲ್ಲಿ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್.
ಹೌದು, ಸೇಮ್ ಪಾಯಿಂಟ್.
ರಿಮ್ಯಾಂಡ್ ಆಗಿದೆ.
ಎರಡು ಕೇಸ್ ಇದೆ.
ಆ ನಂಬರ್ ಕೊಟ್ರೆ ಇಲ್ಲೇ ಮಾಡ್ಬೋದು. ನಿನ್ನೆ ಯಾವ್ದು ರಿಮ್ಯಾಂಡ್ ಆಗಿದೆ ಅಂದ್ರೆ
4171.
ಆ ನಂಬರ್ ಕೊಡಿ.
174.
74 of 2000
disposed of on 18/10/2022. 2022.
2022. ಮೊನ್ನೆ 18. 174 of 2012.
ಹೌದು.
ನೋಡಿ. The appellant counsel heard the both the counsel. The counsel appearing with the appellant would submit that in the connected matter, coordinate bench set aside the judgment and award of the tribunal and remitted back for press consideration. And the same is also arising out of dismissal of the claim petition. ಅದರಲ್ಲಿ ಅಲೋ ಆಗಿತ್ತಾ? ಇದು ಅಲೋ ಆಗಿದೆ. And ಏನಾಯ್ತು ಮೇಡಮ್? Press consideration since the insurance company has challenged the very involvement of the vehicle, and in this case also the very same ground has been urged for the involvement and for the involvement of the vehicle, and matter may be remanded to press consideration. The counsel appearing with respondent also present, and and counsel doesn't dispute the very fact of remanding the matter. When such being the case, when the insurance company disputed the very accident and involvement of the vehicle in the accident, matter has to be considered afresh in view of the order passed in MFA number 174 of 2012, with order dated 18/10/2022 and passed by the coordinate bench, and this matter also to be remanded to the tribunal for consideration of the matter afresh by setting aside the order passed in MEC numbers also. In view of the discussion, in view of the submissions of the respective counsel, the input order is set aside and matter is remanded to the tribunal for press consideration. Consider the other connected matter together. ಎರಡು ಒಟ್ಟಿಗೆ ಆಗೋಗ್ಬಿಡಿ. ಒಂದೇ ಕೋರ್ಟ್ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್. ಒಂದೇ ಕೋರ್ಟ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ. ಗೊತ್ತಿಲ್ಲ ಹಾಗಾದ್ರೆ ಬೇಡ. ಪ್ರೆಸ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. The parties are directed to appear before the court. ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಟ್ಟಿದಾರ ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಕೊಡ್ಲಿಲ್ಲ.
ಅವ್ರು ಕೊಟ್ಟಿರ್ತಾರೆ ನಾರ್ಮಲಿ. 6th of December ಕೊಟ್ಟಿರ್ತೀನಿ, ಅಲ್ಲೂ ಅದೇ ಮ್ಯಾಟರ್ ಬೇಕಾದ್ರೆ ಹಾಕ್ಸ್ಕೊಳ್ಳಿ. 6th of December ಬಾಕಿ ಎಲ್ಲ ಸೇಮ್. If amount in deposit is ordered to be refunded, proper identification. 20 ಶ್ರೀನಿವಾಸ್ ವಿ ರವಿ ಸಂಪ್ರತ್ ಈಗೆಲ್ಲ ಇದ್ರಲ್ರಿ ನಿಂತಿದ್ರು. ಈಗಿದ್ರಲ್ಲ ಇಲ್ಲಿ ಶ್ರೀನಿವಾಸ್ ಇಲ್ವಾ? ಪಾಟರ್ಡ್ ರವಿ ನಿಮ್ದೆ ಯಾರು? ಶ್ರೀನಿವಾಸ್ ಇದ್ಯಾಕೆ? ವೈ ಇಟ್ ವಾಸ್ ಪಾಟರ್ಡ್? Trailer no insurance.
Tractor and trailer. The tractor was insured with the insurance company. The trailer was not insured. In the cross examination, the insured attached that when the driver ಬಂದ್ಬಿಟ್ಟು ಅದರಿಂದ ಗಾಯ ಆಯ್ತು. It was argued that the accident did not.
ಏನೋ ಮೋಸ್ಟ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಲೈಟ್ ಮಾಡಿದ್ದಾರೆ. ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಏನೋ ಡಿವಿಷನ್ ಬೆಂಚ್ ಟ್ರಾಕ್ಟರ್ ಟ್ರೈಲರ್, ಅದನ್ನ ಟ್ರೈಲರ್ ಒಂದೇ ಮೂವ್ ಆಗಲ್ಲ, ಟ್ರಾಕ್ಟರ್ ಮೂವ್ ಆಗುತ್ತೆ. ಇಲ್ಲೇ ಒಂದಿದೆ.
ನಾನು ನನಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಕೊಡಿ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ.
ತೊಗೊಳ್ಳಿ, ಅವ್ರಿಗೆ ಕೊಡ್ರಿ, ಇದನ್ನೇ ಓದ್ಕೊಳ್ಳಿ, ಅವ್ರು ಕೊಡಿ. ಮಾಡಿದಾರೆ ನೋಡಿದೆ ನಾನು, ಐ ರೆಡ್ ಲಾಸ್ಟ್ ಟೈಮ್. ಅವ್ರು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡೇ ಮಾಡಿದ್ದಾರೆ. ಡಿಬಿದು
ಒಂದೇ ಏನಂದ್ರೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ಟ್ರೈಲರ್ ಕೂಡ ಇನ್ಶೂರ್ಡ್, ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ಶೂರ್ಡ್. 50% negligence ನಮ್ಮೇಲೆ 50%
ಹಂಗ್ ಮಾಡಿಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಡಿ ಮಾಡಿದಾರೆ ಏನ್ ಮಾಡಿದಾರೆ. The ratio is that trailer cannot move without the tractor.
Per contra, the would bring to the notice of this court in an unreported statement rendered by the coordinate bench of the court in the matter of Suvarna versus Thompson in MS number 513 of 2007, which is disposed of on 3/8/2011, wherein the view taken by the coordinate bench of this court is attended. It is well settled that it is the truck which can be driven by the driver. The trailer by itself is not a vehicle unless it is attached to a tractor. And the affirmance made in the petition, it has been held that the accident occurred with the tractor negligence driving by the tractor by its driver. When the tractor is insured as on the date of the accident, it is not open to the insurance company to contend that the second trailer was not insured as in this case. The claimants cannot be terminated at third parties as the deceased was riding a motorcycle and the accident occurred due to tractor negligence driving with the driver of the tractor, which was admittedly insured as on the date of the accident, and therefore the finding of the judgment that since the trailer was not insured, liability of the insurance cannot be imposed is perverse and arbitrary and liable to be set aside. When the judgment of the insurance is seen in the background of the aforesaid judgment, this court is of the considered opinion that the judgment referred to the direct counsel. The wherein constitution assignments will be unreported judgment on 3/8/2011. In the case of Suvarna, we applied to the facts of the case on all four. In the present case, admittedly, the deceased also, who was a watchman in a shop situated in APMC yard, was unconnected to the vehicle involved in the accident. According to the complaint, and he was proceeding in the compound of APMC yard. The accident is caused due to rash and negligent driving by the driver of tractor in moving and the tractor backward and hitting the deceased trailer, which was attached to a tractor as to see. It is due to rash and negligent driving of the driver of tractor. The trailer which was attached to a tractor was hit the deceased, resulting in the death. Therefore, the say that the accident caused due to the trailer is without any basis. As observed by the counsel.
The division bench order on the last date of hearing.
ಅದೇ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟೆಡ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಇದನ್ನ ನಾನು ಹೇಳಿದಾಗ ತಾವು ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. ನಾನು ಪ್ರಿಂಟ್ ತಗೊಂಡ್ ಬಂದವನು ಮರ್ತ್ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟೆ, ಅದಕ್ಕೋಸ್ಕರ ಓಡಾಗಿ ಎತ್ಕೊಂಡ್ ಬಂದೆ ಅಷ್ಟೇ. ಐ ಆಮ್ ಸಾರಿ ಮಿಲಾಟ್.
ಅದನ್ನೇ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರ?
ಅದನ್ನೇ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಎಸ್ ಮಿಲಾಟ್, ಇಟ್ ಇಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟೆಡ್. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 7 have been extracted. Page number 9 ಅಲ್ಲಿ ಇದೆ. The extracted portion what my learned friend have just now read is in page number 9.
That is extracted by the coordinate
bench of this honorable court.
Corona case is rightly found when other counsel Manjunath the Patil appearing to the claimant that record of the report is not ಇದು ಇಂಜುರೀಸ್ ಏನ್ರಿ? ನೀವು ಕ್ವಾಂಟಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ. ಏನ್ ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನು?
Blood nature of injuries, blood is left forearm and left leg was fractured and fixed with DCP plates. Blood.
How long he was in the hospital?
Blood from 7/9/2011 to it was stated that he was treated as inpatient from page number 12, paragraph number 12, page number 12, 7/9/2011 to 9/9/2011, and also undergone surgery of internal fixation at Shekhar Hospital, Temple Road, Bangalore. And he was asked to undergo one more surgery for removal of implants.
ಆಯ್ತು, ಇಲ್ಲೇನು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಎಲ್ಲ 1.5 ಲಕ್ಷ ಅಂತ ಹೇಳಿ ಫ್ಯೂಚರ್ ಕಾಂಪನ್ಸೇಷನ್ ಅವಾರ್ಡ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
Liability have been fixed on the owner of the vehicle. That's why I am before this.
ಅದಾಯ್ತು, ನೀವು ಕ್ವಾಂಟಮ್ ಆಲ್ಸೋ ಚಾಲೆಂಜ್, ನೀವು ಕ್ವಾಂಟಮ್ ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಲ್ವಾ?
Milord, I am seeking enhancement of the compensation. Yes, Milord.
Then how the tribunal has assessed the disability of 1,50,000 permanent disability without any?
Milord, PW2 doctor have been examined, Milord. He has clearly stated
disability 17% ಅಂತ ಹೇಳಿದ್ದಾರೆ, but that should be calculated ಅಲ್ಲ?
Yes,
no such calculation. 1,50,000 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. But the doctor, left forearm and left leg was fractured. Right. Two injuries, sir.
Yes, my lord. May I just pass on the evidence of PW2, my lord?
Assess ಮಾಡೋದು ಎಷ್ಟೇ ಹೇಳಿ ಬಂದಿದ್ಯಾ shifted hospital to first and previous injuries, removal of implants, so undergone one more surgery. Kal fracture ಏನು leg was fractured ಅಂತಿದೆ ಏನದು
ಎಲ್ಲ
forearm ಇದೆ ರೀ
forearm
ಇದೆ leg was also fractured ಅಂತ ಬರೀತಾರೆ ಏನದು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಲೆಫ್ಟ್ ಅಪ್ಪರ್ ಲಿಂಬಿಗೆ ಮಾತ್ರ ಅವ್ರು 17% ಹೇಳಿದ್ದಾರೆ ಹೌದಾ
yes my lord
ವೇಗ ಅಂತ ಮಾಡಿ 1,50,000 ಅಂತ ಮಾಡಿದ್ದಾರೆ ಈ ಕಡಿಮೆ ಆಗುತ್ತೆ ನನ್ನ ಪ್ರಕಾರ ಇಫ್ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಒನ್ ಫ್ರಾಕ್ಚರ್ ಅದು ಮತ್ತೆ 1.5 ಲಕ್ಷ ಹೇಗೆ ಕೊಟ್ರಿ ಎಷ್ಟು ಏಜ್ ಅವ್ನು ವಾಟ್ ಇಸ್ ಇಸ್ ಏಜ್
but
37 years
yes my lord he was 30
only one fracture 30,000 pain and suffering okay loss of immunity 20,000 52,000 medical expenses so period of treatment 18,000 loss of income during laid up period ಕೊಟ್ಟಿಲ್ಲ hospitalization ಕೊಟ್ಟಿಲ್ಲ ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಪರ್ಮನೆಂಟ್ ಡಿಸಬಿಲಿಟಿ 1.5 ಲಕ್ಷ ಇದೆಯಲ್ರಿ ಮತ್ತೇನು ಅನೌನ್ಸ್ಮೆಂಟ್ ಮೇಡಮ್ ಹಂಗೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ 8% ಡಿಸಬಿಲಿಟಿ ತಗೊಂಡ್ರೆ
they have not filed any cross appeal my lord
forearm
they have not filed any cross appeal
ಆಯ್ತು ಅಲ್ಲೇ ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ ಬೇರೆ ಎಕ್ಸಲ್ ಕೊಟ್ರೆ ಜಾಸ್ತಿ ಆಗುತ್ತಾ ಇಲ್ವಾ ಅದು ಈಗ ಓನ್ಲಿ ಪಾಯಿಂಟ್ ಆಫ್ ಲಯಬಿಲಿಟಿ ಮೇಲೆ ಮಾತ್ರ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ
yes my lord 6,000 notional income ತಗೊಂಡಿದ್ದಾರೆ
37 ಇದೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಫ್ ದಿ ಇಯರ್
2011
6,500
yes my lord
6,500 ಎಷ್ಟು ಬರುತ್ತೆ ನೋಡಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಎಷ್ಟು ಸೇರಿದಾರೆ ಅವನು
3 days ಇದೆ my lord 7/9/2011 to 9/9/2011 yes my lord he was suggested removal implants removal surgery
ಜಾಸ್ತಿ ಆಗಿದೆ ಮತ್ತೆ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಲಯಬಿಲಿಟಿ ಓನ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ ಅಷ್ಟೇ 50% ಅದು ಮಾಡಕ್ ಬರಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಂಡ್ ಇದು ಮಾಡೋದು ನಿಮ್ ಸಬ್ಮಿಷನ್ ನಾನು ನೋಟ್ ಮಾಡ್ತೀನಿ ಆಯ್ತು ಆರ್ಡರ್ ದಿ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ respondent. This appeal is filed challenging the liability as well as the quantum of compensation. Questioning the judgment and award passed in MEC number 5652 of 2011. The factual matters of the case of the claimant that he met with an accident and sustained fracture of humerus. And he was an inpatient and also subjected to surgery and implant was also removed. In support of his claim, he examined himself as PW1 and also examined the doctor as PW2. The tribunal, after considering both oral and documentary evidence, awarded compensation of rupees 2,70,000. And the same has been questioned in this appeal. Having considered the nature of fracture of forearm and also the tribunal without considering the disability, global compensation of rupees 1,50,000 is awarded on the head of future loss of income. That is with regard to the permanent disability. However, not awarded any compensation on the head of loss of income during the laid up period, as well as other incident.
loss of earning during treatment period 18,000 award ಮಾಡಿದ್ದಾರೆ
18,000 period of treatment.
yes period of treatment
ಮಾಡಿದ್ದಾರೆ period ಏನಾಯ್ತು ಮೇಡಮ್ ಬೇಡ however awarded an amount of 18,000 towards loss of earning during the period of treatment and not awarded any compensation on the head of other incidental expenses. And having considered the compensation awarded, I do not find any ground to enhance the compensation. Compensation awarded is just and reasonable. However, the very contention of the insurance company or the claimant that tribunal committed an error in passing the liability on the owner instead of the insurance company. In support of his contention, he also relied upon the judgment of division bench MFA number 24621 of 2012, connected with MFA number 20314 of 2013. And in fact, similar strength of facts and circumstances, involvement of the trailer and causing an accident with this court in division bench. Fasten the liability on the insurance company. The judgment relying upon the division bench of this court, the coordinate bench also. This is a MFA. The similar set of facts. Fasten the liability on the insurance company in MFA number 100239 of 2016 connected with MFA number 100246 of 2016. And shifted the burden on the insurance company. The counsel appearing for the respondent would vehemently contend that when the trailer was not insured and only tractor was insured, this court can only consider 50% of compensation to be payable to the insurance company, not in entirety. The said submission cannot be accepted in view of the judgment of division bench of this court referred supra and also the coordinate bench of this court referred supra, wherein also the 100% liability is shifted on the insurance company. And hence I do not find any force in the contention of the counsel appearing for the respondent. Having taken note of the principles laid down in the judgment of division bench as well as the judgment of coordinate bench, wherein also refer the division bench judgment of this court and fasten the liability on the insurance company, and hence it is a fit case to fasten the liability on the insurance company instead of owner. In view of the discussions, but if I pass the following appeal is allowed, input judgment and award is modified, setting aside the liability, exonerating the liability of the insurance company, and the liability is fastened on the insurance company to pay the compensation amount. First allowed in part on modest.
Compensation amount together with interest. Together with interest.
Interestable. Interestable.
6 weeks on the date of receipt.
6 weeks.
Please.
All common. Avella mat dictate madakol. 21.
First respond.
Ravish Benny for Arman, Manju and Manju Associates.
Appearing for appellant.
Claimants, claimants, sir. Manju and Manju Associates.
Nave claimant.
Manju and Manju Associates.
Owner.
Nimda claimants appeal aido. In ground and
claim petition is dismissed.
Dismissed. Reason.
Reason given by the trial court is C report has been filed by the investigating officer. There's a delay of 2.5 days in giving the complaint. 2.5 days. In giving the complaint. C report is filed by the investigating officer. That my case is the injured was a pillion rider in a motorbike. The motorbike hit the auto.
Hit the auto rickshaw.
In fact, complaint was given against the driver of auto rickshaw at the first instance. We have filed a claim petition against the owner and rider of the motorbike.
Motorcycle.
So adike auto na party madilla anta heli more reasons koಟ್ಟು claim petition has been dismissed. The tribunal has calculated the compensation 3,38,000 ಲೆಕ್ಕ ಮಾಡಿರು. Since the driver of the auto rickshaw, owner and driver of the auto rickshaw has not been made as party to the proceedings, claim petition has been dismissed.
Negligence ಬಗ್ಗೆ ಏನು pending ಕೊಟ್ಟಿದ್ದಾರೆ?
Negligence ಬಗ್ಗೆ at para number 9 ಮೇಲೆ. Para 10, sorry, page number 9. Police have filed C report.
FIR ಆದ್ಮೇಲೆ C report ಹಾಕಿದ್ರು.
C report. Next aspect, para number 14. He has not proved the accident.
The evidence given by the petitioner PW1 is contrary to the police records except the interested oral testimony of petitioner. Nothing has been placed on record to prove the petition allegations. On appreciating the available materials on record in the considered opinion of this as approached by suppressing the real facts and fails to prove the so. Occurrence of accident remains intact without any proof.
My lord, even in spite, even the owner of the auto.
IME report idea. IME report idea.
IME report.
Even vehicle damage idea.
IME report nade. Exhibit. exhibited.
Front right side indicator damaged. At least have you made any efforts before this court to bring the auto and insurance? ಅಂದ್ರೆ ಯಾವ್ದು ಒಂದು ಟ್ರೇಸ್ ಆಗ್ಲಿಲ್ಲ ಆಟೋ ರಿಕ್ಷಾ?
ಇಲ್ಲ ಟ್ರೇಸ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ
ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆದ್ರೂ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ ನಮ್ ಕಂಟೆನ್ಷನ್. ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆದ್ರೂ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು. ಏನಿದೆ ರೈಡರ್ whether accident is not disputed, whether the driver of the auto or driver of the motor vehicle is negligence in causing the accident. That should be the relevant aspects.
Yes, motorcycle. Auto came and hit this vehicle. Fire and all those.
Auto came or he went and hit the auto? Adjudication.
The auto came and hit his vehicle. There is no finding in this regard. They have not produced any document that first responder rider of the motorcycle is negligent. Meaning that the case is police.
Nature of injuries entry. Nature of injuries entry.
Part of one submission. Came under section 166 of India.
Ido.
They have to claim
166
pending vehicle.
166.
Number pending.
Fracture of femur, fracture of lateral malleolus, fracture of a skull. ಏನು ಅಂದ್ರೆ
ಆಯ್ತ್ರಿ 166 ಪಿಟಿಷನ್ ಇದ್ದಾಗ
no, he was a pillion rider, not a rider.
ಆಯ್ತು ನೆಗ್ಲಿಜೆನ್ಸ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ ಪಿಲಿಯನ್ ರೈಡರ್ ಆದ್ರೂ. He has to prove the negligence.
My lord, see, since the police have filed C report against the driver of the auto rickshaw.
Have you questioned the same?
No, we have not questioned under the circumstances.
ನೋಡಿ ಏನ ಫ್ಯಾಕ್ಟ್ಸ್ ಏನಾದ್ರು ಇದ್ರೆ ಅದರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ.
Rider of the motorcycle is also in negligence in causing the accident since the.
But ನಿಮ್ ಕ್ಲೈಮ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ ಆತರ ಇದೆಯಾ? ನಿಮ್ ಕೇಸ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡುವಾಗ ಆತರ ಇದೆಯಾ?
ಇಲ್ಲ, ನಮ್ ಕಂಪ್ಲೇಂಟ್ we have given against the.
ಮತ್ತೆ
ನಾನ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ some.
ಯಾರೇ ಕೊಡ್ಲಿ?
Against the driver of the auto rickshaw only ಕೊಟ್ಟಿದ್ದು.
Did not even
an opportunity.
That is not your case.
An opportunity may be given, my lord. We will prove the negligence of the driver also, rider of the motorcycle.
ಇಲ್ವಲ್ಲ ನಿಮ್ದು ಸಿ ರಿಪೋರ್ಟ್ ಹಾಕೋ.
ಅಲ್ಲ, ಆಟೋ ರಿಕ್ಷಾ ಮೇಲೆ ನಾವು 49 ಮಾಡಿಲ್ಲ.
ಫರ್ದರ್ ರಿಪೋರ್ಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಬೇಕು.
ಸಿ ರಿಪೋರ್ಟ್ is filed against the driver of the auto rickshaw.
ಆಯ್ತು.
ಅದನ್ನು we are not going against the driver of the
any of the records which you have placed before the court shows that he was also a negligence ಅಂತ ತೋರಿಸಿ.
My lord,
rider of the motorcycle.
motor vehicle inspection report.
ಅದೇ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ಅಂತ.
ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ.
ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ.
both the vehicles were involved. That is also the case of the complaint.
ನಿಮ್ಮ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ. That is not any records ಅಲ್ಲಿ ನಿಮ್ಮ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ಸ್ ಅಲ್ಲಿ no is there any mention about the negligence on the part of the rider of the motorcycle in which your pillion rider was proceeding?
ಬೇರೆ ಯಾರು ಓನರು ಅವರ ಅಪ್ಪ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫಾದರ್ is a paternal his own paternal uncle and first respond.
Relatives
plot ಮಾಡಿ
relatives
ಅಂದ್ರೆ ಫಾದರ್ ಅಂಕಲ್ is injured.
Injured uncle is the owner.
ಇಲ್ಲ, father is the owner of the motorcycle.
Injured father
first respondent is driving the vehicle and is uncle, paternal uncle, own brother of the second respondent. That is owner of the
ಏನಿಲ್ರಿ ಸಿದ್ದರಾಮಯ್ಯ VBS ಏನಿದೆ?
ಅಲ್ಲ, ನಮ್ ಕಂಪ್ಲೇಂಟ್ ಕೇಸ್ ಇರೋದಲ್ಲ.
ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಆಟೋ
ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ತಗೊಂಡ್ ಮಾಡಕ್ಕೂ ಏನು ಇಲ್ಲ ಅಂದೆ ಅಲ್ವಾ? ನೋಡಿ, how do the appellant counsel and also the counsel appearing with the respondent. This appeal is filed challenging the judgment and award passed in ABC number 160 of 2014, dated 17th September 2014 on the file of first additional senior civil judge and MACT at Davangere, questioning dismissal of the appeal. The main contention of the counsel appearing for the petitioner would submit that tribunal committed an error in dismissing the entire crime petition, even though C report is filed against the offending vehicle. And counsel also would submit that it is not in dispute that this claimant is the pillion rider of the vehicle in which the petitioner was proceeding, and ought to have taken even contributory negligence against the rider of the motorcycle. Per contra, the counsel appearing for the respondent would submit that the claimant and his uncle and father, all of them have joined together only in order to make the wrongful gain and given the details of an auto rickshaw. And the same was also not involved in the accident. And hence, the IO investigated the matter and filed the charge sheet C report before the court. And the same is also not challenged. When such being the case, when there is no allegation against the rider of the motorcycle about the negligence on his part, the question of entertaining the claim petition under 166 doesn't arise. ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಓದ್ತಾನೆ. ಹಾ
Even then,
the council also would submit that the tribunal in paragraph number 14 of the judgment in detail discussed with regard to the suppressing of the material before the tribunal. Rightly come to the conclusion that 14 alla madam 15 then 16 and factor 15 and 15 and hence no grounds to set aside the impugned order. Having heard the respective counsel and also on perusal of material with the case of the claimant that two vehicles are involved in the accident. And also admittedly a complaint is given against the driver of the auto rickshaw who came and hit the two-wheeler. And also admittedly complaint was given after 2.5 days. And it is the contention of the insurance company that the auto rickshaw was falsely implicated in the case in order to make wrongful gain. And police have also investigated the matter and filed a C report stating that no vehicle was involved in the accident. The tribunal also in detail discussed while considering the material and record in paragraph 15 of the judgment. And also comes to the conclusion that the auto rickshaw was not made as party to the auto rickshaw driver and the owner was not made as party to the proceedings. And also observed in the order that there is a delay of more than 2.5 days in filing the complaint. And there was sufficient time. And sufficient time was taken to file the complaint. And complaint is also filed after that. And if really the accident occurred due to the negligent riding of the motorcycle by respond number 1, then nothing was prevented to say the said fact in the complaint. The tribunal also taken note of the contents of the complaint, wherein no allegations are made against rider of the motorcycle. When such being the case, the tribunal rightly dismissed the claim petition and hence I do not find any merit in the appeal to revoke the finding of the trial court. The counsel appearing for the appellant to contend that IMA report which is marked as exhibit B5 discloses the damages to the motorcycle. No dispute with regard to the damages to the motorcycle. But I have already pointed out that in a petition of 166, there must be a specific allegation against the rider of the motorcycle which was involved in the accident, and no such allegation, and also no such material is placed before the court regarding negligence on the part of the rider, and instead of in the complaint, allegations are made against the driver of the auto rickshaw. And hence no merit to reverse the finding. And hence the contention of the appellant counsel that auto have taken the contributing negligence also cannot be accepted in the absence of any present evidence before the court regarding contributing negligence. In view of the discussions made by pass the following order. Appeal is dismissed. Ian Vishwanatha.
I appear for the respondent, madam.
ನೀವಿದ್ದೀರಿ ಇವತ್ತು ಅವತ್ತು ಅವರಿಲ್ಲ ಇವತ್ತು. Appellant counsel is absent, respondent counsel is present. List this matter on 24. 23 O Mahesh Kunaba Kedi Laya. Ibro ilva. Both the counsels are absent. List this matter on 24. 24 ಅರ್ಜೆಂಟ್ ಆಯ್ತು. ಬೆಳಗ್ಗೆ ನಿಮ್ಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಕ್ ಹೇಳಿದೆ, ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ಡೇಟ್ ಯಾರೋ ಬಂದು ತಗೊಂಡ್ರು, ಯಾರೋ R1 ಕೌನ್ಸಿಲ್ 23rd ಪೋಸ್ಟ್ ಮಾಡಿದ್ರು. ಈ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಇನ್ಫಾರ್ಮ್ ಯು. ಐ ಓನ್ಲಿ ಡೈರೆಕ್ಟೆಡ್ ಹಿಮ್ ಟು ಇನ್ಫಾರ್ಮ್ ಇಂಟಿಮೇಟ್. ಬಟ್ ಏನ್ ಮಾಡೋದು, ಡೇಟ್ ತಗೊಳಕ್ ಒಂದ್ ಹೇಳ್ತಾರೆ, ಮಾಡ್ತೀವಿ ಅಂತಾರೆ ಮಾಡೋದು. 25 ಮತ್ತೆ VV ಸಿದ್ದರಾಮಯ್ಯ
WC appeal ಮೇಲೆ workman compensation appeal.
Madhukar Nadi for R2, BC Sitaram Rao for R1. Sitaram Rao. Unmute. Ready na?
Okay.
Are you ready?
Yes, yes, ma'am.
Time petition is
Madhukar
dismissed.
Nadi, twist.
Holding that he himself is negligent. Allah,
ಏನೆಲ್ಲ
sorry.
ಬರೀ ಡಿಸ್ಮಿಸಲ್ ಇರೋವೇ ಇಲ್ಲಿ ಪೋರ್ಟಲ್ ಇರೋದು ಡಿಸ್ಮಿಸಲ್ ಮತ್ತೆ
ಇಲ್ಲಿ-
ಲಯಬಿಲಿಟಿ.
ಈ ಲಯಬಿಲಿಟಿಗೆ ಏನಾಗಿರುತ್ತೆ, ಕ್ಲೈಮೆಂಟ್ಗೂ ಅಂತ ಇಂಟ್ರೆಸ್ಟ್ ಇರಲ್ಲ, ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿಯರ್ಗೂ ಅಂತ ಇಂಟ್ರೆಸ್ಟ್ ಇರಲ್ಲ. ಎಸ್ ನಾ ಕಳ್ಕೊಳೋದು ಯಾಕೆ ಅಂತ.
ಆಯ್ತು ನೀವು
Why-
ಕಳ್ಕೊಳ್ಳೋದು ಬೇಡ ಉಳಿಸ್ಕೊಳ್ಳಿ ಹೇಳಿ.
While loading the sand,
While loading the sand,
the injured was sustained,
tractor and trailer
he
bearing
injured and he
also
died in
used
the
to
course of the accident. ಅದಕ್ಕೆ not in the course of the accident ಅಂತ tribunal has come to conclude.
loading and unloading is not in the course of
Course of
employment.
employment ಅಂತ tribunal has come to conclusion at para number. The clear evidence to show that this is extracting without
While extracting the sand, the employment, hence without much discussion, I answer. Yes, really then.
evidence a complaint may kindly peruse method act. Not the case of the complainant. Exhibit P1.
In exhibit R1, the policy doesn't cover the risk of employee in the. Policy ಇದೆಯಾ?
Policy ಇದೆ.
Policy ಇದೆ, but policy liability ಇದೆಯಾ?
ಇದೆ. Premium.
Agriculture.
Compulsory PA come owner driver 100 ಇದೆ.
ಏನಿದೆ?
Basic 1750.
Package policy. Premium 7,900. Basic 50,750. Trailer TP.
PA for owner and
PF for owner.
additional 100 collect ಮಾಡ್ಕೊಂಡವ್ರೆ. That is for the additional. That is for the employees ಅಂತ.
But it does not conclusively say that he is an employee, he is a coolie. The claimant is a coolie, he is not a driver nor the owner. Even the insurance policy does not cover the coolie.
ಕೇಳ್ತಾ ಇಲ್ಲ.
Sorry, madam.
Stable, but connection is unstable.
ಇಲ್ಲ, ನಾಳೆ ಹಾಕಿದ್ರೆ ನಾನು ನೋಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀನಿ.
ಇಲ್ಲ ರೀ, ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಮೋಸ್ಟ್ಲಿ.
ನಾಳೆ ನಾನು ನೋಡ್ಕೊಂಡ್ ಬಂದ್ ಹೇಳ್ತೀನಿ.
Manoj,
council 6.
Manoj, am I audible? Am I audible, Manoj?
The disturbance ಇದೆ.
Sorry, Manoj, sorry.
This matter and else this matter 24. ಏನ್ರಿ ಇವತ್ತೆಲ್ಲ ಬರೀ ಸಿದ್ದರಾಮಯ್ಯ ಡೇ ಅಲ್ರಿ? ಏನು
ನಾದವು ಎಲ್ಲ ಇವತ್ತೇ
ಅಜೆಂಡ್ ಮಾಡಿದ್ವು. ಆಯ್ತು, ಓ ಮಹೇಶ್ವರ್ ಇದಾರ?
ಇದು
ಶರೀಫ್
ಕ್ಲೈಮೇಟ್
ಫೋಟೋ ಹಾಕಿ ಹೋಗಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಕ್ಲೈಮೇಟ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇದೆ ಅಂತ
ಫೋಟೋ ಹಾಕಿ ಹೋಗಿದ್ದಾರೆ. ನಾನು ಸ್ಮಾರ್ಟ್ ಆಗಿದ್ದೀನಿ ಅಂತ ಅಷ್ಟೇ. ಯಾವ್ದು ಹಳೆ ಫೋಟೋ ಹಾಕೋ?
ಇಲ್ಲ, ಈಗ್ಲೂ ಅವ್ರು ಸ್ಮಾರ್ಟ್ ಆಗೇ ಇದ್ದಾರೆ.
ಹೌದಾ? ತೆಗಿಬೇಕು. ಏನ್ ಮಾಡೋದು? ನೀವೆಲ್ಲ ಹೇಳ್ಬೇಕಲ್ಲ, ತೆಗಿ.
ಇಲ್ಲ, ಏನಾಗತ್ತೆ, ವಿಸಿ ಕೆಲವು ಸಲ ಕನ್ವೀನಿಯಂಟ್ ಆಗುತ್ತೆ,
ಕೆಲವು ಸಲ ಇನ್ಕನ್ವೀನಿಯಂಟ್.
ಇಲ್ಲ, ಎಲ್ಲಾ ವರ್ಕ್ ಮುಗಿದಾಗ ಯಾವ್ದೋ ಒಂದ್ ಸಣ್ಣ ವರ್ಕ್ ಇದ್ದಾಗ
ಮತ್ತೆ ನಾವು ಕೊರೋನಾ ಬಂದಾಗ ಹಾಕೊಂಡ್ರೆ ಆಯ್ತು.
ಅಲ್ಲ, ಹಂಗಲ್ಲ. ಎಲ್ಲ ವರ್ಕ್ ಮುಗಿದ ಸಣ್ಣ ವರ್ಕ್ ಇದ್ದಾಗ ವಿ ಕ್ಯಾನ್ ಅಟೆಂಡ್ ಥ್ರೂ ವಿ ಸಿ ಇನ್ ಫ್ರಮ್ ಆಫೀಸ್. ಎಲ್ಲ ವರ್ಕ್ನು ವಿ ಸಿ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಏನ್ ಮಾಡೋದು? ಉಮೇಶ್ ಇಬ್ರು ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. 10th ಇಲ್ಲ, 10th ಜಾಸ್ತಿ ಹಾಕಿದೀವಲ್ಲ. 24th.
ಎಸ್ ಪ್ಲೀಸ್.
ಮಾದೇವಸ್ವಾಮಿ
Claimant appeal for seeking enhancement, my lord.
ರೆಡಿ, ಹೇಳಿ.
The
ಕೇಸ್ ಆಫ್
appellant is-
ಇಂಜುರಿನಾ?
Yes, my lord. The
Injury.
comminuted fracture of digital of end right radius, my lord.
ರೇಡಿಯಸ್.
Yes, my lord.
ಆಯ್ತು,
He underwent surgery for external fixation of KY.
ಆಯ್ತು.
He 4 days inpatient treatment has taken.
Comminuted fracture distal end of radius right. Underwent text. ಆಯ್ತು, ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ಸ್ 20,000 ಬರೀ.
20,000 ಕೊಡಿ.
ಯಾವ ಇಯರ್ ಆಕ್ಸಿಡೆಂಟ್?
2013, man.
13.
Yes. Total amount 94,043 rupees is awarded.
ಎಷ್ಟು ದಿವಸ ಇದ್ರ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ?
4 days, my lord.
4 days.
Yes, ma'am.
5,000 ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟವ್ರೆ. ಡಿಸಬಿಲಿಟಿ ಅಂಡ್ ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ 20,000.
Conveyance and other expenses is ಒಂದು
ಏನು ಕೊಟ್ಟೆ ಅಲ್ವಾ? ಡಿಸಬಿಲಿಟಿ ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀರಾ?
ಎಕ್ಸಾಮ್ ಮಾಡಿದ್ದೀವಿ. 10% ಓಲ್ ಬಾಡಿ ಡಿಸಬಿಲಿಟಿ ಹೇಳಿದೆ.
10%.
Yes, ma'am. Malady is working at SPA, permanent employee for Ambedkar Free University College. He is serving rupees 39,000.
ಕೆಲಸ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ.
Loss of during later.
ಕೆಲಸ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ.
ಕೆಲಸ ಕಂಟಿನ್ಯೂ.
ಹಾಗಾದ್ರೆ ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಬರಲ್ಲ.
ಅದು ಬರಲ್ಲ.
ಓನ್ಲಿ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್. ಎಷ್ಟು ದಿವಸ ರಜಾ ತಗೊಂಡಿದ್ದೀರಿ?
We are not.
ದಾಖಲೆ ಏನಾರು ಕೊಟ್ಟಿದ್ದೀರಾ? ಮತ್ತೆ
because he is taken as 1 month, 4 days inpatient.
4 days inpatient ಅಷ್ಟೇ.
At least 1 month he is taking.
ಆಯ್ತು, 1 month salary ಎಷ್ಟು?
39,000.
ಹಾ.
And my lord, other expense, other my lord is.
ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
20,000 ಕೊಡಿ.
ಮತ್ತೆ ನಿಮ್ಗೆ ಇನ್ ಯಾವ ಎಡ್ಸಲ್ ಕೊಡ್ಬೇಕು? ಓನ್ಲಿ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಮಾತ್ರ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, ಅಮ್ಯುನಿಟೀಸ್ ಲೋವರ್ ಸೈಡ್ my lord.
ಕಮ್ಯುನಿಟೀಸ್ 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
And conveyance nourishment to 5,000.
ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು 10,000 ಕೊಡ್ಬೇಕು.
Pain and suffering.
ಗ್ಲೋಬಲ್ ಇನ್ನೊಂದು 30 ಪ್ಲಸ್ ಒಂದು 10.
ಅಲ್ಲ my lord, in this case my lord, before the trial court has given the joint memo of rupees 1,56,000 my lord. 1,56,000.
ಯಾವ ಹೆಡ್
ಆ ಟೈಮ್ ನಲ್ಲಿ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ.
ನೀವು ಪ್ರಿಪೇರ್ ಮಾಡಿರೋದ ಅಥವಾ ಅವರ?
ಇಲ್ಲ, ಸೈನ್ ಮಾಡಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
ಎನಾನ್ಸ್ಮೆಂಟ್ 1 ಲಕ್ಷ.
ಇಲ್ಲ.
ಟೋಟಲ್ ಅಷ್ಟೇ ಆಯ್ತಲ್ಲ. ನಾವು ಮಾಡ್ತಾರೆ 55 ಪ್ಲಸ್ ಒಂದು 60,000. ನಾನೀಗ ಅಷ್ಟೇ ಹೇಳಿದ್ನಲ್ಲ, 1 month ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಪ್ಲಸ್ ಒಂದು 10,000. 50.
ಅಲ್ಲ, ಅಮ್ಯುನಿಟೀಸ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು 10,000 rupees. ಇಂಪ್ಲಾಂಟ್
20,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇಂಪ್ಲಾಂಟ್ಸ್ ಹಾಕಿದಾರೆ ಸುಮ್ಮನೆ. KY ರಿಮೂವಲ್ ಮಾಡ್ಬೇಕಾಗಿರುತ್ತೆ.
ಆಯ್ತು, ಒಂದು 60,000 ಮಾಡಿ ಅಷ್ಟೇ ಬರುತ್ತೆ. 60 ಅಂದ್ರೆ ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಇಲ್ದಾಗ ಅಮ್ಯುನಿಟೀಸ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು. ಅಲ್ಲೊಂದು 10,000. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ಸ್ ಅಲ್ಲಿ ಒಂದು 10,000. 20 ಆಯ್ತಾ? ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ 39,000. 1 month ಜಾಸ್ತಿ ಏನು ಕೇಳಿಲ್ಲ. 40, 20, 60 ಅಷ್ಟೇ. Third, the appellant counsel and also the counsel appearing for the respondent. This appeal is filed questioning the quantum of compensation. And some claimant had suffered completed fracture distal end of radius right. And he underwent surgery of external fixator and K-wire fixation. And tribunal awarded only 20,000 on the head of pain and suffering. And it requires enhancement of additional compensation of ₹10,000 and medical expenses based on the documentary evidence. And food and nourishment also given 5,000 as against 4 days inpatient. And disability doctor assessed 10%, and however he has continued the job and hence not awarded any compensation on the head of future loss of income. And amenities awarded 20,000 is meager and hence additional compensation of ₹10,000 is ordered. Apart from that, no loss of income is considered when he had suffered the fracture of distal end of radius, and it requires minimum 1 month for the rest and for uniting of fracture, and no document is placed before the court how long he was an inpatient, and he was an employee and he was drawing salary of ₹39,000 per month. And hence 1 month salary loss of income is taken, it comes to 40,000. In all, payment is entitled for additional compensation of in all 60,000. ಏನ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಏನಂದ್ರಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರ?
ಇಲ್ಲ 6% ಇದೆ.
With 6%.
2013 ನಲ್ಲಿ ಆಗ್ಬೇಕಿತ್ತು. ಇವಾಗ ಅದೇ ಅಮೌಂಟ್ ಇವಾಗ ತಗೊಂಡ.
Next. Vijay Kumar, P. Vijay Kumar, Suresh M. Latur. ಅವ್ರದ್ದು ಒಂದು ಅಪೀಲ್ ಇದೆ. Latur.
Yes, sir, I am appellant here. ನಮ್ದೊಂದು ಅಪೀಲ್ ಇದೆ.
Ready na?
Enhancement of yes, ready, my lord.
First, Vijay Kumar,
My lord, the appeal is by the BMTC, my lord, challenging negligence and quantum of compensation awarded by.
In case
My
of
lord, the
injury.
claimant is a boy of 13 years.
13 years.
13 years. My lord, you are riding the motorcycle. He came from Party Road and entered the Tannery Road. From right side, suddenly entered the main road and dashed against the right side hind portion of the bus. Thereby he sustained injury. It is only a deglowing injury to the knee. And my lord, yes, there is no head-on collision or the bus never dashed from the front portion. He came from right side cross road and suddenly entered the right road and dashed against the right side hind portion of the bus. Thereby, my lord, the police, they have not examined any independent eyewitness. The complaint was given by one police, but he was not at the place of accident. But a false case has been registered against
He was at the spot. Police.
he was away from the spot. He came later and he came to know that the accident and he gave a complaint against the driver of the bus. Thereby, my lord, a charge sheet has been filed against the driver of the BMTC bus. Tribunal, considering this aspect, my lord, has fixed the entire negligence on
Have
the
you
part of-
examined the driver?
We have not examined.
Then ಮತ್ತೆ without examining the driver, how what can comes to a conclusion of the contributing?
There is no eyewitnesses.
I next.
Then, my lord, regarding quantum of compensation, my lord. So last month, the claimant has not produced the wound certificate.
Certificate ಹಾಕಿಲ್ಲ.
Hakila. They have produced only the discharge summary at exhibit P8. Exhibit P8 is the Victoria Hospital document, discharge summary. It shows deformity in the left leg and debridement of the left leg. It's only laceration wound, deep laceration wound. There is no fracture.
No fracture.
No fracture. And my lord, Dr. My lord, PW3, Dr. Ramesh PW2, my lord, he has not treated the claimant. And he has assessed the disability, my lord, without taking into consideration of the actual injury. My lord, at para 10, ability component 30%, stability component 20%, then deformity 6%, then pain 6%, then my lord, deep complication 6%. Totally, my lord, he has assessed 68% disability. But this is not pertain to the functional disability. Yes, not a treated doctor.
Tribunal ಎಷ್ಟು ತಗೊಂಡ್ರು?
Criminal, my lord, has taken the disability at my lord. 20% into. Yes. By following the decision of the Mallikarjun, my lord, it has awarded 3 lakh rupees towards disability. In addition to it, my lord, a tribunal has awarded, my lord, 50,000, that is not applicable towards pain and suffering. Mallikarjun case
pain and
ಬರಲ್ಲ.
suffering
Mallikarjun ಯಾವ್ದು ಬರಲ್ಲ.
ಆಯ್ತು.
Medical expenses, my lord, 1,75,000, my lord, it is they are produced a false and fabricated document. He has taken treatment in Victoria Hospital and Boring Hospital. I don't know how these documents came up. You have disputed the medical expenses.
Boring hospital.
ಹೌದು.
Treatment records pertaining to those 2 hospitals
Yes,
are
yes.
different.
ಹೌದು. 1,75,000 medical bills are produced.
ಅಲ್ಲ ಅದೇ ರೀ ಅಲ್ಲಿದೇನಾ ಅದೇ ಹಾಸ್ಪಿಟಲ್
ಅಲ್ಲಿದಲ್ಲ ಬೇರೆದು.
ಬೇರೆ ಬಿಲ್ಸ್
ಹೌದೌದು.
ಬೇರೆ ಬಿಲ್ಸ್ ಹಾಕ್ತಾರೆ.
ಬರೋದಿಲ್ಲ. Then my lord, food nourishment attend charges 15,000. Conveyance charges 8,000.
ಅಲ್ಲಿ ಹೆಡ್ಡಲ್ಲಿ ಕೊಡೋದು
ಯಾವ್ದು ಬರಲ್ಲ.
ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್
ಯಾವ್ದು ಬರಲ್ಲ.
ಡಿಸಬಿಲಿಟಿ ತಗೊಂಡ್ಮೇಲೆ
ಹೌದು. Loss of income for the parents 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of academic year, my lord, there is no document to show that he has lost one academic year. And there is a record to show that he is continuing in studies and there is no loss of academic year. Still 25,000 is awarded. Totally 5,88,000 is awarded. My lord, regarding disability, my lord, the doctor, his evidence cannot be believed and relied upon. It is only a avulsion injury. Avulsion injury. And the tribunal has taken disability to whole body. Maybe that may be just and reasonable. But even as far as
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿ ಬೇರೆ ಹೆಡ್ಸಲ್ಲೆಲ್ಲ ಮತ್ತೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಬರಲ್ಲ.
How it is permissible? Alva. Nourishment and ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ?
20 days.
20 days, sir.
ಹೌದು.
Your lordship may kindly peruse the exhibit P10 photographs, the injuries sustained by the petitioner.
Loss of academic year ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ ದಾಖಲೆ?
Evidence ಇದೆ sir, ಅದು ದಾಖಲೆ
ಇದೆಯಾ? Oral evidence.
oral evidence.
ಆಯ್ತು, ಇವನ್ 30% ಡಿಸಬಿಲಿಟಿ ಇಟ್ಕೊಂಡ್ರು 3 ಲಕ್ಷನೇ ಬರೋದು ಡಿಸಬಿಲಿಟಿ ನಿಮ್ಮ ಪ್ರಕಾರ.
That I am not disputing.
ತಂದೆ ತಾಯಿ 20 ದಿವಸ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಇದ್ರು, ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ 15 ಇರೋದು 25 ಮಾಡ್ಬೋದು, 25,000. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಎಷ್ಟು ದಿವಸ ಇದ್ರು? ಅದೊಂದು 8,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ನೋರಿಶ್ಮೆಂಟ್ ಅಂಡ್ ರಿಟರ್ನಿಂಗ್ ಚಾರ್ಜಸ್ ಅವೆಲ್ಲ ಬರೋದೇ ಇಲ್ಲ. ಬರ್ತದೆ 1,75,000.
ಅಲ್ಲ, that is disputing.
ಎಲ್ಲಿದೆ ಅದು ಬಿಲ್ಲು?
ನೋಡಿ, ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದೀವಿ.
Have you elicited anything about the concoction of document for making? ಎಲ್ಲಿದೆ ಅದು?
My son was not treated in the Apollo hospital. He was treated in Santosh Hospital, Bowring Hospital, Victoria Hospital.
My son
At
was
that time,
not
it is
treated
true
in
to
Apollo
suggest that
hospital.
the doctor in the said hospital have not advised me to take a treatment, further treatment in any hospital. There is no further treatment at all. Even the discharge summary or any documents from the said hospitals is not produced. It is false to suggest that my son was treated in Apollo Hospital. Apollo Hospital, we have disputed it. For some other, not for the injury sustained in the accident. I do not remember the date on which my son was discharged from the hospital. I have already produced the document to show that my son took follow-up treatment in Apollo Hospital. It is false to suggest that medical bills at exhibit 20 are created. It is true. Exhibit P9, 1, 3, 9 and 13 are bills which the decision is not shown. The car pertaining to the said bills are booked on, and I know the name of the owner of those cars. I do not know the said bills or don't bear the seal and signature of the owner. They were obtained whenever my son was taken to hospital. It is true to suggest that those bills are numbered serially. It is false that the said conveyance bills are created for the getting higher compensation. It is false to suggest that I am deposing false by producing created documents. All those bills are not pertain to the injuries sustained in the accident and he has not taken treatment. They are all created documents. Take a treatment in Bowring and Victoria Hospital. Where is the question of producing 1,75,000 bills? That cannot be believed and relied upon.
Victoria Hospital ಬಿಲ್ಗಳೇ ರೀ ಇವು.
ಅದು 33,000 ಅಷ್ಟೇ ಬರ್ತದೆ.
Victoria Hospital discharge card exhibit P8 ಇದೆ ಸರ್. ಆಮೇಲೆ Apollo Hospital discharge summary and two summaries, discharge summaries of Apollo hospitals.
ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಯಾವ್ದು ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ,
ಏನಿಲ್ಲ, ಎಲ್ಲ
ಇಲ್ಲ. 1,58,507 rupees medical bills ಇದಾವೆ.
ಮೆಡಿಕಲ್
ಬಿಲ್ಸ್ ಅಂದ್ರೆ ನಮ್ ಹಾಸ್ಪಿಟಲ್ ಇದು ಡ್ರಗ್ ಶಾಪ್ ದಿಂದ ತಗೊಂಡದ್ದು ಬಿಲ್ಸ್.
ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ಇವೆಲ್ಲ ಬಿಲ್ ಯಾವ್ದು ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ. ಜನತಾ ಬಜಾರ್ ಡ್ರಗ್
ಅಲ್ಲ ಅಂತದೆಲ್ಲ ಮಾಡೋದಿಲ್ಲ, ಹಂಗೆಲ್ಲ ಇರ್ತೈತ್ರಿ.
It's only declaring injury.
ಮೆಡಿಕಲ್ ಯಾವ್ದು ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ ಇಲ್ಲ, ಏನಿಲ್ಲ.
ಎಕ್ಸಿಬಿಟ್ P20 ಇದೆ ಸರ್. ಎಕ್ಸಿಬಿಟ್ P20 ಆಮೇಲೆ P19 Medical bills exhibit P14 ಅದಾವ ನೋಡ್ರಿ sir. Exhibit P14 and P20. Prescriptions exhibit P21.
And even it is a Prime Minister's SSY program, they have taken the treatment. Central government scheme, where the treatment is, the cost of treatment is free. ಅದೆಲ್ಲ reimbursement ಬಂದಿರುತ್ತೆ.
St. John's Medical College ದೆಲ್ಲ ಬಿಲ್ಸ್ ಇದೆಯಲ್ಲ ಏನ್ರಿ ಇದು?
ಅಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿಲ್ಲ, ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅದೇನು. ಅಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್
Central Medical College,
ಎಲ್ಲ ಕಾಲೇಜ್.
St. John's Medical College
Apollo Hospital ಇದೆ ರೀ.
ಅಲ್ಲ ಬೇರೆನೂ ಇದೆ, St. John's Medical College ಇದೆ ನೋಡಿ.
ಅವ್ರು ಡಿಫರೆಂಟ್ ಡೇಟ್ ಮತ್ತೆ ಏನಾರ ಔಟ್ ಪೇಷಂಟ್ ಆಗಿ ಹೋಗಿರ್ಬೋದು.
ಬೈ ಎನಿ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್, ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ ಇಲ್ಲ, ಏನಿಲ್ಲ,
ಏನಿಲ್ಲ.
ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ. ಅಪೋಲೋ ಸ್ಪೆಷಾಲಿಟಿ ಹಾಸ್ಪಿಟಲ್, ಅಪೋಲೋದಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರಾ?
ಹೌದೌದು, 2 ಸಲ ಅಡ್ಮಿಟ್ ಅದಾನ ಸರ್.
As per the evidence of doctor, you ask me kindly see.
ಇಲ್ಲ, produced the discharge summary.
Doctor admits that there is no requirement of future treatment at all.
ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ನೋಡಿ, ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಪ್ರಕಾರ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿರೋದು ಓನ್ಲಿ ಬೋರಿಂಗ್ ಹಾಸ್ಪಿಟಲ್ ಅಂಡ್ ವಿಕ್ಟೋರಿಯಾ.
ಹೌದು.
ಅಂಡ್ ಆಲ್ಸೋ ಆನ್ ದಿ ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಯಾವ್ದೋ ಒಂದು ಹಾಸ್ಪಿಟಲ್, ಹೌದಾ?
ಅಷ್ಟೇ.
ಹೌ ದೋಸ್ ಬಿಲ್ಸ್ 1,75,000 ಅಲ್ಲಿ ಒಂದು 25,000 ಕೊಡ್ಬೇಕು.
ಅದು ಆಮೇಲೆ ಮಾಡಿದ್ದು ನಮ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಟೇಕನ್ ಬೈ ದ ಪಿಟಿಷನರ್ ಇನ್ ಅಪೋಲೋ ಹಾಸ್ಪಿಟಲ್ ಆಫ್ಟರ್ 1 year.
ಕೋರ್ಟ್ ಮುಂದೆ ಬನ್ನಿ, ಯು ವೆರಿಫೈ ದಿ ಬಿಲ್ಸ್ ಅಂಡ್ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್, ಶೋ ಮಿ ದಿ ಬಿಲ್ಸ್, ದೆನ್ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಮೆಡಿಕಲ್
Yes.
ಬಿಲ್ಸ್ ಆರ್ heard in part. This matter and sorry madam, in notes it. Hmm.
20th.
Date 24. Tier number 29. Nagesh Ramaya Sanmati.
Owner of
Case of death, owner of it.
owner of
Owner of it. You know, passenger. Passenger.
Date of accident 16/13, no, FIR is 16/13.
First. Gracious passenger ಅಂತ ಹೇಳೋರ ಅಥವಾ ಬೇರೆ
ಇಲ್ಲ, ಗೋಯಿಂಗ್ ವಿತ್ ಗ್ರಾಸ್ ಅಂತಲೇ
ಗ್ರಾಸ್
ಹುಲ್ಲಿನ ಮೇಲೆ ಕುತ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದ.
ಗಾರ್ಡಲ್ಲಿ ಇದ್ದ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ಮೆಟೀರಿಯಲ್ ಇದೆಯಾ?
ಏನು ಕಂಪ್ಲೇಂಟ್ ಬಂದಿದೆ, ಹುಲ್ಲು ತುಂಬಿಕೊಂಡು ಹುಲ್ಲಿನ ಮೇಲೆ ಕುತ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ. ಎಕ್ಸಿಬಿಟ್ P2. ಹೌದು. P2 ಏನೆಂದರೆ ದಿನಾಂಕ 16/12/2013 ಬೆಳಗ್ಗೆ ಸುಮಾರು 11:45 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ಹಾಗೂ ನಮ್ಮೂರಿನ ಪುಟ್ಟೇಗೌಡನ ಮಗ ಶ್ರೀನಿವಾಸ ಇಬ್ಬರು ಪಾಂಡವಪುರ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ನ ನಮ್ಮ ಸ್ವಂತ ಕೆಲಸ ನಿಮಿತ್ತವಾಗಿ ವಾಪಸ್ ನಮ್ಮೂರಿಗೆ ಬರಲು ಯಾವುದೋ ಆಟೋದಲ್ಲಿ ಹತ್ತಿಕೊಂಡು ಪಾಂಡವಪುರ ನಾಗಮಂಗಲ ರಸ್ತೆಯ ಹಳ್ಳಿ ಸಮೀಪ ಬೆಳಿಗ್ಗೆ 11:45 ಬರುತ್ತಿದ್ದಾಗ ಅದೇ ಸಮಯದಲ್ಲಿ ನಮ್ಮೂರಿನ ಜಯರಾಮರವರ ಟ್ರಾಕ್ಟರ್ನಲ್ಲಿ ಭತ್ತದ ಹುಲ್ಲನ್ನು ನಮ್ಮೂರಿನ ಶಿವಲಿಂಗೇಗೌಡ ಮತ್ತು ನಿಂಗಣ್ಣ ಮಗ ಮಹೇಶ್ವರರನ್ನು ಕೂಡಿಸಿಕೊಂಡು ಟ್ರಾಕ್ಟರ್ನ ಓಡಿಸಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದಾಗ ರೋಡ್ ಹಂಸ್ನಲ್ಲಿ ಹುಲ್ಲಿನ ಮೇಲೆ ಕುಳಿತಿದ್ದ ಶಿವಲಿಂಗೇಗೌಡ ಎಂಬರು ಕೆಳಗೆ ಬಿದ್ದು ಹೋದರು. ತಕ್ಷಣ ನಾನು ಮತ್ತು ಶ್ರೀನಿವಾಸ ಆಟೋಗಳು.
ಆಕ್ಸಿಡೆಂಟ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಆಯ್ತು?
ಆಕ್ಸಿಡೆಂಟ್ 11:45 AM.
Complaint was given at what time?
Complaint was given at 16/12/2013 at 2 p.m.
Same date, 2 p.m.
Same date.
In 2 hours. 2 hours 15 minutes. ಹೌದಾ?
ಹೌದು.
ಏನಿದೆ ಪ್ಯಾಸೆಂಜರ್ ತೋರ್ಸಕ್ಕೆ?
passenger. ಬೇರೆ ಯಾರೋ ಹುಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಅವನ್ನ ಇಟ್ಕೊಂಡು ಅವ್ನು ತಗೊಂಡು ಹೋಗ್ತಾ ಇರಲಿಲ್ಲ. He was the practice passenger.
ಹೌದಾ? ಹಾಗಂತಿದ್ಯಾ? ಎಲ್ಲಿ
ಇಲ್ಲ, ಆ ತರ ಇದು ಕೇಸ್ ಇಲ್ಲ.
ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿಂದ ಬಂತು ಅಂತ ಅದು? ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡಕ್ಕೆ ಎಲ್ಲಿದೆ ಅಂತ?
ಅದಕ್ಕೆ ಮೆಟೀರಿಯಲ್ ಏನು ಇಲ್ಲ, ಅವ್ರ ಪ್ರಿಸಂಪ್ಷನ್ ಅಷ್ಟೇ.
ಮತ್ತೇನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವ್ರು ಏನು ರೀಸನಿಂಗ್ ಏನ್ ಕೊಟ್ಟು?
ರೀಸನ್ ಗ್ರಾಟ್ಯುಯಸ್ ಪ್ಯಾಸೆಂಜರ್ ಅಂತಂದ್ರೆ ರೀಸನಿಂಗ್
ಅದು
ಕೊಟ್ಟರೆ.
ಹೇಗೆ ಅಂತ? ವಾಟ್ ಇಸ್ ದಿ ಮೆಟೀರಿಯಲ್?
ಪ್ಯಾರಾ ನಂಬರ್ 24 man.
24 only. Traveling any person in a tractor apart from the driver is illegal and the policy of insurance does not cover the risk of any inmate of a tractor. The permitted shifting capacity of a tractor is only one that of a driver.
ಅದಕ್ಕೆ ಫೈಂಡಿಂಗ್ ನ ಪ್ಯಾರಾ ನಂಬರ್ 16 ಆಗಿ ಕೊಡ್ತಾರೆ. 16 ಅಲ್ಲ 17 ಆಗಿ ಕೊಡ್ತಾರೆ. ಅದರಲ್ಲೂ ಏನು ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ಏನು ಹೇಳಲ್ಲ. Main contention of the in the para number 24 ನಲ್ಲಿ the main content the response number 2 is that this is that illegally traveled in the said vehicle as gratuitous passenger, though he was not supported in support of their contention respond, though he was not supported to ಯಾವುದು ಸಪೋರ್ಟ್ ಇಲ್ಲ ಅಂತ ಅದೇ ಹೇಳ್ತಾರೆ. They have relied on some citations. ಮುಂದೆ
Doesn't come to owner that he has allowed the person with goods. Now that improve ಮಾಡಬೇಕು. Payments at owner. If this was coming along with goods, how is it like? Oh, they have to prove.
ಅದೇ ಪ್ರೂವ್ ಮಾಡೋದ್ರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P1 ಅಲ್ಲಿ ಹೇಳಿದಾರಲ್ಲ, he was traveling along with a stock ಅಂತ.
ಇದೆ ಅವನು ಹುಲ್ಲಲ್ಲಿ ಕುತ್ಕೊಂಡಿದ್ದ ಅಂತ ಅವನ್ನೇ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದ ಹುಲ್ಲು.
ಹುಲ್ಲಿಗೆಲ್ಲ ರೆಕಾರ್ಡ್ ಒಂದು ಕೊಡಕ್ಕಲ್ಲ. ಇಟ್ಸ್ ಓನ್ಲಿ ಅಗ್ರಿಕಲ್ಚರ್.
ಆಯ್ತು, ದಟ್ಸ್ ಆಲ್ ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಅಷ್ಟೇನಾ? ಈಗ ಲಯಬಿಲಿಟಿ ಅಂದಿ ಒಂದು
ಓನರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್.
ನಿಮ್ಗೆ ಓನ್ಲಿ ಕೊಲೆ ಚಾಲೆಂಜ್ ಮಾಡೋದು ಓನ್ಲಿ ಲಯಬಿಲಿಟಿ.
ಹೌದು.
ನೋಡಿ, heard the appellate counsel and also the respondent. This appeal is filed challenging the judgment and award passed in MEC number 77. The factual matters of the case of the claimant before the tribunal that claimants that the deceased was traveling along with cross to feed deceased as per the instructions of respondent number 1 carrying grass to feed their cows in tractor and trailer, and due to rash and negligent driving of the driver of the tractor trailer, he fell down from the tractor near the humps. As a result, he had sustained injury and succumbed to the injuries. The claimant, in order to substantiate their claim, examined PW1 and also examined PW2 and got marked document exhibit P1 to 7. On the other hand, respondent examined one witness and got marked document exhibit R1 to R4. The tribunal, after considering both were not documentary evidence, allowed the claim petition granting compensation of ₹7 lakhs with 9% interest, and liability is fastened on the insured and exonerated the liability of the insurance company. Hence, the present appeal is filed by the claimant. The main contention of the counsel appearing for the claimant before this court that the tribunal committed an error in coming to the conclusion that he was a gratuitous passenger. Instead of the documentary evidence clearly discloses that he was proceeding along with grass in the tractor. And tribunal committed an error in presuming that he was a gratuitous passenger. And in the absence of any documentary evidence with regard to the fact that he was a gratuitous passenger, the tribunal ought not to have comes to such a conclusion, and hence it requires the parents. Per contra, the counsel appearing for the insurance company would vehemently contend that tribunal in detail discussed the evidence available on record, both oral and documentary evidence, and rightly comes to the conclusion that he was a passenger, gratuitous passenger, not permitted to carry any passenger in the tractor trailer. Having heard the respective counsel and also perusal of material available on record, but also the evidence of PW 1 and 2 as well as documentary evidence, and this court has to look into the document of exhibit B to complaint, wherein specifically it is mentioned that he was traveling along with the gross, and also specific allegation is made that and the instructions of R1 only he was carrying the grass in the tractor trailer. And the accident was on account of negligence on the part of driver of the tractor and trailer. In the cross examination of PW1, who is the complainant, who gave the complaint and traveling in the auto rickshaw. Stated that he has given the complaint and he only got it written the complaint. And suggestion was made that he was sitting on the mudguard, and the said suggestion was denied. They suggested that he did not witness the accident and the same was denied. In the cross examination of PW1, except suggesting that the deceased was sitting on the mudguard, nothing is elicited from the mouth of PW1. And apart from that, no doubt, the insurance company examined RW1, who is the officer of the insurance company. And in his affidavit, he has stated that he was a gratuitous passenger. And in the cross examination, he admits that policy exhibit B 2 is a package policy. ಏನ್ರಿ RW1 ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾನೆ.
ಹೌದು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡು
ಆ ದಿನ ಭತ್ತದ ಹುಲ್ಲಿನ ಲೋಡರ್ ಆಗಿ ಟ್ರಾಕ್ಟರ್ ಮತ್ತು ಟ್ರೈಲರ್ ನಲ್ಲಿ ಹೋಗಿದ್ದರು.
ಹೌದೌದು ಮಾಡ್ಕೊಂಡು.
The RW1 also admitted in the cross examination that the deceased proceeded in the tractor and trailer as loader. And also admits that he might have proceeded on the instructions of the respondent number 1. Having taken the note of the admission of RW1 and also the material available on record, though admits that he was proceeded as loader in the tractor and trailer, that tribunal committed an error in fastening the liability on the owner instead of the insurance company. Hence committed an error in fastening the liability on the owner, and hence it requires interference of this court. In view of the discussions made above, I possible and appeal is allowed. The judgment and award of the tribunal is modified, fastening the liability on the insurance company by exonerating the liability of the insured. The insurance company is liable to pay the compensation within 6 weeks. Yes, counsel. Any submissions?
Serial number 34, man. 34.
34 ಏನಾಗ್ತದೆ?
Next week.
ಅದರ ಸೈಡ್ ಆದ್ರೆ ಇದರ ವಿಷ್ಣುಮೂರ್ತಿ
ಇಲ್ಲ ಯಾರು
ಇಲ್ವಾ? ವಿಷ್ಣುಮೂರ್ತಿ ವಿಷ್ಣುಮೂರ್ತಿ ಸೀರಿಯಲ್ ನಂಬರ್ 34. ಸೊ ನೋಡಿ ಅಷ್ಟೇ, ಯಾರು ಇಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರಿಲ್ಲ. ಆಯ್ತು. ಕೌನ್ಸಿಲ್ 6 time district matter on 24th of November.
46 ಮೇಲೆ
ಏನಾಗ್ತದೆ?
46 next
ಏನಾಗ್ತದೆ ಹೇಳ್ರಿ? ಎಲ್ಲಾ ಡೇಟ್ಸ್ ಕೊಡ್ತೀವಿ, ಮತ್ತೆ ನೀವು ಮೂವ್ ಮಾಡೋದ್ ಬೇಡ. ಮಧ್ಯಾಹ್ನ ಓನ್ಲಿ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಬಹಳ ಇದೆ.
46 any date next week.
ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅಂತಲೇ ಇವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಹಾಕೊಂಡ್ರು.
46 any date next week.
46 ಆಯ್ತು. ಯಾವ ಕೊಡ್ರಿ?
31.
Here 46,
2015, madam.
15, 24. Other side,
30.
Ms. Sriram idara,
Inform Martin.
applicant counsel 6 time and undertakes to inform other side. This matter on 24.
Real number.
31 date may be given. 31.
31 or 51?
31 blood.
31, ಯಾವ ಬೇಕು?
Next week any day blood.
Due to paucity of time, this matter on 24th.
Please.
Serial number 39.
Sir, ಹೇಳಿ inform ಮಾಡಿ ಮಹೇಶ್ ಉಪ್ಪಿನ್.
Please.
Serial number 39.
39.
ಹೌದು ಸ್ವಾಮಿ, ಅವರು ನನ್ಗೆ ಇದನ್ನ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ಯಾರು ಚಂದ್ರಶೇಖರ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಇರ್ಲಿಲ್ಲ ಅವರು. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನಾ ಲಾಸ್ಟ್ ಟೈಮ್ ಫರ್ನಿಶ್ ಮಾಡಿ ಹೇಳಿದೆ ನೋಡಿ, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಫರ್ನಿಶ್.
2 ಸತಿ ಆರ್ಡರ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಅಷ್ಟೇ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ this court directed to furnish the copy of the appeal memo to the respondent counsel. The counsel did not furnish the same. However, in the hands of justice, one more opportunity is given. This matter on 24th. If counsel doesn't appear and appear before the court and also not furnish the copy, appeal will be dismissed for non-prosecution. 30? ಯಾವ್ದ್ರಿ? 30. ಹೇಳಿ ಏನಾಗ್ಬೇಕು 30? ಅನಿಲ್ ಕುಮಾರ್, ಪ್ರಶಾಂತ್, ನೀವ್ಯಾರಿಗೆ?
ಅನಿಲ್ ಕುಮಾರ್.
ನೀವು ಅನಿಲ್ ಕುಮಾರ, ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ 6 time. ಪ್ರಶಾಂತ್ ಇದಾರಾ? ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟ್ ದಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದಿ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಆನ್ 24th. ನೆಕ್ಸ್ಟ್ 38 ಹೇಳಿ. ಅಡ್ಮಿಷನ್ ಕೌನ್ಸಿಲ್ 6 time. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 24th. 56 ಏನಾಗುತ್ತೆ ಹೇಳಿ. ಯುವರ್ ಪರ್ 230 230 ಇರ್ಬೇಕು ನೋಡಿ. 230 ಎಲ್ಲ ಇಲ್ಲ ರೀ, ಅದು 56 230 ಅಲ್ಲ, ಪ್ರಕಾಶ್ HC ಅಂತ ಇದೆಯಲ್ಲ ಅದು. ಯಾವ್ದು ಬೇಕು? ಮಂಡ್ಯ ಇಲ್ಲ, ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅದಕ್ಕೆ. 24th. Both the council present is this matter on 24th.
Serial number 44.
ಹೇಳಿ ಏನಾಗ್ಬೇಕು?
Next week 17th or
17. ನೀವ್ ಯಾರಿಗೆ ಮೇಡಮ್?
Respondents.
Respondent counsel 6 time. Serial number 44 madam. List this matter on 24th. Serial number 47. ಹೇಳಿ. Respondent is there. ನೀವ್ ಯಾರಿಗೆ? ಆಯ್ತು ಇದೀರಿ. ಮತ್ತೇನು ಆಗೋದಿಲ್ಲ ಅಂತ ಕೇಳಿದ್ರು. 24th. ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ 24th. Except 230 matters. ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ 24th. All matters are 24th only. All remaining. 24th. ಸುಮಾರು ಇದೆಯಲ್ಲ ಕ್ರಿಮಿನಲ್. ರಿಮೈನಿಂಗ್ ಡೇಟ್ಸ್ ಕೊಡ್ತೀರಿ. ಕ್ರಿಮಿನಲ್ ಮಾತ್ರ 230 ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್. ಅದು ಗುಲ್ಬರ್ಗ ಬೆಂಚು ಅಂಡ್ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಎರಡು ಇಟ್ಕೊಳ್ಳಿ. ಬಾಕಿದೆಲ್ಲ ಡೇಟ್ ಕೊಡಿ. ಮುಗ್ದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಲ್ಲ. 24th ಅಲ್ಲ.
ಏನಾಗಿರೋದು? 8 24. ನಾವು ಮಾಡಿಕೊಂಡಿದ್ದೀವಿ ಬೇಕಾದ್ರೆ
ಆಮೇಲೆ ನಮ್ಗೆ ಬರ್ತೀರ ಅಂತ ಹೇಳ್ಬೇಡ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾನೆ ಬೇಡ ನಮ್ಗೆ ಆಗ್ತದೆ ಅಂತ And I took that. Whatever. Serial number 72, madam. Permitted to withdraw, madam.
Serial number?
72, madam. Already moved, filed the memo, madam.
Good. Council has filed memo for withdrawal of the petition and hence permitted to withdraw in terms of the memo. Gulbarga bench. HCCP is directed to take notice and file objections if any. Is this matter on 10th of November. Mahantesh H. Desai. Mahantesh. Gulbarga bench. ಬರ್ತಾರಾ? Time ಆಗಿದೆ. So, petitioner counsel is absent. Next 10th ಹಾಕೋಣ. And hence this matter on 10th of November. Third. 57 third. Non-compliance for third time, huh? Petition Prabhu Swami. Petitioner counsel is absent and this matter is listed for third time. Hence urgent and cost of ₹500 payable at registry within 1 week. If cost not paid and office objections are not complied, list this matter on 10th of November. Manjunathacha. Same order, non-payable of payment. Cost payment ಮಾಡಿಲ್ಲ ಮೇಡಮ್? ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ? ತಗೊಳ್ಳಿ. ದಿಸ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ 4th ಟೈಮ್. ಮತ್ತೆ ಥರ್ಡ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಇದನ್ನ. 4th ಟೈಮ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಲ್ಲ ಅಲ್ವಾ? ಕಾಸ್ಟ್ ಹಾಕೋದೇ ನಾನು ಥರ್ಡ್ ಟೈಮ್ಗೆ ಹೌದಲ್ಲ? 4th ಟೈಮ್ ಇದು ಮತ್ತೆ 4th ಟೈಮ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಬೇಕು. ಆಯ್ತು. This matter is listed for 4th time for non-compliance of office objection and also non-payment of cost imposed by this court, and hence it appears the petitioner counsel is not interested in pursuing the matter, and hence petition is dismissed for non-prosecution for non-compliance and non-payment of cost impact. First time, Kemparaju Prasanna DP. HCCP is directed to take notice and file an objection 10th of November. 61. 16 are the same one. Prasanna DP.
For petitioner.
HCCP is directed to take notice and file objections if any. This matter on 10th of November. 61 HK Kenchegoda. In the report submitted by NDN reporter ಅದು ನೋಡಿದಿರಾ? Disciplinary action taken against Sunil Kumar M, an investigating officer of Bidikere Police Station in compliance of this order dated 8/6/22. ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ? ನಿಮ್ಗೆ ಏನಾದ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ? ಕೊಟ್ಟಿಲ್ಲ. PI ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಚಾಮರಾಜನಗರ ಜಿಲ್ಲೆ ಏನು ಬಿಡಿಕೆರೆ ಪೊಲೀಸ್ ಠಾಣೆ ಮೈಸೂರು ಜಿಲ್ಲೆ ಅವರು Four. The report of police superintendent of Mysore district is received and the same is placed on record. Muniyappa NOC, an office objection or objection ತಗೊಂಡಿಲ್ಲ ಅಂತ ಕಂಡಿದೆಯಲ್ಲ. Office note, Wakalat filed by Sri M. Sarath Chandra is returned with objections in way of NOC to be obtained from previous counsel Sri Muniyappa.
ಫೈಲ್ ಮಾಡಿಲ್ಲ ಸರ್, ಮುನಿಯಪ್ಪ ಅವರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿ.
ಯಾರು?
ಮುನಿಯಪ್ಪ.
ಹಾ.
So we checked the NOC from the earlier objector.
ಮುನಿಯಪ್ಪ ಫೈಲ್ ಮಾಡಿದ್ರಾ? Instead of Sri Sanjay BK.
ಹೌದು, ಅವರು ಹಾಕಿದ್ದು.
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರು?
ಸಂಜಯ್ BK ಒಬ್ಬರೇ
ಹಾಕಿದ್ರು. ಮತ್ ಮುನಿಯಪ್ಪ ಅಂತ ಯಾಕೆ ಆಫೀಸ್ ಅವ್ರು ನೋಟ್ ಮಾಡಿದ್ದಾರೆ? ಮುನಿಯಪ್ಪ ಇದಾರಲ್ಲ ಆನ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಮುನಿಯಪ್ಪ NOC ಇದೆಯಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ.
ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆ, ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಹಾಕಿದಾರಲ್ಲ.
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್.
ಇಲ್ಲೇ ವಕಾಲತ್ ಇದೆ ನೋಡಿ. ವಕಾಲತ್ ಇದೆ ನೋಡ್ರಿ ಇಲ್ಲೇ. ಮುನಿಯಪ್ಪ ಅಡ್ವೊಕೇಟ್. ಅವರು ಕೂಡ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಫ್ರಮ್ ಅಡ್ವೊಕೇಟ್ ಅಪಿಯರ್ DK ಸಂಜಯ್ ಅವರು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರು ಈ ಇಂಟರ್ನ್ಯಾಸ್ ಫೈಲ್ಡ್ ವಕಾಲತ್
ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆ.
12/9/2022 ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ರೀ. ಅದಕ್ಕೆ ಆಫೀಸ್ನವ್ರು ನೋಟ್ ಹಾಕಿದ್ದಾರೆ. That is also pending. Pending ಇರಲಿ, but let the record be clear ಅಲ್ಲ. Without NOC how you can represent? ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ. ತಗೊಳ್ಳಿ NOC ತಗೊಳ್ಳಿ ಅವ್ರಿಗೆ. ಮುನಿಯಪ್ಪ ಅವ್ರದ್ದು ಇದೆ, ಇಲ್ಲ ವಕಾಲತ್ ಇದೆ ರೀ. ವಕಾಲತ್ತಿಂದ ಆಫೀಸ್ನವ್ರು ಯಾಕೆ ನೋಟ್ ಮಾಡ್ತಾರೆ? ಟೈಮ್ ಬೇಕಾ NOC ತಗೊಳಕ್ಕೆ? ಅದೇ ಯಾವಾಗ ಎಷ್ಟು ದಿವಸ ಬೇಕು NOC ವಕಾಲತ್? NOC to be obtained from the very previous counsel Sri Muniyappa, since the name of the counsel Sri Muniyappa was deleted. Sanjay BK was deleted as per order dated 17/10/2022 ಇದೆ. ಅವರಿಂದ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ. ಈಗ ನೀವು ತಗೋಬೇಕು ನೀವು. Otherwise you have no locus standi. So counsel appearing for the counsel Sri M. Sarath Chandra seeks time to get the NOC from the previous counsel Sri Muniyappa and hence dismiss matter on 10th of November. ಏನ್ ಅದ್ರಲ್ಲೇನು ಆರ್ಡರ್ ಆಗಿಲ್ವಾ 482 ನಲ್ಲಿ? ಹೌದಾ? I was told that in some cases even though the accused are in custody, bails are granted ಅಂತ. ಅಲ್ಲ, ಇದು 482 stay granted ಅಂತ. Why you have not brought to the notice of the court? It shows the failure on the part of the state prosecution. I
don't know whether they stay in the case.
ಅಲ್ಲ ಇದ್ರಲ್ಲ ಹೇಳಿದ್ದು. I came to know in some cases.
Please.
Accused are in custody. Stay is granted.
That will be counterproductive. That will be adverse to the accused only. He will be inside only. He cannot even come out. His bail petition.
He cannot come out.
Oh, the bail petition cannot also be considered.
Passed in the court. I don't know. I don't.
One of my colleagues was saying there was a stay order, but his bail could not also be considered because session judge said I can't consider because there is a stay.
Things are going on like that.
Please.
I don't know whether the counsel not brought to the notice of the court or the inefficiency on the part of the state in bringing the setback to the court notice. Such orders are passed with knowledge or without knowledge. Right, next 63. 1 of 22 for modification of the order dated 11/7. ఏంటి అది modification? ಏನಂತ? ನೀವು ನಂಬರ್ ಆಗಿದೆ. ಈಗ ಮಾಡಿಫಿಕೇಶನ್ ಕೇಳಿದಾರೆ. ನೀವು ನಂಬರ್ ಈಗ ಸೇಮ್ ನಂಬರ್ ಒಂದು ಚೇಂಜ್ ಆಗಬೇಕು.
Police station and the crime number.
Earlier ಅದು ಇರ್ಲಿಲ್ವಾ?
Earlier ಬೇರೆ police station ಅಲ್ಲಿ ಇತ್ತು. After getting the anticipatory bail, the case was transferred.
It was transferred.
From
Malebennur police station to Basavapatnam police station.
Heard the appellate counsel and the petitioner counsel on IA 1/22 for modification of the order dated 11/7/22. And this court while considering 438 petition in crime number 58 of 22 of Malebennur police station granted bail, and now in the application it is stated that subsequently it was transferred to Yadu
Basavapatnam police station.
Basavapatnam police station in crime number
101/22.
101/22. And hence, in view of the changed circumstances, the same is modified as claim number 101/22 of Basavapatnam police. Howda?
Yes, sir.
And according to IA 1/22 is disposed of.
Please.
Mistake order LS. Santosh BY advocate for defect of complaint. Defect of Nima. Only you can assist us. Heard on IA 1 of. Ilri ನೀವೇನ್ ಹಾಕಿದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಆರ್ಡರ್ ಆಗಿದೆ ಆಗಿದೆ ಹೇಳಿ
Paper time. Senior counsel.
This case for clear is it came to be rejected on merit. Was the file
438 only. Angry maintain agutta.
Senior.
When this court comes to the conclusion that it is not a fit case for exercising the powers under section 438, whether you can file one more application?
Senior counsel.
This is the opinion of the court, this court that not entitled for 438, not a fit case for exercising powers under 438. Whether the court can again consider it?
No.
Nodi, in senior ಕೇಳ್ಕೊಳ್ಳಿ next time. Petitioner counsel seeks time. List this matter on 10th ಕೊಡಿ.
Next week.
10th ಆಗ್ಬೋದಾ ಅಥವಾ ಇನ್ನು ಲಾಂಗ್ ಡೇಟ್ ಬೇಕಾ?
10th ಆಗ್ಬೋದು.
10th ಆಯ್ತು.
Machu.
ಸತ್ಯನಾರಾಯಣ R.
Here for petitioner, my lord.
ಹೇಳಿ.
My lord, 1 week time may be given.
1 week time. Petitioner counsel seeks 1 week time. List this matter on 10th of November. Balakrishnan.
My lord, I am appearing for the petition. Lord, the page number 46. Earlier, he has approached this honorable court for bail. He is accused number 2. As far as his petition is concerned, it was withdrawn as dismissed.
Withdrawn as?
Dismissed.
Withdrawn as dismissed.
Dismissed. And accused number 1's petition on merit, it was rejected.
Rejected. One
By your lordship.
Now this is the second.
This second time, earlier it was not on merit.
Not on merit.
Not on.
Where is that earlier order?
46, my lord.
46 ಅಲ್ಲಿ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ನೋಡಿದೆ. ನೀವು ಪೇಜ್ ಒಂದು ಹೇಳ್ತೀರಿ, ಇಲ್ಲಿ ಪೇಜ್ ಬೇರೆ ಇರ್ತದೆ. 46 ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ ನೋಡಿ. ನೀವು ಹೇಳ್ತೀರಾ ಪೇಜ್, ನಿಮ್ ಕಡೆಯಿಂದ ಪೇಜ್ ನೋಡಿ ಇಲ್ಲಿದೆ.
8227.
ಬಾಲಕೃಷ್ಣನ್, you see here.
Annexure E, my lord.
Page number 40.
Please. Annexure E, my lord.
Annexure E ಇಂದ ನಾವೆಲ್ಲ ಹುಡುಕ್ಕೊತೀವಿ. ಆರ್ಡರ್ ಇದೆಯಾ? ನಮ್ದೇ ಆರ್ಡರ್ ಇದೆ, ಕೊಡಿ ಹೋಗಿ. ಇಲ್ವಾ? ಇದ ಬೇರೆದ? ಇದು ಬೇರೆಯವ್ರದ್ದು ರಿಜೆಕ್ಟೆಡ್. ಅತೀಕ್ ಪಾಷಾ is merits meant reject ಆಗಿರೋದಾ? Record disclosure incident was second class and evident in this connection, but there is Annexure E ಇಲ್ವೇ ಇಲ್ಲ. Annexure ABC ಬಿಟ್ರೆ ಬೇರೆ ಯಾವ annexure ಇಲ್ಲ. When the disease came along with GW18,
66
language questioning him that how they ಬೇರೆ ಕೊಟ್ಟಿದ್ದೀರಾ? When he went near the disease and accused number 2.
66, page number 46.
Page number 46.
Please, my lord. Annexure E.
46. Annexure E.
Please, my lord.
Annexure E ನ detail order ಆಗಿದೆ.
Also, as far as A1 is concerned.
A1. Where is the rejection of
A2?
A2 order copy ಎಲ್ಲಿದೆ?
ಅದೇ ಒಂದೇ petition ಹಾಕಿದ್ದು.
ಒಂದೇ petition.
Ahmad Khan A1, Ismail Khan A2. As far as Ahmad Khan is concerned, it was dismissed. Amjad Khan. Ismail Khan is concerned, it was not pressed.
Not pressed ಅಂತ ಇದೆಯಾ? ಆತರ ಇಲ್ವಲ್ಲ ಆ ರೀತಿ. ಎಲ್ಲೂ ಡಿಸ್ಮಿಸಲ್ ಇಲ್ವಲ್ರಿ? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿದೆ. merits ಮೇಲೆ ಆಗಿದೆ.
Observation is only para number 5 may kindly be perused.
ಹೌದು. ಅದು ಪ್ಯಾರಾ ನಂಬರ್ 5 ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಫ್ ದಿ ಸ್ಟೇಟ್.
ಅದೇ ಅದರಲ್ಲಿ but the observation is only on A1.
No, that is.
Para number 6 having heard the respective counsel.
Having heard the respective counsel and also on perusal documents and record, it is clear that case of prosecution is that deceased was having illicit relationship with the wife of petitioner number 1.
Please.
And hence he conspired with accused number 2 and 3 to committed the murder of the deceased. It is not in dispute that petitioner number 1 and accused number 3 are the direct brothers. It is important to note that the body was recovered at the instance of accused number 2. According to you, accused number 2.
Please. Page number 6.
3 after the lapse of 8 days of the alleged incident.
Yes.
And the body was buried under the earth. And also the statements of witnesses, that is last seen witnesses, have been recorded after the lapse of 45 days of the discovery of the body. That cannot be a ground to disbelieve the case of the prosecution at this stage, and the same has to be tested in trial. The allegation against petitioner number 1 is that he was having a motive to get rid of the deceased since he was having illicit relationship with his wife.
A1.
Apart from that, accused number 3 is the direct brother of accused number 1. And CDR report discloses that on the date of the accident, phone calls are made among accused number 1 to 3. And the same was substantiated with regard to the conspiracies concerned, and the same has to be proved only during the trial. When such being the materials available on record, body was also discovered at the instance of accused number 2 and 3, and not at the instance of petition number 1. Cannot be accepted as petition number 1 is the main architect of to get rid of the deceased. ನಿಮ್ಮಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ merit ಮೇಲೆ ನೀವೇ ಬಾಡಿ ತೋರಿಸಿರೋದು.
Yes. Earlier there is no observation on A2.
Apart from that, even CDR reports also goes against you. CDR report.
Other CDR.
Accused number 3. For 3 also rejected. Coordinate bench. Similar, 2 against 2 and against 3 also are the same.
This petitioner may not no motive. 7 days delay in registering the FIR.
No.
The only material is
Only after
CDR.
the recovery of the body.
CDR.
Body is also
7 days may not.
exhumed at the instance of the petitioner only. Body ಎಲ್ಲ ಹೂತಿಟ್ಟಿರ್ತಾರೆ. ರಿಕವರಿ ಆಗಿರೋ ನಿಮ್ಮವನ್ ಮೂಲಕ. ನಿಮ್ಮವನ್ ಮರ್ಡರ್ ಮಾಡಕ್ ಸೇರ್ಕೊಂಡಲ್ಲ ಹೂತಿದ್ ಬಾಡಿ ಹೆಂಗ್ ಸಿಗುತ್ತ್ರಿ?
That has to be decided at the time of the trial.
ಹೇಳಿರೋದು.
There are 7 days delay in registering the
That is
FIR.
not a ground.
At CDR, there are so many other numbers.
In detail discussed, similarly placed accused number 3 is also rejected by the
And
coordinate
I'll leave it to your lordship.
bench.
So earlier I made a submission to withdraw.
Withdraw ಆಗಿಲ್ಲ. Merits ಮೇಲೆ ಆಗಿದೆ.
I made a submission. Your lordship observed on accused number 1.
Why you read this order and you made submission that the earlier one.
This order may not observation is against A1.
Not only A1.
No, while perusing the entire record, I appeared before your lordship. I said I may be permitted to withdraw.
Merits
So
ಮೇಲೆ
I need not to make.
ಕೃಷ್ಣ ನೀವೇ ಮಾಡಿರೋದು.
ಹೌದು ಸ್ವಾಮಿ ನಾನೇ ಮಾಡಿ. I made submission to withdraw the petition.
ಆತರ ಇದ್ರೆ ಆಗಿರ್ತಿತ್ತಲ್ಲ ಇಲ್ವಲ್ಲ.
But observation is only against.
ಆರ್ಡರ್ ಆಗಿದೆ.
A2 I made a submission, I may be permitted.
ಇಲ್ಲ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಬರ್ದಿರಿ ನೋಡಿ. Submit that deceased was missing from 9.
ಹೌದು.
Which wife deceased had lodged a missing complaint on 9th and only on the arrest of accused number 2 and 3 FIR was registered for the offence present 302 of IPC, and petitioner number 1 was arrested on so and so.
ಇಲ್ಲ ಅದೆಲ್ಲ observation ಆಗಿದೆ ಓದ್ದೆ ಸ್ವಾಮಿ. Finally A1 ಮೇಲೆ ಅಬ್ಸರ್ವ್ ಆಗಿದೆ. That's what I appeared before your lordship. I only appeared. I made submission.
And also the counsel appearing for the state. This is a successive bail petition filed by the counsel appearing for the accused number 2. And counsel would submit that earlier not passed an order on merits against this petitioner. The same submission cannot be accepted this court while considering the bail petition of this petitioner and also the other accused. In paragraph number 6, made it discussed in detail that that it is important to note that the body was recovered at the instance of accused number 2 and 3 after the lapse of 8 days of the alleged incident, and the body was buried under the earth. And also the statement of witnesses, that is last seen witnesses, have been recorded after lapse of 45 days of the discovery of the body. And also given the reason that same cannot be a ground to disbelieve the case of the prosecution at this stage, and the same has to be tested in trial. This court considered the petition of this petitioner and merits. And also this court observed that when the body was discovered at the instance of this petitioner and also accused number 3, not a case for granting bail. And apart from that, the counsel appearing for the state also brought the notice of this court that the other accused, accused number 3, who is placed similarly, also approached this court by filing criminal petition number 7682 of 2022, and this court rejected this bail petition on 14th of September 2022. And when searching the material and record, not a case for entertain the successive bail petition on behalf of this petitioner. Hence, bail petition is rejected.
May I approach after examination of CW1.
CW1 ಅಂತ ಬರೋದಿಲ್ಲ. Already ಮಾಡಿದ್ವಿ.
Expedition ಅಂತ ಬಂದಿದೆ ಸರ್.
ಆಯ್ತು,
Time
ಆಗಿದೆ.
frame ಆಗಿದೆ.
ಆಯ್ತು, ಮತ್ತೆ ಬಂದಾಗೆಲ್ಲ ಒಂದೊಂದು ಆರ್ಡರ್ ಬರೆಯಕ್ಕಲ್ಲ.
ಆಯ್ತು.
Tarjani Desai.
Earlier occasion, Islamapur passed an order. Is there a liberty to the petitioner to file the approach this order after filing charge sheet? Now the charge sheet has been filed on 21/5/2022.
Without petition approach this court after filing of the charge sheet.
Yes.
ಆಯ್ತು. Then what is?
Lord, he was arrested on 26/3/2022. He is in custody.
Custody from
26/3/2022.
22. Offense.
Offense 307, 506.
307.
307 is it.
Button knife and also the dragger. ಹೇಳಿ. Nine cases. ಏನ್ offenses ಏನು? 9 cases and offenses. Not the number, offenses. What are the offenses? 457, 380, 342, 354, 384, 292, 323, 399, 402, 394, 307, 504, 395. ಏನ್ರಿ ಇದು 394, 395 ಬರೀ ಇದೆ. ಬರೀ ಇದೆ offenses.
But he is a driver by profession.
ಡ್ರೈವರ್ ಜೊತೆಗೆ ಇದು ಒಂದಲ್ಲ, ಎಲ್ಲ ದೊಡ್ಡಬಳ್ಳಾಪುರ ನಗರನೇ. ಗ್ರಾಮಾಂತರ
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಮೊದಲೇ
ಸಿಟಿ ಅಲ್ಲೇನೆ. ಎಲ್ಲಿ ಡ್ರೈವರ್ ಏನ್ ಡ್ರೈವರ್?
He is in Bangalore. What he gives the statement before the police. He is doing the driver job and he is livelihood. Unfortunately on
ಆಯ್ತು, ಇಂಜುರಿ ಏನ್ ಕಾಸ್ ಮಾಡಿದಾನೆ ಹೇಳ್ರಿ.
ಸ್ಟಾಬ್ ಇಂಜುರಿ ಅಂತ ಕೈಗಿದೆ.
ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ ಬಂದ್ರೆ ಅಟ್ಯಾಕ್ ಮಾಡೋದು.
ಇದೆಲ್ಲ ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ಕಲ್ಲ, ಅಲ್ಲಿ ಫುಡ್ ಕೇಳಿದಾರೆ, ಫುಡ್ ಕೊಟ್ಟಿಲ್ಲ.
ಇವೆಲ್ಲ ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ ಹೋದ್ರೆ ಅವ್ರ ಮೇಲೆ ಅಟ್ಯಾಕ್ ಮಾಡೋದು. 511 to 711 date of discharge, alleged history of assault by unknown persons on 511/2001 at airport, multiple stab injury on left hand, chest ಕೊಡ್ದವ್ ನೋಡ್ರಿ, chest wall, chest wall,
ಎರಡ್ ಕಡೆ ಇಂಜುರೀಸ್ ಇದೆ.
and anterior wall, multiple cut lacerated wound on left hand, anterior part of chest and other injuries are grievous in nature. ಹೇಳಿ. ಅಟ್ಯಾಕ್ ಮಾಡಕ್ ಹೋದ, ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ ಹೋದ್ರೆ ಅವ್ರ ಮೇಲೆ ಸ್ಟಾಪ್ ಮಾಡಿ. Then why we have to exercise discretion in his favor?
So far as that is concerned, the only charge sheet is the two eyewitnesses. So they said that the injured is that the person who gives the complaint on 6/11/2022. The next day, police recorded the statement. And they wanted to implicate him.
CW2 and 3.
Yeah. And
injured witnesses.
The police wanted to say that when he was in jail, he met one Mr. Salim, and these people, the witnesses were this victim was with the Salim, and she has actually developed rivalry.
9 ಕೇಸ್ ಇದಾವೆ ಜೊತೆಗೆ ಕಾಸ್ಡ್. ಇವನು ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟು?
ಒಂದು 4 accused-ಗೆ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಕೊಟ್ಟು.
ಮೋಸ್ಟ್ಲಿ ಬೇರೆ ಕೇಸಸ್ ಇಲ್ಲ. ನೋಂದಣಿ ಸಂಖ್ಯೆ ಹೋಂಡಾ ಆಕ್ಟಿವಾ ದ್ವಿಚಕ್ರವನ್ನು ತೆಗೆದುಕೊಂಡು A1 ಆರೋಪಿಯು ತನ್ನೊಂದಿಗೆ 2 ಮತ್ತು ಎಲ್ಲ ಕಾನೂನು ಸಂಘರ್ಷಕ್ಕೆ ಒಳಗಾದ ಹುಡುಗರು ಕರ್ಕೊಂಡು ಹೋಗುದು. ಹೋಟೆಲ್ ಬರಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಸಾಕ್ಷಿ ಒಂದೂರವರನ್ನು ಕುರಿತು ಊಟ ಕೊಡು ಎಂದು ಕೇಳಿದ್ದು, ಸಾಕ್ಷಿ ಒಂದೂರವರು ಊಟ ಖಾಲಿಯಾಗಿದೆ ಎಂದು ಹೇಳಿದ್ದಕ್ಕೆ A1 ಆರೋಪಿ ನಾನು ಯಾರು ಅಂತ ಗೊತ್ತೇನೋ, ನನಗೆ ಊಟ ಇಲ್ಲ ಅಂತೀಯ ಎಂದು ಹೇಳಿ ತನ್ನ ಬಳಿ ಇಟ್ಟುಕೊಂಡಿದ್ದ. ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಬಂದಿತ್ತಲ್ಲ, ವೈ ಇಟ್ ವಾಸ್ ಅರ್ಜೆಂಟ್ ಲಾಸ್ಟ್ ಅಕೇಶನ್?
ಲಾಸ್ಟ್ ಟೈಮ್ ಫಸ್ಟ್ ಟೈಮ್ ಅಂತ ಬಂದಿದ್ದು ಅಬ್ಜೆಕ್ಷನ್.
ಹೌದಾ, ಓದಿ ಆದ್ಮೇಲೆ ಇದಾಯ್ತಾ? ನಂಗೆ ರಿಮೆಂಬರ್ ದಿಸ್. ಊಟ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಹೊಡೆದಿದ್ದು.
ಅದು ತಾವು ಮೊದಲು ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಮಾಡಿದ್ದೀನಿ.
ಹೊಟ್ಟೆಗೆ ತಿವಿದು ನಂತರ ಬಾಜಿದ್ ಕಡೆ ಇದ್ದ ಇನ್ನೊಂದು ಬಟನ್ ಚಾಕುವನ್ನು ತೆಗೆದುಕೊಂಡು ಮತ್ತೆ ಸಾಕ್ಷಿ ಒಂದೂರವರ ಎದೆಗೆ ತಿವಿದು ಕೊಲೆ ಮಾಡಲು ಯತ್ನಿಸಿ ನಿನ್ನನ್ನು ಇವತ್ತು ಜೀವಂತವಾಗಿ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿ ಸಾಕ್ಷಿ ಒಂದೂರವರ ತೀವ್ರ ರಕ್ತಗಾಯ ಉಂಟು ಮಾಡುತ್ತದೆ. 2 ಮತ್ತು 3 ಕಾಣಿಸಿಕೊಂಡು ಹೋಗ್ತಾರೆ. 1ನೇ ಆರೋಪಿ ಕೃತ್ಯ ಸಾಗಲು ಎಸಗಿರುತ್ತಾರೆ ಅಂತ. 1, 2 ಬರೀ ಓನ್ಲಿ ಅಸಿಸ್ಟೆಡ್ ಅಂತ ಅಷ್ಟೇ. ಬಟ್ ಇನ್ಫ್ಲಿಕ್ಟೆಡ್ ಇಂಜುರಿ ಬೈ ದಿಸ್ ಪಿಟಿಷನರ್ ಓನ್ಲಿ.
ತಾವು 9/6/2022 ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾಗ ಪ್ರಾಬ್ಲಿ ವಾಟ್ಸ್ಆಪ್ ಹ್ಯಾಸ್ ಅಬ್ಸರ್ವ್ಡ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ ತಕ್ಷಣ ಬನ್ನಿ ತಕ್ಷಣ ಕೊಡ್ತೀವಿ ಅಂತಲ್ಲ,
ಚಾರ್ಜ್ ಶೀಟ್ ರಿಸರ್ವ್ ಲಿಬರ್ಟಿ ಅಂತ ಇವಾಗ ಫೈಲ್ ದಿ ಪಿಟಿಷನ್
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ ಬರ್ಲಿ ಅಂತ. ಬಟ್ ಇಲ್ಲಿ ಇಂಜೂರ್ಡ್ ಇದಾರೆ, ವಿಟ್ನೆಸಸ್ ಇದೆ, ಅವನೇ ಇಂಜೂರ್ಡ್. There are 2 injured. ಅದು just
injured is one.
Just wall ಕೊಡ್ದವ್ರೆ.
ಚಂದ್ರಶೇಖರ್ ಅಂತ ಹೇಳಿ.
CW2.
But so far as there are 2 eyewitnesses, they have seen the occurrence.
Chandrasekhar is PW1.
Chandrasekhar is the injured.
ಅದು injured CW1. ಅವನ eyewitness ಇಬ್ರು ಇದ್ದಾರೆ, CW2 and 3.
ಇಬ್ರು ಇದ್ದಾರೆ. ಅವರು they are also running the hotel just in front of the hotel.
Certificate ನೋಡುವಾಗ injuries on the chest. Wall of the chest.
Serious injuries ಏನಿಲ್ಲ, but he is away from this knee.
Heard the petitioner counsel and also the counsel appearing for the state. This petitioner earlier approached this court during the crime state for bail, and this court, while dismissing the bail petition, given the liberty to the petitioner to approach this court after the filing of the charge sheet. Now charge sheet is filed and counsel appearing for the petitioner would submit that the injured is out of danger and investigation has already been completed. No need of custodial trial and he may be enlarged on bail. Per contrary, the counsel appearing for the state would submit that this petitioner is a rowdy seater and there are 9 cases against him. And all the cases are pertaining to committing of the robbery and dacoity. And in this case also, he inflicted injury with button knife, that too on the vital part of the chest. And mere filing of charge sheet is not a ground to enlarge him on bail. Having heard the respective counsel and also on perusal of material. ಇದ್ಯಾವುದು ಸುಮಾರು ದೊಡ್ಡಬಳ್ಳಾಪುರ ಬೇರೆ ಬೇರೆ ಕಡೆ ಎಲ್ಲ ಇದಾವಲ್ರಿ ಇವು? ಸುಮಾರು ಕೇಸ್ ಏನಾಯ್ತು?
ಸುಮಾರು 31 ಕೇಸ್ ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇವನ್ ಮೇಲೆನೆ
31
ಕೇಸ್ ಇದಾವೆ.
31 ಕೇಸ್ ಅಂತ ಹೇಳಿ ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
ನೋಡಿ ಇದ್ರಲ್ಲಿ ಎಷ್ಟಿದಾವೆ ಅಂದ್ರೆ
ದೊಡ್ಡಬಳ್ಳಾಪುರದ ಪೊಲೀಸ್
ದೊಡ್ಡಬಳ್ಳಾಪುರದಲ್ಲಿ 6,
ಬೆಂಗಳೂರು ಬೇರೆ ಇದ್ದಾರೆ,
ಟೌನ್ ಅಲ್ಲಿ ಅದನ್ನೆಲ್ಲ 3, ಆಮೇಲೆ 1, ಬಸವೇಶ್ವರ ನಗರದಲ್ಲಿ
ಎಲ್ಲ ಕೂಡ ಆಲ್ಮೋಸ್ಟ್ ತೀರ್ಮಾನ ಆಗಿದೆ.
ಕಾಮಾಕ್ಷಿಪಾಳ್ಯ 1, ರಾಜಗೋಪಾಲ್ ನಗರ 3
ಅವ್ರು ಕೊಟ್ಟಿರೋದು. That is before the district court.
ಅದರದ್ದೇ ಕಾಪಿ ಹಾಕಿರೋದು.
ಅದು ಕಾಪಿ ನಾನು ಹಾಕಿದ್ದೀನಿ because they opposed the bail and sought for remand. Material
available on record. The police have investigated the matter and filed the charge sheet. The injured is a complainant and his statement is also recorded. And apart from that, CW2 and 3 are the eyewitnesses who have witnessed the incident of inflicting the injury. The wound certificate also discloses that the injuries are grievous in nature and particularly he inflicted injury with button knife on his chest wall and he had sustained grievous injuries. And also the details furnished by the prosecution discloses number of cases, not only 9 cases as submitted by the counsel appearing for the state, and in the remand application placed before the Dodballapur court discloses number of cases registered not only on Dodballapur town and rural, And even in Rajan Kunte, Basveshwar Nagara, in total 6 cases, and Kamakshipalli and Rajgopal Nagara, several cases are registered against him. When such being the material on record, when in the present case on hand, also the injured victim also made the statement and identified him, and apart from that, 2 eyewitnesses have also witnessed the incident. And also record discloses that when the victims register the act of the petitioner, at that juncture, he used to inflict injury with button knife. And in the case on hand also, he inflicted injury with button knife on the vital part of the victim CW1. And when such being the material on record, it is not a fit case to exercise the discretion in favor of the petitioner. Bail petition is rejected. Approach Pasha. Yes, counsel. Where is the earlier order? However, in ends of justice, also made it clear that dismissed for non-prosecution. So ahead. Next, accused number SP.
Sole accused.
Sole accused. Offense and 302, 201.
302. Complete page number 12, man. Complaint at page number 12, man.
Page number 12. Charge sheet agide ನೋಡಿ.
Charge sheet.
Page number 31 go.
ಕಾಲಂ ನಂಬರ್ 3ರಲ್ಲಿ ಕಂಡು ಬಂದಿರುವ ಆರೋಪಿ ಸಾಕ್ಷಿ 13ರ ಮಗನಾದ ಹನುಮಂತೇಶ್ ಗೌಡ ಕೆವಿ.
ಕೆಳಗೆ ಬಂದ್ಬಿಡಿ 6 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದು ಹನುಮೇಶ್ ಗೌಡ ವ್ಯಾಪಾರ ಕೈ ಹಣವನ್ನು ಸಾಲವಾಗಿ ಕೊಟ್ಟಿದ್ದು ಅದು ಬಡ್ಡಿ ಸೇರಿ ಒಟ್ಟಾರೆ 6,61,000 ಆಗಿದ್ದು ಹಣಕಾಸು ವಿಚಾರದಲ್ಲಿ ಇಬ್ಬರು ಜಗಳ ಮಾಡ್ಕೊಂಡಿದ್ದು ಈ ವಿಚಾರ ದಿನಾಂಕ 11 ರಮೇಶ್ ಗೌಡ ಸಾಕ್ಷಿ 15ರನ್ನು ಕುಮಾರ ಅವರ ವಿರುದ್ಧ ವಿಜಯನಗರ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟಿದ್ದು ಈ ಸಂಬಂಧ ರಮೇಶ್ ಗೌಡ ಸಾಕ್ಷಿ 14 ಕೊಡಬೇಕಾದ ಹಣದ ಪೈಕಿ 5 ಲಕ್ಷ ಹಣವನ್ನು ಆರೋಪಿಯವರನ್ನು ಕೊಡುವಂತೆ ತೀರ್ಮಾನಿಸಿಕೊಂಡಿದ್ದು ಅದನ್ನು ಸಾಕ್ಷಿ 15 ಕುಮಾರ್ನಿಂದಾಗಲಿ ಮೃತ ಹನುಮೇಶ್ಗೌಡರಿಂದಾಗಲಿ ಆರೋಪಿಗೆ ಹಣ ವಾಪಸ್ ಬಾರದ ಕಾರಣದಿಂದ ಈ ಹಣಕಾಸು ವ್ಯವಹಾರದಲ್ಲಿ ಆರೋಪಿ ಮೃತ ಸಂದೇಶಗಳು ಮೈಸೂರು ಉಂಟಾಗಿದ್ದು ಬೇಕಾದ ಮಾಡಿ ಅನ್ವೇಷಣೆ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶ ಹೊಂದಿದ್ದು ಅದರಲ್ಲಿ ಆರೋಪಿ ಹೊಸವಾದ ಬಟನ್ ಶಾಕ್ ಹೊಂದಿಸಿಕೊಂಡು 6/7/70 ಮಧ್ಯಾಹ್ನ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಅನ್ವೇಷಣೆ ನಡೆಸಿದ ವಿಜಯನಗರ ರಾಣಾ ವ್ಯಾಪ್ತಿ ವಿಜಯನಗರ 9ನೇ ಮೈಲಿನಲ್ಲಿ ಸಾಕ್ಷಿ 16ರವರೆಗೆ ಸೇರಿದ ಕಟ್ಟಡ ಸಂಖ್ಯೆ 7 ಎಂಟರ್ಪ್ರೈಸಸ್ ಕೇಳುವ ನೆಪದಲ್ಲಿ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಸಾಕ್ಷಿ 2ರವರ ಸಮಕ್ಷಮವಾಗಿ ಹಣಕಾಸು ವಿಚಾರದಲ್ಲಿ ಮಾತನಾಡಿ ಜಗಳ ಮಾಡಿಕೊಂಡು ಕಚೇರಿಯಿಂದ ಹೊರಗಡೆ ಹೋದ ನಂತರ ಅನ್ವೇಷಣೆಗಳನ್ನು ಒಬ್ಬನೇ ಇರುವ ಸಮಯದಲ್ಲಿ ಈತನನ್ನು ಆರೋಗ್ಯ ವ್ಯವಸ್ಥೆಯನ್ನು ಬೈದಾಡಿಕೊಂಡು ತನ್ನಲ್ಲಿದ್ದ ಬಟನ್ ಶಾಕಿನ ರಮೇಶ್ ಕುತ್ತಿಗೆ ಎದೆ ಪಕ್ಕೆ ರೂಪಾಯಿಗಳ ಕೊಲೆಗೈದಿರುತ್ತಾನೆ.
My lord, the entire case is based on the circumstantial evidence, my lord.
No.
Only on this.
CW2 is the eyewitness. Ganesha.
My lord, he just last seen the accused with the victim, with the deceased, my lord.
ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ ಅಂತಿದೆ ನೋಡಿ. ಆಯ್ತು ಹೇಳಿ.
My lord, the accused has been arrested just because there was a transaction between the deceased and the accused, my lord. Only on that basis.
Not because of just murder. Murder was for arrest matter, not because of financial transaction.
My lord, there's no eyewitness to the entire incident.
ಆಯ್ತು ಆಮೇಲೆ
Further, my lord,
other grounds.
my lord, the lower court, while rejecting the order, or erroneously mentioned that they were based on the statement of the co-accused statement, the accused has been considered, my lord, at page number 22, my lord.
ಅದೆಲ್ಲ ಬೇಡ, ನಾನೇನು ಐ ಆಮ್ ನಾಟ್ ಸಿಟ್ಟಿಂಗ್ ಆನ್ ಅಪೀಲ್. ಯು ಮೇಕ್ ಔಟ್ ಎ ಕೇಸ್ on
My
your
lord,
own grounds.
My lord, there's no eyewitness. That is the main ground, my lord.
that
It
is
is
the only ground.
circumstantial evidence, my lord.
That is the only ground. Then you go to the statement of CW2. Where is the statement? Have you produced it or not?
My lord,
Why you have not produced the entire charge sheet? After filing up charge sheet? Why? FSL report. Knife. Recovery is from the accused only.
Also, the state law of accused.
Detected.
The PM report, PM is the part of the report.
Victim. How many injuries?
10 injuries are there.
ಎಲ್ಲ ಸ್ಟೈನ್ಡ್ ಅಲ್ರಿ ನಿಮ್ಮ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಬ್ಲಡ್ ಸ್ಟೈನ್ಡ್ ಎಲ್ಲ ಸ್ಟೈನ್ಡ್ ವಾಟ್ ಎವರ್ ದಿ ಸೀಸರ್ ಅಟ್ ಯುವರ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಲ್ ಆರ್ ಬ್ಲಡ್ ಸ್ಟೈನ್ಡ್ ಕ್ಲಾತ್ as well as knife which was seized at the instance of your client. Okay, so
my lord, I'm in judicial custody from last 2.5 years, my lord.
2.5 years.
2.5 years. my lord.
ಜೀವ ತೆಗ್ದಿದ್ರಲ್ಲ ಅದು ಜೀವ ಹೋಗಿದೆಯಲ್ರಿ ಅವ್ನು?
circumstantial evidence, my lord.
Circumstantial
Case of
evidence
trial, my
ನೋಡಿ.
lord. There's no direct
Circumstantial
witness, my lord.
and
There's no
direct
chain
evidence.
witness, chain witnesses also, my lord. There's no lasting theory, my lord. ಜೊತೆಗೆ ನೋಡಿದ ಅಂತ ಹೇಳ್ತಾ ಅಷ್ಟೇ, my lord, CW1. And
ರಿಕವರಿ ಆಗಿದೆಯಲ್ರಿ, ನೈಫ್ ನಿಮ್ ಕಡೆ ಆಗಿದೆ, ಅದ್ರಲ್ಲಿ ಬ್ಲಡ್ ಇದೆ,
Yes, my lord.
ಡಿಸೀಸ್ ಬ್ಲಡ್
Recovery
ಇದೆ,
ಇದೆ.
ನಿಮ್ ಬಟ್ಟೆನಲ್ಲಿ ಡಿಸೀಸ್ ಬ್ಲಡ್ ಇದೆ, ಇನ್ನೇನ್ ಬೇಕು?
and even, my lord, complainant is the employee of the deceased, my lord.
Whoever it may be counsel,
Favorable
whoever
statement,
it may be
my lord.
counsel, whatever may be the transaction between them, what right you have given to you to take the life of a person? ಈಗ ಬಂದು 2 ವರ್ಷದಿಂದ ಜೈಲಲ್ಲಿ ಅವನೇ, 3 ವರ್ಷದಿಂದ ಜೈಲಲ್ಲಿ ಅವನೇ ಅಂತ ಹೇಳ್ತೀರಿ ನೀವ್ ಇಲ್ಲಿ. ಅವನ್ ಲೈಫ್ ಅಲ್ವಾ? ಅವ್ನು ನನ್ನ ಪ್ರಪಂಚ ಎಲ್ಲ ಇಲ್ದಂಗ್ ಮಾಡಿದೀವಲ್ಲ. ಮತ್ತೆ ಹಂಗೆ ನೀವು ನಾನ್ ಜೈಲಲ್ಲಿ, ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ ಜೈಲಲ್ಲಿ ಇರಕ್ಕಾರು ಎಲ್ಲ ಬೇಸಾಕಿ ತಿನ್ನಕ್ ಅವಕಾಶ
My
ಮಾಡ್ಕೊಡ್ಲ.
lord, but
ಮತ್ತೆ
case is on circumstantial evidence, my lord.
I told let the matter be tried. That's all. You think it over the life of a person, victim. ಎಲ್ಲ ಬರೀ ನೀವು ಅಕ್ಯೂಸ್ಡ್ ಜೈಲಲ್ಲಿ ಅವನೇ ಅದು ಇದು ಹೇಳ್ತೀರಿ. ಟೇಕಿಂಗ್ ಆಫ್ ಎ ಲೈಫ್ ಆಫ್ ಎ ಪರ್ಸನ್ ಅಲ್ವಾ? Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution that there was a financial transaction between the victim and the accused, and due to the said motive committed the murder of the victim, and the same is witnessed by CW2 and CW1 and 2 who have left the place after this scuffle between this petitioner and the victim. This petitioner went inside with a knife and inflicted injury and caused the death. It is also case of the prosecution that recovery is made at the instance of this petitioner. That is a weapon which was used for committing the murder and also the bloodstains cloth. And FSL report also confirms the bloodstains both in the knife as well as in the cloth of the accused. The counsel appearing for the petitioner will submit that case is based upon the circumstantial evidence and no eyewitnesses to the incident. And though the prosecution relies upon the statement of CW2 as eyewitness, he was not present, only he came to spot after the incident. And hence matter has to be tried and no need of custodial trial. For account of the counsel appearing for the respondent that the CW2 is the eyewitness to the incident, and apart from that, recovery is also made at the instance of this petitioner, and the same is proved that both knife as well as the cloths of the petitioner was stained with blood of the deceased. And hence, there is a prima facie case, having heard the respective counsel and also on perusal of material. And also a material discloses that there was a financial transaction between the accused and also the complainant. And having motive to get rid of the deceased, he consequently inflicted injury with knife. The main contention of the petitioner counsel that there are no eyewitnesses to the incident, and prosecution relies upon the statement of CW2 as eyewitness. And apart from that, the PM report discloses that the cause of death is on account of multiple injuries, of stab wound injuries. And knife which was recovered at the instance of petitioner was also stained with blood, and also the cloths which were seized at the instance of the petitioner were also stained with blood, and FSM report also confirms the same. When settling the case, there is a prima facie case against the petitioner hearing, and hence it is not a quick case to exercise the discretion in favor of the petitioner. The other contention of the petitioner counsel that he is in custody for the last 2.5 years, and the same cannot be a ground in a case of heinous offense of taking the life of a person. Merely he is in custody from last 2.5 years is not a ground, and hence the petitioner has not made out any case.
Direction
on bail.
case in the charge ಆಗಿಲ್ಲ madam. Case in the charge ಆಗಿಲ್ಲ.
Charge sheet ಯಾವಾಗ ಹಾಕಿರೋದು?
But charge
sheet ಹಾಕಿರೋದು ಯಾವಾಗ? This juncture 7/7/2020 ವರ್ತಮಾನ ದೋಷಾರೋಪಣ ಸಂಖ್ಯೆ 9/9/2020.
Yes, madam.
At this juncture, the council would submit that the charge has not yet framed. And accused is only a sole accused, Allah? Sole accused. And hence, this court can direct the trial court to frame the charge and dispose of the matter expeditiously. In view of the discussions made up, I pass the following order. Bail petition is rejected. The trial court is directed to frame the charge and proceed with the matter and dispose of the same.
No observation cannot. High court observation they cannot.
Then High Court
Based on the merits that to decide.
then ಬರೋದಿಲ್ಲ ಬಿಡಿ, ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಏನಾಯ್ತು ಹೇಳಿ? ಅದಕ್ಕೋಸ್ಕರ ಟ್ರಯಲ್ ಮಾಡೋದು. And dispose the matter as soon as possible. ಆಯ್ತಾ? ಆಯ್ತು, ಅದು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅಷ್ಟೇ. The trial court should not influence with the observation made by this court while passing the bail order. Petitioner by the. Yes, counsel.
Yes, madam. Clear order was, you have to reject it. Without given verdict after examination of victim and doctor.
Victim and doctor.
Examine doctor.
Doctor ಆಗಿಲ್ವಾ? After the examination of the victim as well as the doctor ಅಂತಿದೆ. ಡಾಕ್ಟರ್ ಯಾವಾಗ ಆಗಿದೆ? ಇದು ಹಾಕಿದೀರಾ ದಾಖಲೆ? ರಿಪೋರ್ಷನ್ ಕಾಪಿ ಹಾಕಿದೀರಾ? ವಿಕ್ಟಿಮ್ ಸಪೋರ್ಟ್ ಮಾಡಿದಾರೆ ಇಲ್ಲ ಅದರ ಎವಿಡೆನ್ಸ್ ಹಾಕಿದೀರಾ ಕಾಪಿ? ಏನು ಹಾಕಿಲ್ವಲ್ರಿ? ಏನೋ ಹಾಕಿಲ್ವಲ್ಲ? ಹಾಕಿ ನೋಡೋಣ ಆಗಿದೆ. Counsel submits that the doctor is also examined. And counsel appearing for the state would submit that doctor has not been examined.
One week
ಟೈಮ್ ಕೊಡ್ತೀನ್ರಿ, ಎಕ್ಸಾಮಿನ್ ಆಗಿದೆ ಇಲ್ಲ ಡಾಕ್ಟರ್? ನಿಮಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಗೊತ್ತಿದ್ರೆ ಹೇಳಿ. ಆಗಿದೆ, ಆಯ್ತು ಹೇಳಿ. And hence the counsel is directed to place the deposition copy of the petitioner or victim and also the doctor. This matter on 10th. 10th ಆಗ್ಬೋದಾ?
ಆಯ್ತು ಸರ್.
ಪ್ರಕಾಶ ಎಂ.
For the petition, earlier my lord 430
ಈಗ 438 ಮೊದಲು 439 ಅದಂಗೆ
ಅದರಲ್ಲಿ ಬಾಡಿ ವಾರಂಟಿ ಮಾಡಿ 8/6/2022 ಮೇಲೆ ರಿಲೀಸ್ ಆನ್ ಬೇಲ್ ಈ ಒರಿಜಿನಲ್ ಕೇಸ್.
ಹಂಗೇನು ಅರ್ಥ ಆಗ್ತಿಲ್ಲ.
ಅಲ್ಲ, ಒರಿಜಿನಲ್ ಕೇಸ್ ಬಿಡುಗಡೆ ಆಗ್ತದೆ 8/6/2022 ಮೇಲೆ.
ಆಯ್ತು,
ಆ ಕೇಸ್ ನಲ್ಲಿ ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಇದರಲ್ಲಿ ಬಾಡಿ ವಾರಂಟಿ ಮಾಡಿ
ಬಾಡಿ ವಾರಂಟ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಾ?
ಮಾಡಿಲ್ಲ ಸರ್,
ಮಾಡಿಲ್ಲ.
ಅಬ್ಸ್ಕಾಂಡ್ ಆಗಿದ್ದಾರೆ. ಅಬ್ಸ್ಕಾಂಡ್ ಇವಾಗ
ಅಬ್ಸ್ಕಾಂಡೆಡ್ ಹೆಂಗಾಗುತ್ತೆ? ಬಾಡಿ ವಾರೆಂಟ್ ತಗೊಳ್ಳೋದು ಯಾವಾಗ ಕಸ್ಟಡಿಲಿ ಇದ್ದಾಗ?
16/3/2020
ಅರ್ಲಿಯರ್ ಪಿಟಿಷನ್ 439 ಹಾಕಿದ್ರ ನೀವು?
ಹೌದು ಸರ್, ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್?
ಪೇಜ್ ನಂಬರ್
ಮತ್ತೆ 438 ಬರ್ತ್ರಿ?
438 ಮೇಲೆ 8
ನೋಡಿ. having heard the respective counsel appearing parties and also present material on record, it is clear that this petition along with other
8/6/2020 ಮೇಲೆ ರಿಲೀಸ್ ಆನ್ ಬೇಲ್ ಮೇಲೆ ಒರಿಜಿನಲ್ ಕೇಸ್ ಮೇಲೆ
complainant's lorry, and after stopping the said lorry, this petitioner dragged out the complainant from the lorry and inflicted injury with the dragger on his neck and chest, and taking into note of the nature of the injury which is grievous in nature and the vital part of the complainant as per the wound certificate produced by the petitioner itself, not a fit case to exercise the discretion in favor of the petitioner. The bail petition is rejected. The merits only.
And the original case ಮೇಲೆ the release on bail for the Sanand put ಮೇಲೆ then ಮೇಲೆ release on 8/6/2022 ಮೇಲೆ
ಒರಿಜಿನಲ್ ಕೇಸ್ ಅಂದ್ರೆ ಯಾವುದು?
ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ ಸರ್.
ಇದು ಕ್ರೈಮ್ ಬೇಸ್ಡ್ ಆನ್
ಈ ಕ್ರೈಮ್ ನಂಬರ್ 56/17 ಮೇಲೆ
17 ಅಲ್ಲೇ ಈಗ 439 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. ಹೌದಾ? Now how you can seek for 438?
ಅಲ್ಲ, ಕೈಂಡ್ಲಿ ಮೇಲೆ
ಕ್ರೈಮ್ ನಂಬರ್ 17/21.
ದಿ ಬೇಲ್ ಗ್ರಾಂಟೆಡ್ ಈ ಕೇಸ್ ಆ ಕೇಸ್ ನಲ್ಲಿ ರಿಲೀಸ್ ಆಗ್ತಾನೆ
8214. ಇನ್ನೊಂದು 8250. ಆಯ್ತು, ಅದು ಕ್ರೈಮ್ ಬೇರೆ.
ಕ್ರೈಮ್ ನಂಬರ್ 56 ಮೇಲೆ
ಆಯ್ತು.
ಈ ಕೇಸ್ ಮೇಲೆ
56/21. ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಬೇಲ್ ಆಗಿದೆ.
ಬೇಲ್ ಆಗಿ ಇದ್ರಲ್ಲಿ ರಿಲೀಸ್ ಆಗ್ಬಿಟ್ರು. ಈ ಕೇಸ್ ನಲ್ಲಿ ರಿಲೀಸ್ ಆಗ್ತಾನೆ.
ಆ ಕೇಸಲ್ಲಿ ಹೆಂಗ್ ರಿಲೀಸ್ ಆಗ್ತದೆ?
ರಿಲೀಸ್ ಆಗಿದೆ ಅಂತ ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಬಾಡಿ ವಾರಂಟ್ ಆಗಿತ್ತು ಮಾಡಿರೋದು.
ಏನ್ ನಂಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಈಗ ಅವನ ಮೇಲೆ 2 ಕೇಸ್ ಇತ್ತು. earlier crime number 17/21. This court considered the bail petition 439. ಹೌದಾ? ಈಗ ಇನ್ನೊಂದು ಕೇಸ್ ಇತ್ತು ಅವನ ಮೇಲೆ. ಆಯ್ತು, ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಬೇಲ್. ಅದು ಕ್ರೈಮ್ ನಂಬರ್ ಬೇರೆ. ಹೌದಾ? 56/21 ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಅವ್ನು ರಿಲೀಸ್ ಆಗಿರ್ತಾನೆ.
ಆಯ್ತು,
ಆ ಕೇಸಲ್ಲಿ ಇದ್ದಾಗ ಅವನೊಂದು ಬಾಡಿ ವಾರೆಂಟ್ ತಗೊಂಡಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ನೀವು ಅರ್ಲಿಯರ್ 439 ಅಲ್ಲಿ ಬಂದಿದ್ರಿ.
ಈ ಕೇಸ್ನಲ್ಲಿ ಈಗ NBW ಇಶ್ಯೂ ಮಾಡಿದ್ರು ನಿಮ್ಗೆ.
ಹಾ ಅಲ್ಲ ರೀ, ಅರ್ಲಿಯರ್ 439 ಅಲ್ಲಿ ಬಂದಿದ್ರಿ, ಬಾಡಿ ವಾರೆಂಟ್ ಮೇಲೆ ಇವಾಗ ಸೆಕ್ಯೂರ್ಡ್, ಹೌದಲ್ವಾ? ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರು. ಇದೆಯಲ್ಲ ಮತ್ತೆ ಟ್ರೈನ್ ನಂಬರ್ ಏನದು? ಸೇಮ್. ನೀವೇ ಹೇಳಿದಿರಲ್ರಿ ಜೈಲಿಗೆ ಹೋಗಿದ್ದಾನೆ, ರಿಮಾಂಡ್ ಆಗಿದ್ದಾನೆ.
16/3/2020 ಮೇಲೆ ಅರೆಸ್ಟೆಡ್ ಮೇಲೆ
ಹೌದ್ರಿ,
ಅದಾಗಿದೆ ಸಮಯ 8/6 ಮೇಲೆ ರಿಲೀಸ್ ಆಗಿದೆ ಈಗ. ರಿಲೀಸ್ ಆಗಿದ ಮೇಲೆ ಈಗ ಮತ್ತೆ
ಬೇರೆ ಕೇಸಲ್ಲಿ ರಿಲೀಸ್
ಬೇರೆ ಕೇಸಲ್ಲಿ ಒರಿಜಿನಲ್ ಕೇಸಲ್ಲಿ ರಿಲೀಸ್ ಆಗಿಬಿಡ್ತು ನೀವು.
ಬೇರೆ ಕೇಸಲ್ಲಿ
ಈಗ 438 ಯಾಕೆ ಬಂದ್ರು
ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ರಿಲೀಸ್ ಆಗ್ತಾನೆ?
ಇದ್ರ ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಸರ್.
ಈಗ ನೀವ್ ಹೆಂಗ್ 438 ಆಗ್ತೀರಿ? ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ನೀವು 438 ಆಗ್ತೀರಿ? ಅರ್ಲಿಯರ್ he was taken on custody.
ಆ ಕೇಸ್ ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಅಬ್ಸ್ಕಾಂಡ್ ಆಗಿದೆ ಸುಮ್ಮನೆ. ಅಬ್ಸ್ಕಾಂಡ್ ಆದ್ಮೇಲೆ ಇವಾಗ ನಾನು 438 ಡಿಸಿಷನ್ ಕೇಂದ್ರ ಸಚಿವ
ಈಗ ಅಬ್ಸ್ಕಾಂಡ್ ಆಗೋನು.
ಹೌದು.
ಅಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಕಸ್ಟಡಿ ಇದ್ದಾಗ ಅವನ ಹೆಂಗ್ ಅಬ್ಸ್ಕಾಂಡ್
ಈ
ಆಗ್ತಾನೆ?
ಕೇಸ್ ಕಸ್ಟಡಿ ಆಗಿಲ್ಲ. ಈಗ ಒರಿಜಿನಲ್ ಕೇಸ್ 8/6/2020 ರಿಲೀಸ್ ಆಗಿಬಿಟ್ಟು ಅನ್ಸುತ್ತೆ. ಒರಿಜಿನಲ್ ಕೇಸ್
ಅದ್ ಇನ್ನೊಂದ್ ಕೇಸ್ ಅಲ್ರಿ?
ಆ ಕೇಸ್ ರಿಲೀಸ್ ಆಗಿ ಹೊರಗೆ ಬಂದ
ಅದ್ರಲ್ಲಿ ರಿಲೀಸ್ ಹೊರಗೆ ಹೆಂಗ್ ಬರ್ತಾನೆ?
ಹೊರಗೆ ಬಂದ್ಬಿಟ್ಟ ಅಂತ ಬಂದಿದ ಮೇಲೆ ಈಗ ಕಂಡು ಆರ್ಡ್ ಶೀಟ್ ಮೇಲೆ
ಏನ್ರಿ ವೆರಿಫೈ ಮಾಡ್ರಿ ನೀವು? ಅದ ಹೆಂಗ್ ಆಗ್ತದೆ? ಆ ಕೇಸಲ್ಲಿ ರಿಲೀಸ್ ಆಗ್ತಾನ ಅಷ್ಟೇ. ಈಗ 10 ಕೇಸ್ ಇರ್ತದೆ, ಯಾವ ಕೇಸಲ್ಲಿ ಬೇಲ್ ಆಗುತ್ತೋ ಆ ಕೇಸಲ್ಲಿ ಹೊರಗೆ ಬರ್ತಾನ ಅಷ್ಟೇ.
ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಇಶ್ಯೂ NBW ಅಂತ ಆಗಿದೆ ಸ್ಪೈ ಆಗಿದೆ.
Which are committed to this court.
Yes,
7th ADJ. ಅಲ್ಲ ರೀ, ಈ ಕೇಸ್ ಯಾವ್ದು SC ನಂಬರ್ ಏನು? ಈ ಕೇಸಲ್ಲಿ SC ಆಗಿಲ್ವ ಈಗ?
SC ಆಗಿದೆ 141 ಮೇಡಮ್.
ಇದೆ 141.
ಇದರಲ್ಲಿ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಈಗ.
ಮೊದ್ಲು ಕಸ್ಟಡಿಗೆ ಹೋಗಿದ್ದಾನಲ್ರಿ ಅವನು?
ಒರಿಜಿನಲ್ ಕೇಸ್ ರಿಲೀಸ್ ಆಗಿ ಹೊರಗೆ ಬಂದ್ಬಿಟ್ಟೆ
ಬೇರೆ ಕೇಸ್ ಅಲ್ರಿ. ವೆರಿಫೈ ಮಾಡ್ರಪ್ಪ, ನೀವು ಇಬ್ರು ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್. ನನ್ಗೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ ನೀವ್ ಹೇಳೋದು. ಅದಂಗ ರಿಲೀಸ್ ಆಗ್ತಾನ ಅವನು? ಒಂದ್ ಕೇಸಲ್ಲಿ ಕಸ್ಟಡಿ ತಗೊಂಡಾಗ ಬೇರೆ ಕೇಸಲ್ಲಿ ರಿಲೀಸ್ ಆದ್ರೆ ಹೌ ಹಿ ವಿಲ್ ಬಿ ರಿಲೀಸ್ಡ್ ಇನ್ ಅನದರ್ ಕೇಸ್.
ಅದೇನೇ
ಇಲ್ಲ ಜಡ್ಜ್ ಮೇಲೆ ಬರೀಬೇಕಾಗುತ್ತೆ ಹೆಂಗ್ ರಿಲೀಸ್ ಮಾಡಿದ್ರು ಅಂತ. ಮತ್ತೆ
ಹೊರಗಡೆ ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ 438 ಪಿಟಿಷನ್ ಅಂತಲ್ಲ 438
ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದವರೆಲ್ಲ ಜಡ್ಜ್ ಆದ್ರೆ ಹಿಂಗೆ ಆಗೋದು. ನೋಡಿ ಯಾವಾಗ ಬೇಕು? ಇಷ್ಟಿಸ್ ಮಾಡ್ರ 10th ಬೇಕಾ ಯಾವತ್ ಬೇಕು? 17th. ಆಯ್ತು. At the request of the petitioner counsel, is this matter on 17th.
The petitioner is the lady and she is in custody for the last 7 months. Offenses under section 302 IPC. 302 IPC.
302.
Yes, sir. It has been alleged by the complainant that she has received a telephone call from her brother-in-law. He has informed her that the brother of the petitioner and her mother has chased him and assaulted him with some unknown weapon, and he died on the spot.
Earlier this petition was disposed of on merit.
Yes. Yes, my lord.
At page number 71 alli.
Yes, ma'am. My humble submission here in this case is that
Gangamma antide innobru yaru?
Gangamma has been admitted to bail at the hands of this honorable court. Here, this case is, there are no eyewitnesses to the
Nagaratna.
Nagaratnam. Yes, ma'am.
Nagaratna.
Nagaratnam.
Nagaratnam ಅಲ್ಲ, ಇದು ನಗರತ್ನ ಅಂತಿದೆ. ಮಿಸ್ಟೇಕ್. ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕಿರ್ತಾರ ಅದೇ ಇರ್ತಾರೆ. ಈ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿರೋದು. ಈಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಏನಿತ್ತು? ಚೇಂಜ್ ಆಫ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಏನು? ಆಫ್ಟರ್ ದಿ ರೆಸಿಟ್ ಆಫ್ FSL ರಿಪೋರ್ಟ್ ಅಂತ ಇದೆ. FSL ಬಂದಿದೆ ಈಗ. ಅದರಲ್ಲಿ ಸ್ಟೇನ್ ಡಿಟೆಕ್ಟ್ ಆಗಿದೆ.
My lord, hearing this case,
ರಿಕವರಿ ಏನು? ವುಡ್
on the spot, laying on the spot.
ಒಂದೇ ನಿಮಿಷ. ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ನಲ್ಲಿ ರೀಸನಿಂಗ್ ನೋಡ್ಬಿಡ್ತೀನಿ. 6. Specific court act allegation is made against this petitioner and also accused number 1 that they inflicted injury with the very same club. The other allegation against section number 3 is that she assaulted with hands. And based on the post-mortem report, there are 2 injuries, that is split laceration present sagittally over the left side top of the head, measuring so and so 12 centimeter above the ear, and scratch abrasion obliquely present over the front right starting from the outside aspect of the sun. Downward and so 17 centimeter interchange in length. Having taken note of the nature of injuries and also allegation against this petition, accused number 1, that even though victim tried to escape from the spot by seeing accused number 1, both of them chased the victim. And while chasing, the victim fell down on the vacant place of CW2. And that time, the petitioner and also the accused number have inflicted injury with the very same club. The specific court act allegation made against this petitioner that she used the very same club used by accused number 1 and injury on the head, taking note of the injuries blood. So, and when such being the material occurrence, you will also witness the incident of quarrel at the first instance, and thereafter when he came back, he found the injured lying, and specific court act allegation is made against this person. The cause of death is the post-mortem report is corresponds with the merits decide.
No, my lord. Here it is not decided on merits.
FSL, FSL ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳ್ಬಿಡಿ. ಅಷ್ಟೇ ನಾನು earlier merit consider ಮಾಡಿದ್ದೀನಿ.
One submission.
FSL goes in your favor, then you are entitled. If it is not goes in favor of you, then
FSL report it may be blood stained. It has been used by A1, not by A2, my lord.
ಅದು ಎಲ್ಲ trial.
Hanumantraya, CW1 has clearly stated that Hanumantrayappa has assaulted. Only one person has assaulted, and another
ಒಂದೇ ಕ್ಲಬ್ ಅಲ್ಲಿ ಇಬ್ರು ಸೇರ್ಕೊಂಡು
ಇಬ್ರು ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಇವ್ರು ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಯಾರು ಇಲ್ಲ ಅದಕ್ಕೆ.
CW2 and CW3.
No eyewitnesses to that effect, my lord. It is the observation made by the investigating officer.
CW3 ನೋಡಿ.
Yes, my lord.
CW3.
Three. Manoj, he does not state that he has seen. He is the eyewitness.
Recovery at whose instance?
No recovery at the instance of this petitioner, my lord. The club, it is alleged that club was laying on the spot. That was picked up, and with that club, A1 has assaulted, not A2. Manoj is not a direct eyewitness. He has not seen anyone assaulting. He is just saying he was passing through and he seen some people gathered there on the place at the place of incident. He has not at all seen anyone assaulting. She is a lady, and my lord.
What is the motive?
There is no motive. Is alleged that one button mobile was taken by the A3, my lord. What is that mobile number? Make up the mobile. Does not the family members don't know? The complainant who is wife of the deceased don't know. What is the phone number? What is the make? Nothing. Everything is blackmail. Only hypothetical imaginary allegation has been made that.
Eyewitnesses is there in the incident? 3 only. Earlier there was a scuffle between both of them. Inflicting of injury, who have witnessed?
There are absolutely no eyewitnesses, my lord. No one has seen
eyewitness CW3 intere. CW3 ಪ್ರಕಾರ ನೋಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರು
only at the first instance there was a quarrel between the accused and
accused himself as deceased himself has gone to the house.
CW3 statement ತೋರಿಸಿ ಇಲ್ಲಿ.
Yes, ma'am.
ಹಾಕಿದಿರಾ ಇಲ್ವಾ?
Manoj, I may be permitted to read, my lord. I have submitted in earlier petition.
Page number ಹೇಳಿ.
49 ನಲ್ಲಿ ಇಲ್ಲಿ ಕೊಡ್ತಾ
49 ಅಲ್ಲ.
ಇಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
49 ಅಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲ.
ಮನೋಜ್.
ಚಾರ್ಜ್ ಶೀಟ್ 49 ಮನೋಜ್ ಇದೆ. ಈ ಮುಂಚೆ ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟಿದ್ದೆ.
ಅಡ್ವೊಕೇಟ್ಸ್ ಅದರಲ್ಲೂ ಚೌಕಾಸಿ ಮರ್ಡರ್ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ವಿಟ್ನೆಸಸ್ ಹಾಕ್ಲಿಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ನಿಮ್ಮೆಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ಗೆ?
ನಾನು ಮುಂಚೆನೆ
ಜೆರಾಕ್ಸ್ ಒಂದು 50-100 ರೂಪಾಯಿ ಖರ್ಚಾದ್ರೆ ಅದರಲ್ಲೂ ಚೌಕಾಸಿ. ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕು ಕೋರ್ಟ್ಗೆ. ನಿಮಗೆ ಯಾವ್ದು ಬೇಕು ಯಾವ್ದು ಬೇಡ ಅನ್ನೋದಲ್ಲ.
ಅರ್ಲಿಯರ್ 48-37 ನಲ್ಲಿ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೆ.
ಏನ್ ಮಾಡೋದು ಅದರಲ್ಲಿ ಆಯ್ತು ಮತ್ತೆ ಹಾಕ್ಬೇಕಲ್ವಾ? ಎಲ್ಲಿದೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 39
ಇಲ್ಲೇನೆ ಇಟ್ಟಿದ್ದೀನಿ. ಫಸ್ಟ್ ಪೇಜ್ ಅದರಲ್ಲಿ
ಫಸ್ಟ್ ಪೇಜ್
ಮನೋಜ್
CW3 ನ ಇದು.
ಹೌದು.
ನಾನು ಮೇಲೆ ತಿಳಿಸಿದ ಹೊಸವಾಗಿದ್ದ ಹಾಲಿನ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಪ್ರತಿದಿನ ಜನ ಬಂದು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಮುಖ್ಯ ಧೈರ್ಯ ಹಾಕಿ ಬರುತ್ತೇನೆ. ಇದರಂತೆ ನಾನು ಧೈರ್ಯವನ್ನು ತುಂಬಿಕೊಂಡು ಬರುವ ಸಲುವಾಗಿ ಧೈರ್ಯ ತುಂಬಾಳಿದಲ್ಲಿ ಹಾಲಿನ ಕೆಲಗಳನ್ನು ತುಂಬಿಕೊಂಡ ನಂತರ ಕೋಡಿಕೊಳ್ಳದ ಕಡೆಗೆ ನಾನು 30 ಮನೆ ನೇರದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದಾಗ ರಸ್ತೆಯ ಬಲಭಾಗದಲ್ಲಿರುವ ಹೊಲದಲ್ಲಿ ಹನುಮಂತೇಗೌಡ ಮತ್ತು ಅವರ ತಾಯಿ ಗಂಗಮ್ಮ ಮತ್ತು ತಂಗಿ ನಾಗರತ್ನರವರು ಸೇರಿ ಜಗದೀಶನ ಮೇಲೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು. ನಂತರ ನಾನು ಡೈರಿಗೆ ಹೋಗಿ ಹಾಲಿನ ಕ್ಯಾನ್ಗಳನ್ನು ತುಂಬಿಕೊಂಡು ವಾಪಸ್ ಬರುವ ಸಲುವಾಗಿ ಗಲಾಟೆಯಾದ ಜಾಗದಲ್ಲಿ ಬರುತ್ತಿದ್ದಾಗ ಜಗಳವಾಡುತ್ತಿದ್ದ ಸ್ಥಳದಿಂದ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿದ್ದ ಕೃಷ್ಣಮೂರ್ತಿರವರ ಮನೆಯ ಬಳಿ ಜನರ ಗುಂಪು ಸೇರಿಕೊಂಡು ಹತ್ತಿರವಾಗಿ ನೋಡಲಾಗಿ ಗಲಾಟೆ ನಡೆಯುವ ಜಾಗದಲ್ಲಿ ಜಗದೀಶನ ತನಗೆ ಏಟುಗಳಾಗಿ ಸತ್ತು ಹೋಗಿದ್ದನು. ನಂತರ ವಿಚಾರ ತಿಳಿಸಲಾಗಿ ಅವರ ಮನೆಯಲ್ಲಿ ಮುಂಭಾಗದಲ್ಲಿದ್ದರು ಗಂಗಮ್ಮ ಎಂಬುವರಿಗೆ ಮೊಬೈಲ್ ಕೊಟ್ಟಿದ್ದು, ಮೊಬೈಲ್ ವಾಪಸ್ ಕೊಡುವ ವಿಚಾರದಲ್ಲಿ ಗಂಗಮ್ಮ ಮತ್ತು ಆಕೆಯ ಮಗಳು ನಾಗರತ್ನ ಮತ್ತು ಮಗ ಹನುಮಂತೇಗೌಡ ಹಾಗೂ ಬುದ್ಧ ಜಗದೀಶ ಮಧ್ಯೆ ಗಲಾಟೆಯಾಗಿದ್ದರಿಂದ ಜಗದೀಶನ 3 ಜನ ಸೇರಿ ಅಟ್ಟಿಸಿಕೊಂಡು ಹೋಗಿ ಆಗ ಜಗದೀಶ್ ಮೂರ್ತಿರವರ ಮನೆಯ ಬಳಿ ಜಾರಿ ಬಿದ್ದಾಗ 3 ಜನ ಸೇರಿ ದೊಣ್ಣೆಯಿಂದ ತಲೆ ಮೇಲೆ ಹೊಡೆದು ಕೊಲೆ ಮಾಡುತ್ತಾರೆ ಅಂತ
ತಿಳಿಯಿತು ಅಂತ ಹೇಳ್ತಾರೆ sir.
ಫಸ್ಟ್ ನೋಡಿದ್ದೆ ಅಂತ
ಇಲ್ಲ
ಅದು ಮನೆ ಹತ್ರ ಜಗಳ ಆಡ್ತಾ ಇದ್ರು ಇವ್ರು 3 ಜನ ಅವನ ಜೊತೆ ಅದನ್ನ ನೋಡಿದ್ದೆ ನಾನು
ಮನೆ ಹತ್ರ ಹೌದು ಸರ್. ಆದ್ರೆ ಅವ್ರ ಮನೆಯಿಂದ ಸ್ಪಾಟ್ ಆಫ್ ಎಲ್ಲಿ ಸತ್ತು ಬಿದ್ದಿದ್ರು ಅದು ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿದೆ. ಅವನು ಸತ್ತು ಬಿದ್ದಿದ್ದ
ಸೀಸರ್ ಇದೆಯಲ್ರಿ ಸೀಸರ್
ನಾಟ್ at the hands of any accused man.
ಸ್ಪಾಟ್ ಅಲ್ಲಿ
It is on the spot. ಮತ್ತೆ ಅವ್ರು ಹೇಳೋದೇನಂದ್ರೆ earlier there was no motive, intention and preparation. No preparation was made. ಅಲ್ಲೇ ಅವನು ಬಿದ್ದಿದ್ದ ಅಂತೆ, ಅಲ್ಲಿ ಬಿದ್ದಿದ್ದ ದೊಣ್ಣೆಯನ್ನ ತಗೊಂಡು ಹನುಮಂತರಾಯಪ್ಪ ಹೊಡೆದ ಅಂತ ಹನುಮಂತರಾಯ ಅನ್ನೋ ವಿಟ್ನೆಸ್ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಒಬ್ಬರೇ ಹೊಡೆದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟು ಫೈನಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ. FSL ರಿಪೋರ್ಟು ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಲ್ಲ ಡಿಫೆಕ್ಟಿವ್ ಚಾರ್ಜ್ ಶೀಟ್ 98th day ಫೈಲ್ ಮಾಡಿ 7 months in the petitioner are in judicial custody. And petitioner has got 4 children. So one is a special child. They are laying virtually on the footpath. Nobody is there to take care of her children. She is a school teacher. And complainant as being wife of the deceased does not disclose the phone number. Does not disclose what is the make of the phone. No iota of material is placed before this honorable court regarding make of the phone number, anything over which a dispute has been taken place. This is the complaint. Very vague and doubtful complaint.
ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಏನಿದೆ ರೀ PM ರಿಪೋರ್ಟ್
And absolutely no preparation, intention and motive.
ಹಿಸ್ಟೋಪೆಥಾಲಜಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ರಿಪೋರ್ಟ್ಸ್ ಬಂದ್ಮೇಲೆ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರೆ. ಏನು
ಅದು the depth of the injury is not known. Pathological final report is not there. Virtually it is on the 90th day filed.
The weapon was seized at the spot at the time of Pata. But only the witness CW3 found at the time of earlier quarrel ಅಷ್ಟೇ. ಅವ್ರ ಮನೆ ಹತ್ರ ಜಗಳ ಆಗ್ತಾ ಇತ್ತು, ನೋಡಿದೆ ನಾನು ಹಾಲು ಹಾಕಿ ಬರೋದ್ರೊಳಗೆ ತಪ್ಪಿದ್ದಿದ್ದ ಅಂತ. ಆಮೇಲೆ ಏನಂತ ನಾನು CW2 is not an eyewitness.
ಅಲ್ಲ ಸರ್, ಓನ್ಲಿ ಮತ್ತೆ ಕ್ಲಬ್ ಮನೆಯಿಂದ ತಂದ್ರು ಅಂತ ಹೇಳಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲೇ ಬಿದ್ದಿದ್ದು ಕ್ಲಬ್ ತಗೊಂಡು ಹೊಡೆದ್ರು ಅಂತ ಅಂದ್ರೆ ದೇರ್ ವಾಸ್ ನೋ ಮೋಟಿವ್, ಇಂಟೆನ್ಷನ್ ಆರ್ ಪ್ರಿಪರೇಷನ್ ಅಟ್ ಆಲ್. Even if admitted for the sake of argument that he had assaulted with
ಮೊಬೈಲ್ ವಿಚಾರ ಗಲಾಟೆ ಆಗಿರೋದು. ಮೊಬೈಲ್ ಕೊಟ್ಟಿದ್ದ ವಾಪಸ್ ಕೇಳಕ್ ಹೋದ, ಕೊಡ್ಲಿಲ್ಲ. Except CW3 no other. ಹೇಳಿದ್ರೆ hearsay. ನೋಡಿ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that there was a quarrel between the deceased and his petitioner and other accused with regard to non-returning of mobile. And the same was witnessed by CW3. And when CW3 went to dairy and while returning, he found the dead body of the victim. prosecution mainly relies upon this statement of CW3. The counsel appearing to the petitioner who submits that there are no eyewitnesses to the incident, and only CW3 says that he witnessed only quarrel between them and not inflicting of any injury. And this petitioner is in custody from last 7 months. And also no recovery at the instance of this petitioner, and according to the prosecution, the weapon which was used was lying at the spot. ಇವ್ರಿಗೇನಾರು ಇಂಜುರೀಸ್ ಇದೆಯಾ? ಇಂಜೂರ್ಡ್ ಏನಾರು ಅಲ್ಲ, ಇವನಿಗೆ ಅಕ್ಯೂಸ್ಡ್ ಏನಾರು?
No, no.
ಇಲ್ಲ. The counsel also submit that investigation has been completed and charge sheet is filed, and is a matter of trial, and hence he may be enlarged on bail, and he is ready to obey the conditions. For contrary, the counsel appearing for the state would submit that the weapon which was used was seized at the spot, and FSL report also received. The same is stained with blood. And apart from that, CW3 also witnessed the first instance, the incident between the victim and accused persons. And hence, there is a prima facie case against the petitioner hearing. This petitioner is accused number 2 now.
Yes.
Having heard the respective counsel and also on perusal of material. The prosecution mainly relies upon the statement of CW3. And CW3 not witnessed the incident of assault made to the victim. Only it says about earlier he had witnessed the quarrel between this petitioner and other accused and also the victim. And also no recovery at the instance of this petitioner, and the weapon which was used was lying at the spot. No doubt the FSL report confirms the weapon was stained with blood. And when the weapon was seized at the spot, not at the instance of this petitioner, as well as not CW3 witnessed the incident of assault made by this petitioner. And this court also earlier rejected the bail petition only on the ground that FSL report is awaited. Now FSL report is received, but the same confirms the stains in the weapon. But the fact that when there was no recovery at the instance of this petitioner and the case is rest upon the circumstantial evidence, it is appropriate to enlarge the petitioner on bail with conditions.
Poor lady, my lord.
And no any sound circumstances against the petitioner. ಏನು ಹೇಳಿ?
Poor lady, my lord. Soft condition.
ಏನ?
Soft condition may be.
ಅದ್ರಲ್ಲಿ ಬೇರೆ ಸಾಫ್ಟ್ ಕಂಡೀಷನ್ಸ್ ಬೇರೆ ಇದೆಯಾ?
She is very poor lady. And a primary school teacher, man.
ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ ಟೀಚರ್ ಹೌದಲ್ಲ? ಸೂರಿಟಿ ಕೊಡ್ತಾರೆ. ಸೂರಿಟಿ ತಗೊಳ್ಳೋ ಉದ್ದೇಶ ಏನು ಅಂತಂದ್ರೆ ಟ್ರಯಲ್ ತಪ್ಪಿಸ್ಕೊಳ್ಬಾರ್ದು. In order to secure the accused. ಅದರಲ್ಲಿ ಪೂರ್ವ ಸಾಫ್ಟ್ ಕಂಡೀಷನ್ಸ್, ರಿಜಿಡ್ ಕಂಡೀಷನ್ಸ್ ಅಂತ ಏನಿಲ್ಲ. ಆಯ್ತು ಅಷ್ಟೇ. ಅಷ್ಟೇ, that's all. 73 ನ ಮುಗಿದೋಯ್ತು, ಇದು ಆಗೋಯ್ತಲ್ಲ. ಏನಾಯ್ತು ಇದು? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ನೆಸೆಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಇದೆಯಲ್ಲ, ಏನ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಯ್ತು ಏನೋ? ನೀವೇನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಪಿಟಿಷನರ್ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ on 24th ಅಷ್ಟೊಳಗೆಲ್ಲ ಮೈ ಹುಷಾರ್ ಮಾಡ್ಕೊಂಡು ಅರ್ಜಿ ಹಾಕಿ. ಪೇಮೆಂಟ್ ಆಲ್ರೆಡಿ ರಿಸೀವ್ಡ್ ಅಂದ್ರಲ್ಲ ನೀವು, ಹಂಗ್ ಕ್ಲೋಸ್ ಮಾಡಕ್ ಆಗಲ್ರಿ. ಅಕ್ವಿಟಲ್ ಆಗ್ಬೇಕು, ನೀವು ಕಾಂಪೌಂಡ್ ಮಾಡ್ಕೋಬೇಕು. ಕನ್ವಿಕ್ಷನ್ ಆಗಿರೋ ಕೇಸ್ ಇದು. ಅಡ್ವೊಕೇಟ್ ಏನ್ ಮಾಡ್ತಾರೆ? ಅವ್ರ ಹೆಂಗ್ ಮಾಡ್ತಾರ್ರಿ? ಅವ್ರ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? ಅವ್ನ ಹಾಕ್ಬೇಕು, ಅಪ್ಲೋಟ್ ಹಾಕೋಬೇಕು. ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡಿದೀನಿ ಅಂದ್ರೆ ಯು ಸೀಕ್ ದಿ ಕಾಂಪೌಂಡಿಂಗ್ ಆಫ್ ಅಫೆನ್ಸ್. ಕನ್ವಿಕ್ಷನ್ ಆಗಿ ಸೆಂಟೆನ್ಸ್ ಆಗಿರೋದು. ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ನೆಸೆಸರಿ ಅಪ್ಲಿಕೇಶನ್. ಆಯ್ತಾ? ಮುಗೀತಲ್ಲ? ಮುಗೀತಲ್ರಲ್ಲ? ಓ ಮತ್ತೆ MFS ಇಟ್ಕೊಂಡ್ಬಿಡಿತ್ತಲ್ಲ, MFS ಅಲ್ವಾ? ಯಾರು ಇಲ್ಲ? ಯಾರ ಇದಾರ MFS ಅಲ್ಲಿ? ಏನಾದ್ರು ಎರಡು ಸೈಡ್ನವರು ಇಲ್ಲ? ಮಾಡೋಣ, ಕೆಲಸ ಮಾಡೋಣ. 445 ಅವ್ರಿಗೆ. ಓಕೆ, ಯಾರು ಇಲ್ಲ? ಎಲ್ಲ ಹೊಟ್ಬಿಟ್ಟವ್ರ? ಯಾರು? ಪ್ರದೀಪ್ ಯಾವ್ದಾದ್ರು ಕೇಸ್ ಇದ್ರೆ ಕರೀರಿ ನೋಡೋಣ. ಇದ್ರೆ ಕರೀರಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ಬಟ್ ಡೇಟ್ ಅದ ಫೈಲ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು matter will not be registered because of criminal matters. ಈಗೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡು ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ನನಗೇನಿಲ್ಲ.
Serial number 37 I am there for the second respondent.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number 37.
37
Upon my ಇದೀನಿ, ಅವರು ಇದ್ರೆ I am ready.
ಅದರ್ ಸೈಡ್ ಇಲ್ಲ. ವೆಂಕಟರೆಡ್ಡಿ ಸಿಎಂ ಇದಾರ? ವೆಂಕಟರೆಡ್ಡಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ನಿಮ್ದು ಯಾರು ಮೇಡಮ್ ಅದರ್ ಸೈಡ್?
ಯಾವ ಡೇಟ್?
ಡೇಟ್ 24th ಕೊಟ್ಟಿದ್ದೀವಿ. 24th of November. ಇಲ್ಲಲ್ಲ ಮೇಡಮ್, ಅವ್ರು ಇಲ್ಲಲ್ಲ ಈಗ.
ಆನ್ಲೈನ್ ಇರ್ತೀನಿ ಹೇಳಿದ್ರು.
ಆನ್ಲೈನ್ ಇಲ್ಲ ಈಗ, ಅದಕ್ಕೆ ಹೇಳಿದ್ರು. Tomorrow no sitting, madam. Till 10th no sitting.
ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ
ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಂತಿಲ್ಲ ನಮ್ ಪೋರ್ಟಲ್. ಯಾವ್ದಾವ್ದು ಬರುತ್ತೋ ಅದೆಲ್ಲ ತಗೊಂಡ್ ಮಾಡಿ.
ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಟಾಪ್
ಹಂಗ್ ಮಾಡಕ್ ಇಯರ್ ವೈಸ್ ಬರುತ್ತೆ.
ಲಾಸ್ಟ್
10th ಬಹಳ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಜಾಸ್ತಿ ಪೋಸ್ಟ್ ಮಾಡಿದೀವಿ. ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದೀವಿ ಅವತ್ತಿಗೆ, ಬೇಡ ಅವತ್ತು. ಆಕ್ಚುಲಿ ಐ ಮೇಡ್ ಸಿಟ್ಟಿಂಗ್ ಟುಡೇ ಓನ್ಲಿ ಫಾರ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಗೋಸ್ಕರ. ಯಾಕಂದ್ರೆ 15 ದಿವಸ ಎಲ್ಲ ಬೇಡ.
ಅವ್ರದ್ದು ಡೆತ್ ಕೇಸ್ ಇದೆ. ಅವ್ರದ್ದು ಡೆತ್ ಕೇಸ್ ಒಂದು ಕವರ್ಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಡೆತ್ ಇಂಜುರಿ ಎಲ್ಲ ಡಿಸೈಡ್ ಮಾಡೋದು.
ದಿಸ್ ಇಸ್ ಕವರ್ಡ್ ಮಿಲಾಟ್ ಮುಕುಂದ ದೇವಂಗನ್.
ಆಯ್ತು, ಅದನ್ನು ಮಾಡೋಣ, ಡಿಸೈಡ್ ಮಾಡೋಣ. ನನಗೆಲ್ಲ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಈಗಲೇ 5 ನಿಮಿಷ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತೀನಿ. ಮುಕುಂದ ದೇವಂಗನ್ ಕೇಸ್ ಅಂದ್ರೆ ಗೆಟಿನ್ ಮೇಡಮ್ ಫೋನ್ ಮಾಡಿ ಏನಾರು ಇದ್ದಾರ ಕರೀರಿ. ಮತ್ತೆ ನಾನು ನೀರ್ ಕುಡಿಯೋದ್ರಲ್ಲಿ ಕರ್ಕೊಂಡು ಆಯ್ತು 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 ಮಾಡಿ, ಫೋನ್ ಮಾಡಿ. ನೀರ್ನೇ ನಿಧಾನ ಕುಡಿಯೋದು.
Serial number 38. It is not different.
ಏನಾಯ್ತು? 48
ಟ್ರ್ಯಾಕ್ಟರ್ ಟ್ರೈಲರ್ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಮ್ಯಾಟರ್ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದು ಆಯ್ತಲ್ಲ ಬೆಳಗ್ಗೆ ಯಾವ್ದು ಮಾಡಿದ್ದೀವಿ. ಪ್ರದೀಪ್ ಇಲ್ಲಲ್ಲ ಈಗ.
ಅದೇ ಪ್ರದೀಪ್ ನನಗೂ ಇದನ್ನು ಪ್ರದೀಪ್ ನನಗೆ
ಏನ್ ಮ್ಯಾಟರ್ ಏನು
ಅದು ಮೆಲಡ್ ಇನ್ ದಿ ಟ್ರೈಲರ್. ಮೆಲಡ್ he was working as a coolie. ಮೆಲಡ್ ದಿ ಟ್ರೈಲರ್
ಬೆಳಗ್ಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೀನಿ ಒಂದು.
ಅದೇನೆ
ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ನ ರೆಫರ್ ಮಾಡಿ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿ.
ಪ್ಲೀಸ್
ಇವೊಂದು ನೋ ಇನ್ಶೂರೆನ್ಸ್ ಟು ದಿ ಟ್ರೈಲರ್
ಪ್ಲೀಸ್
ಮಾಡಿದೀವಿ. ಅದು ಸಿಮಿಲರ್ ನಿಮ್ದು?
ಪೇ ಅಂಡ್ ರಿಕವರಿ ಸೇಮ್ ಅದು.
ಸೇಮ್ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಬರಲ್ಲ. ರಿಕವರಿ ಇದೇ ಬರ್ತದೆ, ಪೇಮೆಂಟ್ ಬರ್ತದೆ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
ಸೇಮ್ ಅದೇನೆ.
ಅದೇ ಮಾಡ್ತೀವಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡೋಣ. ಇವತ್ತು ಮಾಡಿದೀವಿ, ಅದು ಆರ್ಡರ್ ತಗೊಳ್ಳಿ.
ಆಗ್ಬೋದು. ಅದು ತಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ್ಲೂ ಅದನ್ನ ಇವತ್ತಿಗೆ ಹಾಕೊಂಡ್ರಿ, ಸೇಮ್ ಡೇಟ್ ಗೆ
ಹಾಕಿದ್ವಿ. ಬೆಳಿಗ್ಗೆ ಒಟ್ಟಿಗೆ ಮಾಡೋಣ ಅಂತ ಬೆಳಿಗ್ಗೆ ನೀವಿರ್ಲಿಲ್ಲ, ಅವರು ಹೇಳಿ.
ಇಲ್ಲ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೆ, ಅವರು ಇಲ್ಲ, ಅವರು ನಾನು ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ, ಯಾರು ಬೆಳಗ್ಗೆ ಅದ್ರಲ್ಲಿ ಇವರು ಅಪಿಯರ್ ಆದ್ರು, ಯಾರು ರವಿ ಸಂಪ್ರತಿ
ಇದ್ರು
ಮಾಡಿದ್ವಿ.
ಅದು ರೀಚ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ನನ್ಗೆ ನಾನು
ರೀಚ್ ಆಗಲ್ಲ ಅನ್ನಂಗಿಲ್ಲ. ಯಾವ್ದು ಬರ್ತದ ಅವಾಗೆಲ್ಲ ರೀಚ್ ಆಗ.
ಸಾರಿ, ಇದ್ದಿದ್ರೆ ನಾನು ಜೊತೆಗೆ
ನಿಮ್ದು ಹೇಳಿ ನಿಮ್ದು ಮಾಡ್ತಾ ಇದ್ವಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡೋಣ
ಪ್ಲೀಸ್.
ಯಾರು ಬರ್ತಾರಂತ? ಪ್ರದೀಪ್ ಇದೆಯಾ? ಯಾವ್ದ್ರಲ್ಲಿ? ಮೇಡಮ್ ಆಯ್ತು, ಇಬ್ರು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ತಗೊಳ್ಳಿ. 43
even Nataraj Bellal is coming online.
serial number 43.
ಏನಾಗುತ್ತೆ? 43 ಹೇಳಿ.
Minor death 5 years by seeking enhancement.
2,55,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
2,55,000 ಕೊಟ್ಟಿದಾರ. ಯಾರು ಅದರ್ ಸೈಡ್
ಇವ್ರು ಪ್ರದೀಪ್ ಅವ್ರು.
ಪ್ರದೀಪ್ ಏನ್ರಿ? ಯಾರ 2,55,000 ಕೊಟ್ಟವ್ರಂತಲ್ರಿ. ಏಜ್ ಎಷ್ಟು ಮೈನರ್ ಬಾಯ್?
5 ವರ್ಷ.
5 ವರ್ಷ.
ಆರ್ಕೆ ಮಲ್ಲಿಕ್ ಕೇಸ್ ರೆಫರ್ ಮಾಡಿ
ಆಯ್ತು, 5 ಲಕ್ಷ ಮಾಡೋಣ. ಕಿಶನ್ ಗೋಪಾಲ್ ಕೇಸ್ ಇದೆಯಲ್ಲ
ಹೌದು.
ಅದೇನೆ. ನೋಡಿ ಫೈಲ್ ಏನ್ ಬೇಡ ತೋಡಿ. Heard the petitioner counsel and the counsel appearing for the respondent. His appeal is filed challenging the judgment and award. ನೋಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಫೈಲ್ ಕೊಡ್ತಾರ ಆಯ್ತಾ. ಕ್ವಶನಿಂಗ್ ದಿ ಕ್ವಾಂಟಮ್ ಕೊಡಿ, ಎಲ್ಲ ಅವ್ರ ಹತ್ರ ಇದೆಯಲ್ಲ ಕೊಡಿ, ಅವ್ರದೇ ಕೊಡಿ. Questioning the quantum of compensation awarded in a case of death of a minor boy who is aged about 5 years. The tribunal awarded compensation of rupees 2,45,000 and hence the present appeal is filed. The counsel appearing for the petitioner would vehemently contend that the tribunal committed an error in not considering the judgment of the apex court in Kishan Gopal case. We take a note of the boy is aged about 5 years and awarded lesser compensation and hence it requires interference. For part of the counsel appearing for the insurance company which submit that the age of the deceased was 5 years and hence the compensation awarded is just and reasonable. Having heard the respective counsel and also on perusal of material available on record, the claimants are parents, parents who lost the minor boy of 5-year-old. And this judgment was passed on 11th day of August 2014. And the appeals court also were disposing of the death of a minor in Kishan Gopal case. Awarded compensation of rupees 5 lakhs. And having taken note of the principles laid down in the judgment of Kishan Gopal case, it is appropriate to award an amount of rupees 5 lakhs. In a case of death of a minor boy. And hence the judgment and award of the tribunal is requires to be modified. In view of the discussions made up by Pasti Palangoda, appeal is allowed in part. The judgment and award of the tribunal is modified, enhancing compensation of 5 lakh as against 2 lakh. So 2,45,000. 2,46% interest. On this proposal. ಇನ್ನೊಂದು ಯಾವ್ದು ಇದ್ದಾರಾ? ಇಬ್ರು ಇದ್ದಾರಾ? 40 in serial number 43 madam. 43 ಅದು ನೆಕ್ಸ್ಟ್ 53 ಹೇಳಿ.
53 WC ಪಾಲಿಸಿ ನಾವು ಡಿಕ್ಲೇರ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅವರು ನಮ್ಮ ಹತ್ರ ಪಾಲಿಸಿ ಒಳಗಡೆ ಸ್ಕಿಲ್ಡ್ ಲೇಬರ್ 2,600 ಅಂತ. ಆತರ 2,600 ನಾವು ಲಯಬಿಲಿಟಿ ಆಗ್ತದೆ ಸರ್. ರಿಮೈನಿಂಗ್ ಓನರ್ ಕೊಡ್ತಾರೆ.
ಅವ್ರು ಡಿಕ್ಲೇರ್ ಮಾಡ್ಕೊಂಡ್ರೆ 2,600 ಸ್ಯಾಲರಿ ಅಂತನಾ? ಪಾಲಿಸಿ ತಗೊಳ್ಳುವಾಗ ಆ ಮೇಲೆ ತಗೊಂಡ್ರು.
ಲೇಬರ್ಗೆ 2,600 ಅಂತ ಪ್ರೀಮಿಯಂ ಕಟ್ಟಿ ನಮ್ಮ ಹತ್ರ
ಓನರ್ಗೆ ನೀವು ಓನರ್ಗೆ ಬಟ್ ನೀವು ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್. ಪಾಲಿಸಿನಲ್ಲಿ ಇಫ್ ದಿ ಸ್ಯಾಲರಿ ಈಸ್ ಟೇಕನ್ ಆಸ್ 2,06,000 ಆ ರೇಟಿಗೆ ಮಾತ್ರ ಕಾಂಟ್ರಾಕ್ಚುಯಲ್ ಇಂಡೆಮ್ನಿಟಿ. ಟೋಟಲ್ ಪ್ರೀಮಿಯಂ ಫರ್ ಎಂಪ್ಲಾಯಿಗೆ ಇಷ್ಟು ಅಂತ ಸ್ಯಾಲರಿ ವೇಜಸ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ಪಾಲಿಸಿ ತಗೊಂಡಿರ್ತಾರೆ. ಹಾಗಿದ್ರೆ ಅದೇನೆ ನೀವು ಕೊಡೋದು. ಈ ಓನರ್ಗೆ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಓನರ್ ಕೊಡ್ಬೇಕು. ಇದೇನ್ ನೋಡ್ರಿ, ದಿಸ್ ಇಸ್ ಓನ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಫ್ ಇಂಡೆಮ್ನಿಟಿ, ಹೌದಲ್ವಾ? ಕಾಂಟ್ರಾಕ್ಟ್ ಆಫ್ ಇಂಡೆಮ್ನಿಟಿ ನಲ್ಲಿ ವೇಜಸ್ ಎಷ್ಟು ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರೋ ಅದ್ರ ಮೇಲೆ ಮಾತ್ರ ಲಯಬಿಲಿಟಿ ಬರುತ್ತೆ.
ಟೋಟಲ್ ಅಮೌಂಟ್
ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಅವ್ರು ಕೊಡ್ಬೇಕು. 24,000 ಅವ್ರು ಕೊಡ್ತಾರೆ. ಬಾಕಿದೇನಾದ್ರು ನಿಮ್ದು ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತಂದ್ರೆ ಓನರ್ ಕೊಡ್ಬೇಕು. ಕ್ಲೈಮೇಟ್ ಗ್ಯಾಪ್ ಕ್ಲೈಮೇಟಿಗೆ ನೀವಾ? ಆಕ್ಸಿಡೆಂಟ್ ಯಾವ ಇದು ಯಾವಾಗ? 2013 ಆದ್ರೆ ಮಿನಿಮಮ್ ವೇಜಸ್ 8,000 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡವ್ರಿ? 7,500 ತಗೊಂಡಿದ್ದಾರೆ. ಆಯ್ತು, 7,008 ತಗೋಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಡಿಪೆಂಡ್ಸ್ ಅಪ್ ಟು 8,000 ಅಂತ ಇರುತ್ತೆ. ಈಗ ಕ್ಲೈಮೆಂಟ್ಸ್ ಏನ್ ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ?
ನಾವು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ. ಈಗ ಅಪೀಲ್ ಬೈ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯ? ಬಟ್ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ ಹಾಕಿದಾರಾ?
ಹೌದು.
ಹಂಗ ಹಾಕಕ್ ಬರಲ್ಲ ಏನ್ರಿ?
3 helpersಗೆ 24,000 ತಗೊಂಡಿದ್ದಾರೆ.
ಇದೊಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸರ್.
3 helpers.
ನನ್ನ ಫೈಲ್ ಕಳ್ಸುತ್ತೆ.
ಆಯ್ತು, ಅದಾಗ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ ಬಿಡಿ ಡೇಟ್ ಹಂಗ. ಡೇಟ್ ಆಗ್ಲಿ 24th ಕೊಟ್ಟಿದ್ದು. ನೋಡ್ಕೊಳ್ಳಿ, ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಕೊಳ್ಳಿ. ಕರೆಕ್ಟ್ ಮಾಹಿತಿ ಇಲ್ದಲೆ ತಪ್ಪು ಆರ್ಡರ್ ಬರೆಯೋದು ಬೇಡ. ಆಯ್ತು, 24th ಏನ್ ಆಗೋದಿಲ್ಲ, ಒಂದು 10 ದಿವಸದಲ್ಲಿ.
55
ಬಂದ್ರ ಮೇಡಮ್?
55 ಬಂದು
ಎಲ್ಲಿದ್ದಾರೆ? VC ಇದಾರಾ?
ಎಸ್ VC ಅಲ್ಲಿ ಬರ್ತಾರ.
VC ಕಾಣ್ತಾರೆ, ನೀವು ಒಬ್ರೇ ಕಾಣ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ ಬರ್ತಾರಂತ ಹೇಳಿ ನಾವೆಂತ ಒಂದು
ಆಯ್ತು, ಇನ್ನೊಂದ್ ದಿವಸ ಮಾಡಂಗ್ ಬಿಡಿ ಮೇಡಮ್. ಒಂದಿದೆ ಮುಕುಂದ ಯೋಗನ್ ಕೇಸ.
ಅಲ್ಲ ಪರ್ಮಿಟ್ ಇದೆ.
ಪರ್ಮಿಟ್
ಅದಕ್ಕೆ
ನೀವು ಇದ್ದೀರಾ? ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್?
55
ಓನರ್ಗೆ
ಅವ್ರದ್ದು ಒಂದ್ ಯಾವ್ದು ಇದೆ, ನಟರಾಜ್ ಬಲ್ಲಾಳ್ ಅವ್ರದ್ದು ಒಂದಿದೆ.
ಲೀಸ್ ಫಾರ್ ಕ್ಲೈಮೆಂಟ್ಸ್
ಅವ್ರ ಕ್ಲೈಮೆಂಟ್ ನೀವ್ ಯಾರಿಗೆ?
ನಾನು ಓನರ್ಗೆ. ನಂದು ಮುಕುಂದ ದೇವ.
ಮುಕುಂದ್ ದೇವಗನ್ ಅಷ್ಟೇ ಆದ್ರೆ ನಾನು ಒಪ್ಕೊಂತೇನೆ. ಪರ್ಮಿಟ್ ಇದೆ ಅದ್ರೊಳಗೆ.
ಪರ್ಮಿಟ್ ಏನ್ ವೆಹಿಕಲ್ ಏನ್ ನೋಡಿ.
ವೆಹಿಕಲ್ ಟೆಂಪೋ ಮಿಲಾಡ್, ಅದು ಲೈಸೆನ್ಸ್ ಅಂತ ಬರೆಯೋದಕ್ಕೆ ಚೀಟಿ ತಪ್ಪಾಗಿ ಪರ್ಮಿಟ್ ಅಂತ ಬರೆದಿದೆ ಒಂದು ಕಡೆ ಅಷ್ಟೇ. ಪರ್ಮಿಟ್ ಇಸ್ ದೇರ್, ಲೈಸೆನ್ಸ್ ಇಸ್ ದೇರ್.
ಲೈಸೆನ್ಸ್ ಇದೆ, ಲೈಸೆನ್ಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ನನಗೆ. ಪರ್ಮಿಟ್ ಇಲ್ಲ ಹೇಳಿ ನಮ್ದೊಂದು ಎವಿಡೆನ್ಸ್ ಕೊಡ್ತೀರಿ.
ಪರ್ಮಿಟ್ ಇದೆ, ಅದನ್ನೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಪರ್ಮಿಟ್ ಅಲ್ಲ ಮೇಡಮ್, ಅದು ಲೈಸೆನ್ಸ್ ಇದೆ. ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್. ಹೌದಾ, ಅದು ಹೋಗ್ತೇವೆ ನಾವು, ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತನಾ?
ಹೌದು, ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತಾನೂ ಇದೆ.
ವೆಹಿಕಲ್ ಏನು?
ಟೆಂಪೋ ಮಿಲಾಡ್,
ಗೂಡ್ಸ್ ವೆಹಿಕಲ್.
ಗೂಡ್ಸ್ ವೆಹಿಕಲ್
ಹೌದು. LMB ಇದೆ, ಗೂಡ್ಸ್ ವೆಹಿಕಲ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಮಿಲಾಡ್.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಿಮ್ ಕಾಪಿ ಕೊಡಿ. ಅದು ನಿಮ್ ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ? ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನಮ್ ಇಲ್ಲಿಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಬಂದು ತರ್ಸಿದ್ರಾ? ಕೊಡಿ ತರ್ಸಿದ್ರೆ.
ಪೇಜ್ ನಂಬರ್ 19 ಅಲ್ಲಿ ಎಲಾಬರೇಟ್ ಮಾಡಿ.
ಪೇಜ್ ನಂಬರ್
19 ಇಶ್ಯೂ ನಂಬರ್ 3 ಅಲ್ಲಿ ಪಾರಾ 12 ಇಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಮಿಲಾಡ್.
ಪ್ಯಾರಾಗ್ರಾಫ್
ಪಾರಾ 12 ಅಪ್ ಟು ಜಡ್ಜ್ಮೆಂಟ್. ಪೇಜ್ ನಂಬರ್ 18 ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್.
Specific case of the respondent number 2, the driver of the tempo involved in the accident had no effective reliance at the time of arrest act. Hence, the respondent number 1 allowing the driver to drive the vehicle in terms of policies also and respondent in this regard RTO who got examined. RW who had deposed that tempo bearing number so and so was got registered in the name of the respondent number 1 and as per B registered extra driving license as per exhibit R1 to 3, it was ineffective from so and so. On perusal of these documents, it is clear the driver of the tempo has valid license to drive the vehicle. But at the same time, the respondent number 1 vehicle is LTV. LTV na LMV na? And it is from 25 to 2024. And so from this as on date of the accident, that is on 22/1/2013. And then involved in the accident does not have valid permit. Permit illa anta. Even though the risk covers from 2022, it is from R1 to R5, it is clear that driver of the tempo bearing number 1 had no valid license to drive the three-wheeler transport. We had license to drive three-wheeler non-transport. ಆಯ್ತು. ಹೇಳ್ರಿ
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್
ಕವರ್ ಆಗುತ್ತೆ.
ಒಂದು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಾಗ ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತ ಒಂದು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ವಿ, ಬಟ್ ಪರ್ಮಿಟ್ ಬೇಕಾಗಲ್ಲ, ಎಕ್ಸೆಂಪ್ಷನ್ ಇದೆ. ಇಲ್ಲಾಡಲ್ ರೇಟ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಇಸ್ 400. ಸೆಕ್ಷನ್ 66 ಸಬ್ ಕ್ಲಾಸ್ 5 ಪ್ರಕಾರ
400 ಇಲ್ಲಾಡಲ್ ಪರ್ಮಿಟ್ ಬೇಕಾ?
ನೋಡಿದೆ, ಅದಕ್ಕೆ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದೆ, ಅದಕ್ಕೆ ಅದು ಒಂದು ಸೇರಿ ನಾನೇ ಹೇಳ್ತೀನಿ.
ಆಯ್ತು, ನೋಡ್ತೀವಿ.
ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್ 22.
ಇರ್ಲಿ, ಈಗ ಬಲ್ಲಾಳ್ ಅವ್ರ ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದಾರಾ?
ಹೌದು.
ಡೆತ್ ಕೇಸ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದಾರ?
Lord, the trial court award was 3,52,000, my lord, for loss of dependency. Paragraph number page 27, ink page 27, my lord, paragraph number 19, subclause B. Paragraph subpara A.
13 ಮಿಲಾಡ್.
13 ಆದ್ರೆ 8,000 ಹೋಗುತ್ತೆ. 4,000
ಹೌದು, 8,000 ಆಗ್ಬೇಕು. 8,000 ಆಗ್ಬೇಕು.
ಏಜ್ ಏನು?
40 as per post mortem report.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
41 years ಅಂತ.
5 ಇದ್ದಾರೆ, 1/4 ಆಗ್ಬೇಕು. ಹೌದಾ?
Yes.
ಹೌದು.
ನೋಡಿ ಅದೇನಾ ಅದೊಂದೇ ಕ್ವಾಂಟಮ್ ಅಷ್ಟೇ ಅದೊಂದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ನೋಡಿ.
Future income. Future income.
ಫ್ಯೂಚರ್ ಇನ್ಕಮ್ 40 ಇದೆಯಾ 40 ಕ್ರಾಸ್ ಆಗಿದೆಯಾ?
40 ಅಂತ ಇದೆ ಸ್ವಾಮಿ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 25 ಅಲ್ಲಿ ಇಟ್ಸ್ ರೆಫರ್ ಟು ಅಕಾರ್ಡಿಂಗ್ ಟು ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಡಿಸೀಸ್ಡ್ ವಾಸ್ ಏಜ್ಡ್ ಅಬೌಟ್ 40 years. Paragraph number 16 my lord at page number 25 ink page 25.
42 years ಇದೆ ನೋಡಿ prior to the accident he was aged.
ಹೌದು ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಬಟ್ PM ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ 40 ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಇರ್ಲಿ ಬಟ್ ನಿಮ್ಮ ಪ್ಲೀಡಿಂಗ್ ಏನೇ 42 ಅಂತ ಇದೆಯಲ್ಲ.
Yes.
ಇದೆ ಬಟ್ ಅವ್ರ ಅಡ್ಮಿಟ್ ಅಲ್ಲೇ 42 years ಅಂತಿದೆ.
ಹೌದು.
Was aged about 42 years doing ಗುಜರಿ ವರ್ಕ್ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರಲ್ಲ.
ಹೌದು ಇಶ್ಯೂ ನಂಬರ್ 4 ಅಲ್ಲಿ ಹಾಗೆ ಹೇಳಿದ್ದಾರೆ ತೋರಿಸಿದ್ದಾರೆ.
25% to be added ಅಷ್ಟೇ. 25%. Madam, these two appeals are filed by the insured and also the claimant, questioning the quantum of compensation awarded. So questioning the judgment and award passed in MEC number 313 of 2013 dated 23rd day of March 2013. Questioning the quantum as well as liability. The factual matters of the case of the claimants before the tribunal that Mohammed Asraf alias Asraf was proceeding by the side of the road in front of Baby's hostel from a near Garodi, from a Kankaradi village, Mangalore on public road. By that time, a temper of came in rash and negligent manner in wrong side and dashed against him. And dashed and capsized on the deceased. Hence, he has sustained grievous injuries and succumbed to the injuries. It is the claim of the claimant that he was earning rupees 15,000 per month by doing gujari work and contributing 10,000 to the family. And he was aged about 42 years. And the family lost the earning member of the family, and hence hence they are entitled for compensation. The tribunal, after considering both verbal and documentary evidence, taken the income of rupees 4,000 and calculated loss of dependency and awarded the total compensation of rupees 6,77,000. And liability is fastened on the insured, and hence the present appeal is filed by the insured as well as claimant. Sir,
owner of the vehicle.
Insured ಅಂದ್ರೆ owner ಇರ್ತದೆ. Insured, right? The main contention of the insured before this court that the vehicle involved in the accident is a light motor vehicle, and in view of the judgment of the Mukund Devagan case, the transport endorsement is not required. And also the unladen weight of the vehicle is only less than 400. 400. And then question of permit also doesn't arise. Per contra, the counsel appearing for the claimant would submit that the tribunal committed an error in taking the income of rupees 4,000 instead of 8,000 as notional income. Right? And compensation awarded is very meager and hence it requires interference. Per contra, the counsel appearing for the insurance company would submit that the deceased was aged about 42 years as pleaded. And though PM report mentioned the age of years, when there is an admission, the claimant mentions that he was aged about 42 years working and usually worker. The court has to take note of this fact into consideration. The counsel also submit that tribunal rightly considered appeal on record and fastened the liability on the insured. Hence, it doesn't require interference. Having heard the respective counsel and also on perusal of material, the vehicle involved in the accident is a light motor vehicle, is not in dispute, and driver also having driving license to drive it. LME vehicle is also not in dispute. And when considering the case in view of the judgment of Mukund Devagan case, the tribunal committed an error in fastening the liability on the insured instead of insurer. The vehicle unladen weight is also 400. Under the circumstances, the contention of the permit doesn't not permit is not sustainable in the law. Hence, liability has to be fastened on the insurer, on the insured. Next part. Now coming to the conclusion. Now coming to the loss of dependency and quantum of compensation is concerned. He is aged about 42 years and the relevant multiplier applicable 42
14.
This court has to revisit the quantum of compensation by considering the income of rupees 8,000 as notional income. And apart from that, 25% has to be added. If it is added, it comes to rupees 10,000, and this court has to deduct 1/4. Taking note of the number of claimants, and hence, after deducting 1/4, it comes to rupees 7,500. Into 12 into the relevant multiplier 14, it comes to rupees 1,60,000. Apart from that, the claimants are wherever, madam. No, claimants are also entitled for an amount of rupees 33,000 on the head of funeral expenses and funeral and loss of estate. ಯಾರು ಈ ಕ್ಲೈಮೇಟ್ಸ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರ್ರಿ? ಎಷ್ಟು ಜನ ಇದಾರೆ? 5 ಜನ.
Wife and
Claimants are wife and children, and there are, and in all 5 are there, and hence all are entitled for an amount of rupees 40,000 each at the head of love and affection, and also the loss of, and 2 lakh is awarded and it says like claimants are entitled for an amount of rupees 14,93,000. In your discussions, I pass the order. Both the appeals are allowed. The judgment and award of the tribunal is modified. Passing the liability on the insurer instead of the insurer, setting aside the order of the tribunal, passing the insurer. And quantum of compensation is also enhanced to rupees 14,93,000.
90%.
Amount refund ಮಾಡುವ ನಿಮಗೆ
25,000 mandatory amount.
Refund the amount in favor of the appellant with on proper identification. But
Not a time limit for deposit money.
ಫಾರ್ಮಲ್ ಅದು 6 ವಾರ ಕೊಟ್ಟಿರ್ತೀವಿ, 6 ವಾರದಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ.
Oblige.
ಅಷ್ಟೇ ಅಲ್ಲ?
Grateful.
ಮೇಡಮ್ ಇನ್ಯಾರು ಇದಾರಾ? ಬೋತ್ ಸೈಡ್ಸ್ ಇಲ್ಲ, ಬೋತ್ ಸೈಡ್ಸ್ ಇಲ್ಲ. 18 ಆಯ್ತಾ ಮೇಡಮ್?
ಅದಕ್ಕೆ